Of each of the cases in today's public hearing. Here at the outset of the meeting, we would respectfully ask, would you please silence your phones, your tablets, and any other electronic devices so that the board's proceedings won't be interrupted. Speakers before the board have only a limited amount of time, and we want neither their presentations nor the board's deliberation to be interrupted. Thanks in advance for your help with that. For each of today's public hearings, the board reviews the correspondence that's been submitted in support of and opposition to each of the cases. The board also reviews correspondence and recommendations from other government agencies and elected officials in preparation for the hearings. In today's hearings, staff will present the site plans, maps, photographs, and other documents that comprise the case record. At the conclusion of the staff presentation, the appellant will have the opportunity to make the desired presentation to the board. After the appellant's presentation, the board would hear from those wishing to speak in support of the appeal. If the appeal has opposition, the opponents would then have the opportunity to come forward and address the board as well. After the opposition presents its testimony, the appellant will have a period of time for rebuttal. Under BZA rules adopted January 4, 2018, the appellant has 5 minutes for a presentation if there is no opposition present. For contested cases, BZA rules allow 10 minutes to each side for a presentation. Should the appellant wish to provide rebuttal testimony, it's imperative that the appellant reserve some portion out of that originally allocated 10 minutes in order to do so. At the conclusion of each hearing, the board will deliberate and then vote on the case. The board is vested with the power to act on each of these cases under the provisions of the Metro Zoning Code, specifically Section 17.40.180. Each of the sections that I referred to today come from the Metro Zoning Code, which was established and applicable to the entire jurisdiction of the metropolitan government, passed into law on January the 1st, 1998. I'll introduce the entire zoning code and make it part of today's record for each of the cases. The Metro Code also requires a record of these proceedings. Because BZA meetings are recorded and televised and later uploaded to YouTube for future reference, it is imperative that anyone wishing to address the board come forward to the front table, use the microphone to introduce yourself by name and address, and then just make the desired presentation. We'll welcome all of you who wish to participate in the hearings, but it is imperative that you come forward to follow those procedures in order to do so. The Metro Code requires 4 members of our 7-member board in order to establish quorum. The code also requires at least 4 affirmative votes in order to grant an appeal. In the event that 5 or more members are present, but a case fails to get 4 affirmative votes, the case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within that 30-day window shall be deemed denied by operation of law. Pursuant to board rules, an aggrieved party may appeal decisions to the Chancery Court within 60 days of the hearing date. Additionally, an aggrieved party may file a motion for rehearing within that same 60-day window, pursuant to the BZA rules and regulations for such motions. After that 60-day window elapses, the board's decision becomes final and no further action can be taken. If your appeal is in fact granted, you are required to obtain the permit for which you applied. A permit must be obtained within 2 years for a board approval to remain valid. It should be noted that if any false or misleading testimony is presented to the board, any board approval could be revoked at a later date by means of a show cause hearing. Mr. Vice Chairman, I submit that all the cases have been filed in the proper order, all appellants have been properly notified by certified mail, and all legal notice requirements have been fulfilled. Mr. Vice Chairman, we do have a couple of preliminary announcements for today's cases. 2 items originally docketed have been withdrawn. First, case number 2017-259. That's involving the property at 1318, 1322, and 1326 6th Avenue North in the Germantown neighborhood. Again, case 259 has been withdrawn by the appellant. Second, case 2017-442. That involves the property at 318 Rosebank Avenue in East Nashville, Council District Number 6. That case has been withdrawn as well. Finally, one case has been deferred to a later date, and that's case 2017-422. That involves a property at 6212B Morrow Road in the Nations neighborhood, Council District Number 20. That matter has been deferred 1 meeting to our February 15th docket. For members of the public, we will note that our board has and utilizes a consent agenda. One board member reviews the record for each case prior to today's hearings and identifies those cases where appellants met the criteria for their requested action. If the reviewing board member determines that testimony in the case would not alter the material facts, then that case is recommended for the consent agenda. So we'll enter into the record those cases that have been so recommended today, and if anyone is here in opposition to one of the 3 cases identified for consent agenda, please raise your hand and indicate as much. The first. The first such case is item 2017-412. Bradley Bork is the appellant for the property located at 204 White Bridge Pike, a request for a rear setback variance. Is there anyone here in opposition to case number 412? Seeing none, that case will proceed on the consent agenda. The second case, in fact, let's skip the second and go to the third to be certain. The next case identified for consent agenda is number 2017-444, involving the property at 209 Ash Grove Drive, a request for height and rear setback requirements for a detached garage structure in the AR2A zoning district. Is there anyone here in opposition to case number 444? Seeing none, that too will be on consent agenda. And Mr. Vice Chairman, I believe that we can proceed with the consent agenda involving those 2 cases, number 412 and number 444. We would solicit a motion from the board at this time.
Okay, I'll enter a motion for those 2 cases. Is there a second for those 2 cases? Have a motion and a second. All in favor, say aye. Aye. Any opposed? Consent agenda passes unanimously.
For the parties interested in those 2 cases, number 412 and 444, you have your approval. You feel free to stay, feel free to leave. Our staff should be able to assist you with the permitting process as early as tomorrow, hopefully. Mr. Vice Chairman, as you know, we try to identify the elected officials who are with us at our meetings here at the outset of the meeting and give them the opportunity to address the board on the cases of interest for them. Toward that end, I know I saw Councilmember Sharon Hurt in the audience. Councilmember Hurt, do you wish to address the board here at the outset of the meeting? Very well.
Thank you, Mr. Michael. Good afternoon. I am Sharon Hurt, Councilwoman at Large, and my address is 6316 Willow Oak Drive. I am here in regards to case 2017-240. I am not the council person for that district, but I have spoken to Councilman John Cooper, who has been assigned, and I also spoke to Councilman, well, I guess Judge Nick Leonardo in regards to this particular case. And it's my understanding that the appellant is applying for a permit to run a type 1 short-term rental property. Based on Mr. Cooper, he indicated that he was not sure. He knew that there were some opposition to it, but he was not sure who was right or who was wrong in the case, and that he would, because of the appellant trying to become compliant and do what's right, he would ask that she be given that opportunity. And likewise, speaking with Councilman Leonardo, he too was well aware of the opposition in the case, but he didn't see anything wrong with the appellant having the proper permit to run a type 1 short-term rental. And I can say, as councilwoman who was assigned for that district during my time there, I did not receive any complaints about that. And we would say that if the permit is allowed, that we hope that there is enforcement, and I'm sure that the appellant is going to comply with the rules and regulations as they move forward. I have spoken to the owner and to her, and she has assured me that she will follow all the proper procedures and applications and all that's needed in order for her to be in compliance. So based on the information and the research that I was provided and was able to accomplish, the recommendation is that she be allowed to be given a permit to run a short-term rental property in type 1.
Thank you, Councilor Hurt. Does anyone have any questions about this case for Councilor Hurt?
Thank you.
We appreciate you being here.
Thank you very much.
John Michael.
Councilmember Fabian Bedney joins us from District Number 31. Councilman, do you wish to address the board?
Our former BZA member, we miss you here. You've gone on to much bigger and better things representing people in the Metro Council, but we appreciate your opinion on now this side.
Well, it's good to see you guys again. I appreciate the work you do. I know it's hard, so thank you very much for your service to the city. Well, thanks for letting me speak first. I gotta get back to work. I'm here to speak in opposition of the variance request for a sidewalk on Barnes Road. I have communicated to the community, and based on the feedback I got from them, and also my knowledge during my time serving the BZA, I don't think that there is a hardship to justify the requirement of a variance for removal of that sidewalk. Sidewalks are really hard to build in my district. I've been working on getting a sidewalk on Blue Hole Road from a neighborhood to a school, and we are now on the second year of trying to put that sidewalk there. So we appreciate any sidewalk being built, and the residents in the community feel the same way. There is a long history with this issue. Councilmember Lonell Matthews sponsor, and we passed legislation requiring that this type of industrial uses be built on industrial zone issues. But that was preempted by federal law, so I'm not even going to go there trying to talk about if this entitlement is there or not. I'm just going to talk about the sidewalk, and basically my request to you is that due to the fact that there is really not a hardship on that side, that you guys don't grant the variance and that the sidewalk be built per codes.
Commissioners, this is case 445. Does anyone have any questions for Councilman Bedney? Okay, no. Thank you for being here.
Thank you. Thank you very much. Have a good day.
And Mr. Chairman, we're also joined by Councilmember Jeff Syracuse from Council District 15. Councilman, do you wish to speak or wait? Choose to wait. Very well. With that, Mr. Chairman, we may have one other item to add to the, or two other items potentially to add to the consent agenda. We'll need to take that up at the first break if possible. With that, we're prepared to present the first case if the board is ready.
Okay, let's go.
Mr. Chairman, the first case to come to the board for hearing today is case 2017-240. This is an appeal, technically an item A appeal of the denial of the short-term rental property permit. As you will probably recall, this case was adjudicated in late 2017, then the subject of a motion for rehearing, which was ultimately granted by the Board of Zoning Appeals, thus bringing the matter back for today's fresh public hearing on the subject. The property shown in the slides preceding is the one at issue. You have seen other cases on Queens Lane Court very recently, but this is the one that was heard previously in 2017. You've heard from Councilmember Sharon Hurt on the matter already. However, the appellant, Ms. Mays, is represented by counsel, so we will invite them forward at this time in order to make the desired presentation to the board for their case.
Good afternoon.
Good afternoon. Please state your name, your address, and let's get started.
My name is Teresa Morgan. I am an attorney representing Ms. Mays. My address is 731 Porter Road in East Nashville. I'll let you go.
My name is Catherine Mays. I reside at 208 Queens Lane Court.
Mike Mays, 208 Queens Lane Court.
Okay, let's get started. Counselor?
Thank you. So we're here today to just ask for Ms. Mays to be granted the opportunity to reapply for a short-term rental permit for a type 1. She does stay in the house, and she has a profile ready to go on Airbnb for just one bedroom for a maximum of 2 guests. And so, so we're here today to ask, I believe a stop order was issued in July of 2017, and the Mays have not had any guests in their short-term rental since then. So we are hoping that we can reapply for a short-term rental permit soon.
Okay.
Ms. Mays was under the impression that she actually did have a permit issued at some point in time. She has the support of councilmen. There have been no complaints. We have been working with the, I forget which department it is, it's been a minute. We've been working with the collections office to get paid up on taxes from the time when she did operate. And so we would like to ask that the original 1-year penalty period be shortened to the 7 months that she already has not been operated, and be allowed to apply tomorrow, please.
Questions for the applicant? Okay. Do you have anything to add right now?
Not right now, no.
Okay. There's opposition, right, John Michael?
There was originally. Is there opposition for case number 240 today? Please show by showing your hands. See none, Mr. Chairman.
Oh, back there. Do you wish to let the opposition come forward now and come back for rebuttal?
Yes,
Okay.
yes, sir.
So opposition, please come forward, and those who want to speak out, state your name, your address, and why you're opposed to this. All opposition to this case 240, please come forward now. Okay, who wants to get us started? Please state your name and your address and why you're in opposition.
Okay. Verinda Orr, 201 Queens Lanes Court.
Okay, and why are you in opposition to this case?
I'm in opposition of this case because Mrs. Mays never quit after she got after it was stated that she was not supposed to run this for a year. When we got back home after September the 21st, she had 4 out-of-state cars there then. Before she left, she said that she had a large family, but she is an only child, so I don't think that's a large family. She has had several parties, even Christmas night. She had so many cars until they were double parked. She had other parties there. She has had several parties. So she never came into compliance with what you all said down here the other time. It was like, well, if they gave me a year probation on this, I'm going to do what I want to do. So this is what I'm saying. She is just breaking all rules, and she's doing what she want to do.
Okay, next.
My name is Luther Orr at 203 Queens Lane, 201 Queens Lane Court.
Okay.
And same thing, that night, what was it, Christmas Eve?
Christmas night.
Christmas night, there were so many cars there until one of our neighbors was trying to get out.
Well, let me ask you this. How do we know that this isn't just a Christmas party?
Well, because of the cars that was there and the license plates. Okay. And was trying to get out, so we called the Metro policeman, and he came there to check it out. And he said that to him, it was all right because emergency vehicles could go, between the two. They was double parked. So may I ask a question to the council here?
What do you mean a question? We're here to ask you questions.
Well, if a person's operating like that, I thought I heard in this first meeting that we had, are you allowed to use the street for your business? That's all I want to know.
Public street is, as far as I know, eligible for any sort of normal vehicle that isn't some sort of large recreational vehicle, 18-wheeler, commercial vehicle, that you could park normal vehicles on streets unless there's a special permitting process, which some of our neighborhoods have, that you are not allowed to park on the streets unless you live there during certain parts of the day.
Okay. All right.
Okay. Next person.
My name is Rosa Coleman. I live at 4223 Eaton's Creek Road. My opposition to this is the same kind of activity that had been going on before we were here last time has gone on since we were here the last time.
When was this and what type of activity are you talking about?
Well, we were here for a hearing in September.
Okay. But you said the same type of activity. What do you mean by that?
That was going on at this particular house.
But what does that mean? Describe what you're trying to say.
A lot of cars parked, noise.
People coming and going.
Yes, that kind of thing. And I believe the decision was that she had to wait a year to reapply, and it hasn't been a year.
Okay. Anything else to add?
So I think she should wait a year, and probably some time should be added since, she never really stopped before.
Okay. Next.
My name is Walter Holloway. I live at 4214 Eden Creek Road. And the problem that I noticed that I was notified by Mr. Orr, some of the activity that some of the rentals was doing was drug use on the outside of the property, urinating out in public. And so, and also my understanding they was operating at one time without a permit. And so they wasn't, I guess they wasn't sure ignorance of the law, and there's no excuse for not doing your own observation of what you need to do to operate a business. And so we have to live there, we can't go nowhere else, and we just don't want that in our neighborhood. And so when you come out, you're looking out your window, somebody out there urinating in public, indecent exposure, that's something we don't want to tolerate.
Any questions for the opposition?
Because I don't know the area, can you each tell me if your home is on this screen we have in front of us?
Do you all live, can you see your house on this screen?
Yes, it should be the back.
Or do you live close by?
In the
Does
back,
every one of
just the back of that property.
the back? How about you all? Can you see your house up here?
Real close.
Yes? Can you see your house up here on the screen? No? Do you see your?
I think my house is up there because I looked at this.
But it's nearby. It's
Yes,
okay.
nearby.
Okay. Anything else to add? Okay. Thank you. We're going to hear from the applicant again. Applicant, please come forward.
So I'm going to let Ms. Mays address some of the concerns that they expressed. I would just state, we've already stipulated she operated for some period of time without a permit. So
But since
that's exactly
what about since September, Counselor?
Or July, you testified just a minute ago that there hadn't been rental since July. Does that?
I'll let
You were saying
her,
September, but-
I had that in my notes, but I'll let Ms. Mays answer.
No, we have not operated since we left this courtroom. Yes, I am an only child, but my husband has 4 siblings. My late husband had 5, it was 5 of them. We are all family. My husband's birthday is actually Christmas. Christmas Day. We always have family and friends. The people next door to us had people in town. The complaints that they are saying that they saw is completely impossible. If you guys look at the pictures that I included from the street, unless you actually come down my driveway, there's no way that Miss Orr or anybody else can see anything that goes on in my house. The only two people that can see anything are my two neighbors that's on the right side, looking at this picture here, and they wrote letters stating that they haven't witnessed anything. The fellow on the left side of me wrote a letter. I mean, I have letters from my adjacent neighbors, and their complaints, in my opinion, are just unfounded. I would like to say this, though. No?
Okay, anything? Is there?
That's addressing them, and I know we're,
I don't think we need to.
No.
Counselor, is there anything else?
No, Your Honor. Oh, my goodness. I just left court. I do apologize. No.
Yeah.
No, Your Honors.
I do have something else. I mean, I have to say this.
Now, let me, you're a lawyer. You've hired a lawyer.
No, I would like to.
Okay.
Because, I mean, this is me on the line here. You know, between my husband, myself, and our parents, we have 180 years of service to Metro as school teachers, principals, and service. My autistic son lives in my house. There is no way that I'm going to have anything that's going to upset him. Even when we have family over, he retreats, but he's okay because he know he'll come down and mingle with people that, you know, his cousins and stuff. But to have someone else at my house, strangers, have a whole lot of noise and stuff, that would drive him crazy. That would drive him absolutely crazy. And I would never do that to him. That is all I want to say.
Okay, any other questions? Thank you. We're going to close the public hearing, and let's hear from Mr. Osborne or Mac. Who had this case, and can you give us?
Mr. Osborne.
Mr. Osborne. Tell us how you initially heard about this case and what you might have in the file related to any sort of complaints and any recent activity over there.
So we received a complaint for this one around the end of July, and I followed up on it on August 10th when I visited the property and posted a stop work order and sent an abate notice telling them to stop operating without a permit. It looks like since the last hearing, we have received some complaints that we haven't been able to really validate. The advertisements go up and down, but it doesn't look like there's been any new reviews on any of those.
So wait a minute. The advertisements go up and down. What does that mean?
They'll be up for a couple days, and then they'll be down for a couple days.
What months or what days were they advertising?
January, December.
Like this January? Like
Yes.
this month?
Yes, sir.
Okay. And
I haven't found any proof of operation since
but
then.
you could have booked something if you wanted to with that active. Was it an active ad?
I wasn't able to see it at the time. I'm able to see in host records that they did have screenshots from those days.
Okay, so tell us how Host works and how they were able to capture that.
So periodically, they'll scroll through the site and take a screen grab of the whole listing.
And so if the listing is up, that means you can book?
Potentially. The calendar may be blocked at that time.
Okay.
I'm not sure.
We're going to open the public hearing to ask Counselor, what's going on here? Are your client still advertising this property since our
She is
last hearing?
She is not, Mr. Ewing. She was referencing that profile to make the Airbnb profile. So she was pulling some pictures off of it and looking at it. It may have been active during that time.
But it sounds like on multiple occasions. You really think that?
I'm gonna let Ms. Mays explain.
No, just to get the pictures, to get some profile stuff. But I've been seeing more and more of accounts being cloned. I don't know if you all have been seeing it, but I've been seeing accounts being cloned. But I have not done any advertising or had any guests since.
Well, did you have an active posting for this since our last meeting?
No, there is no active posting.
No, but did you have an online posting where someone could see your property?
No.
And potentially book it?
No. I took it down.
Okay, so Mr. Osborne, how many times has Host really said that this happened?
So I'm looking at VRBO's or HomeAway's listing right now. It looks like the last time it was up was December 15th, December 6th. And it was down on November 30th. It was up on November 24th, November 19th, and it was down on November 13th. It was online on November 7th. November 2nd. And then I'll check Flipkey because I think that was the most recent.
So that sounds about 5 or 6 times that Host found that this was an active listing?
Yes, sir.
By active, does that just mean the profile is
Counselor,
visible?
we're asking the questions.
On January 19th, it wasn't online on Flipkey. On January 8th, it was. And then on January 3rd, it is back down. On December 23rd, it was online. And that was down on December 29th and 16th. And back online on December 7th.
Okay, so not to give away any trade secrets about our investigation process, but it sounds like basically Host gets out there and looks at these pages very frequently, and the ones that they find take screenshots and send them on to you, right?
Every week or so, they'll go through and take screen grabs from these listings, and then they will save them so that we can access them on their site.
So this was not just one time, not just to, sounds like Shaquille O'Neal, it was many, right?
It appears that way, yes, sir.
Questions for Mr. Osborne? Okay. Counselor, anything else to add?
We have no idea how Host works. She's saying she has no Flipkey account. She once checked into getting a HomeAway.com account. Everything that has been an issue that we have discussed here has been through VRBO. I don't know. I have never been sitting next to Ms. Mays while we were looking at these profiles. My advice to her was let's bail out of VRBO. Since VRBO is about renting an entire house, let's set up an Airbnb profile where you're renting a guest room. That's what we were trying to do. That's it. To my knowledge, you have not rented anything at all.
Counselor, it's not about renting.
Understood.
Violation of our law is posting. I didn't write the
had
law,
no
the council did, and that's what it says. So if you post, you are in violation of the law and are up to a year punishment. That's what the council said. It's not even the renting that's a violation. It's just literally posting an ad without a permit.
I understand. To our knowledge, the profiles did exist and she had a login, but they weren't visibly posted. And so
Okay.
those are the differences to me. And I understand.
Yep, okay. Any other questions for the applicant?
I do. So have you canceled the VRBO account?
To make it active over so many months or whatever, then they'll delete it.
Ma'am, you don't have a permit. Why would you keep it active?
No, it's not. I'm saying it wasn't active. When we first started doing this, she said, I want you don't have to make it active. You can just set up what you want and just keep it inactive. But if you don't make it active, they will completely wipe it out.
Well, considering you didn't have a permit, why is that a
Mr. Ewing,
concern?
we were simply trying to create a profile on Airbnb to show you what she intended to do going forward.
That is not,
Forward looking. So a profile exists, but it's not visible. No one can book it.
we are not the application process of the short-term rental. The people that you show what you intend to do are the codes department. We are the people that see whether you are in violation. So to me, someone that's saying you were setting something up to show us, that is very irrelevant to what our process is here today.
But no, I have not been, it has not been active And again, there have been so many cloning profiles. When stuff goes dormant or whatever, they'll take stuff and they'll clone it. They've been cloning.
Okay. Any other questions for the applicant? Okay, we're going to close the public hearing again. Discussion.
Well, I have, first of all, what is the legal posture exactly? Are we determining whether we are administratively changing a penalty, or are we calling this a new
I think it's a
hearing?
complete rehearing.
Let's ask John Michael. John Michael, what are we here for today?
The motion to rehear was granted, so this is a fresh hearing on the case, as though the one in September had never happened. They've walked in with a one-year wait period on a permit. The board will determine whether or not to reduce that one-year wait.
As I see the two presentations, there's a couple of differences. I'm not sure if I'm supposed to remember that the other one didn't happen, but I do remember it happened, and I remember way too much about this one. But I remember that the council member came and expressed his strong desire that we deny it. That council member who is now a judge, has sent word through Council Lady Hertz that he doesn't have those feelings anymore. That's one change. There are many more letters of support, including the two neighbors, that have not been bothered, which was not part of the original hearing. And the opposition has been steadfast in their testimony about what their experience is here. And so I think that the other new piece of information is that the testimony, I think, has always been that Reynolds stopped when they were told to stop. The new testimony is from the code staff that we keep seeing an active listing, but with zero evidence of, through reviews or other means, that it actually was rented. And so, all of that, if this was a brand new hearing and someone had had it listed but not rented, had support from neighbors and not active opposition from council, but I think we got even more than that to say, hey, I think this is something you should allow. I think it would be in that 6-ish plus category, and that's around the time that it's been. If we don't believe the testimony of the renting, then I think that's, if you think that it was up and there were actual rentals, then I think that you've got a different story. So to me, it kind of comes down to what your feelings are on that piece of it.
Any more discussion? Does anyone have a,
Well, I think I agree with that analysis.
okay. So does anyone have a motion?
And to be clear, the initial stop order was in July. So I'm,
John Michael, when was the stop order? Do you know?
The stop work itself was August 10th, and then the BZA application was filed on August 11th.
so it's right at 6 months now, give or take a week, I guess. So it technically is still item A appeal since we're rehearing the case, correct?
Correct.
Brand new case.
All right, so I'll move that we find that the zoning administrator did not err in his decision, and that the applicant be allowed to reapply for a permit on February 10th.
Okay, motion's been made. Is there a second?
I'll second.
Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? No. Passes 5-4. I mean 5-2, I'm sorry.
Mr. Chairman, before we move into our next hearing, I will note that one case that was not originally identified for the consent agenda is in fact eligible, and we would recommend it for the board's consideration. That's case number 2017-440. Brian Watkins is the appellant for the property located at 907, both A and B, 32nd Avenue North, over in Council District number 21. The planning's recommendation had been for allowance of payment into the sidewalk fund on this case. The appellants have agreed to do exactly that, and therefore staff would recommend it to the board for consideration on now an amended consent agenda.
Okay, we will amend the consent agenda to place case 440 on there. Is there a second?
Second.
Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Passes unanimously.
The next case the board will hear is case number 2017-327. Steve Hatcher is the appellant for the property located at 446 37th Avenue North, shown here on the zoning map, right at the end of 37th, before it drops off onto Interstate 40. Rajesh Nair, the owner of the property, is part of the appeal as well. The request is for a variance from the sidewalk requirements in this, the R6 zoning district, in the construction of a single-family residence. This matter has been before the board in the past. I believe the appellants went back to rework their case a little bit. The site plan submitted gives a sense of the layout of the property in this uniquely shaped lot at the end of the street. From my site visit in the winter, get a sense of the street, especially in the lower right-hand corner coming back out of 37th. And then again here, as you see each side of the end of that little dead-end road. Are the appellants present for case 2017-327? No dice, Mr. Chairman. I solicit your action.
Well, board members, you know the drill. We could either defer this for a month and hope that they show up, or we could just reject it, or what's the bidding of the board?
You know, the only thing that was outstanding to me was that if I remember, they were having some issue with TDOT and extending the street, and they were saying that they had to have sidewalk for like 3 or 4 lots. It wasn't even their property, and I think all we had the authority to do is give them a variance for the 13 feet, and they were willing to pay into the fund for the 13 feet. So I think, frankly,
let's defer it to the next
meeting. I would say
meeting.
either defer it or just say no. You just got to pay into the fund for your 13 feet, and let them have settled that outside of our purview, because I don't think we have a right. I think that our legal counsel even said we don't have a right to give them a variance for some other land that TDOT may be talking to them about. That's their property that they're, is that fair enough?
I have to be honest, I don't recall the specifics of the case, having not heard it with them here. I mean, I remember the case and I remember the issue, but I don't recall enough to give you the advice.
So
I thought it was Public Works that was asking them to extend the site. I do remember that there was an issue with Public Works, and the issue was, part of the deal was that if a variance was granted here, they still had to work
it
with
may have been
Public Works.
Yeah, it may have been Public Works. I thought it was some state thing, but so I'm happy to defer it for a month and
Yeah, let's defer it for a month.
And Mr. Chairman, we would respectfully note that we do have some room on the February 15 docket that we could possibly get this case on, and the old
absolutely.
March 1 docket is already overloaded.
February 15th.
Put it there. Okay, motion's been made to defer this case till February 15th and been properly seconded. Any discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Case gets deferred till February 15th. One less case to hear. Okay. John Michael.
Mr. Chairman, the next case is 2017-397, over in the edge of Council District number 24. Andy Hurt is the appellant for the property located at 4500 Harding Pike. This is the intersection of Harding and White Bridge Road in West Nashville. The request is for a change in legally nonconforming use in the MUL zoning district for replacement of a static billboard with a new digital billboard. The aerial photograph shown here gives you the sense of the layout. This is, of course, the Bellmead Kroger area and adjacent shopping strip. The billboard in question was to the top end of this aerial photo. From my recent site visit, the view of that area on the eastern, or rather northeastern edge of the lot along White Bridge there. On the bottom portion of the screen to the lower right, the view more up White Bridge Road, to the lower left, down Harding going westbound out of town, and the upper left corner, caddy corner, back toward the intersection of Harding and Woodmont. There is opposition present on this case. I believe you have an extensive case file in front of you, board members. The appellants are represented by counsel, so we'll invite them forward at this time. You'll have 10 minutes to make the desired presentation. If you wish to save any time for rebuttal purposes, save it out of that originally allocated 10 minutes, please. Just introduce yourself by names and addresses and address the board.
Good afternoon. I'm Brian Preston.
Please press the button. There you go.
Good afternoon. I'm Klein Preston. I represent Mr. Hurt, and my address 4515 Harding Pike.
I'm Andy Hurt. I'm representing the property owners, and my address is 4525 Harding Pike.
Okay, get us started. What are you trying to do here?
Well, we had a pre-existing billboard on the property, and code states in there it was a static billboard. And my understanding after reading the codes is what we had there was a older digital billboard. I've got pictures of it we can provide
Okay, yes,
to you.
please show us. What is an older digital billboard?
It was a billboard for a hospital advertisement that had a digital counter on it for how many minutes the wait at the ER is at that time. It would change on a frequent basis based on the caseload at the ER.
And so you're saying that because that was there, you want to get something, what do you want?
I want to replace that with a newer digital billboard.
And what is a newer digital billboard?
Yeah, the full screen that you see, frequently in the area that
So
we're
I
in.
remember these,
I have photographs of what the original billboard
yes,
was.
let's have it for our board members.
We keep speaking in the past tense. Is the billboard not there now?
No, part of the process to replace it is you take the old one down and then apply for a permit.
Is there a pole there?
I don't know if there's a stump still there. There's a base, maybe
Because
part of the
normally,
stump.
you need some part of the billboard to be grandfathered in, don't you?
It's grandfathered in. There's a base there
But usually it's
under 13-7208 or whatever that statute is.
So, out of this old picture of the billboard with the kind of little digital counter is very similar, I guess, to these lottery billboards now. It tells you how much the jackpot. A very small portion of the billboard is this number. So,
It's a type of lottery.
yeah, here you are. Why are you saying that this is even a digital billboard?
Because it has a digital component on it. And when I read the codes, codes just says digital. I don't see a definition of what it is anywhere. So if it's digital, it's digital, in my opinion.
Okay.
And it moves on its own. I mean, it's electronic and.
Well, to me, there's an argument before that, and that's that. I mean, it seems like that the reason that, from what we understand from the zoning administrator, that this property was denied really had nothing to do with the type of billboard, but it had to do with the fact that the billboard had been removed and had not been there for more than 30 months, and it was actually removed before you came to us in 2013.
No, that's not correct. It was the first application was to move the billboard and move the location, and it had not been. There was not an issue with 30 months or the removal. This application is for the new billboard in the same location where the sign was.
Well, I'd like to hear from the zoning administrator to just for clarity on why you think we're here.
I drafted a letter to the board that I finished only moments before this meeting. So as soon as I finish reading it, I'll give it to council and to other council. So I'm going to read my memo into the record so that we have it. Dear members, this is an item A appeal of my decision to decline to issue a permit for a new non-conforming digital billboard. The property in question is the Bellmead Plaza Shopping Center that contains 10.57 acres and located at 4500 Harding Pike. The property is currently zoned MUL Mixed Use Limited. In 1974, the property was zoned CS, Commercial Services. The CS district allows billboards. In 1984, a permit was issued to construct a billboard on the property, and the billboard was constructed. In 1998, the property was rezoned to MUL. The MUL district does not allow billboards. And I'm citing Metropolitan Code Section 17.32.150A and Metropolitan Code Section 17.32.050G5. Sometime between 2011 and mid-2013, the billboard was dismantled and removed. On June 4th, 2013, the property owner made application for a permit to reconstruct the former billboard at a different location on the property. That permit was denied by my office. On July 3rd, 2013, the owner filed an appeal to the Board of Zoning Appeals seeking to overturn the decision not to issue the permit. On July 18th, 2013, the Board of Zoning Appeals heard the appeal and upheld my decision to not issue the permit. That was BZA case number 2013-059. The owner appealed to Chancery Court by common law writ of certiorari, and the Chancellor upheld the BZA's decision. The owner then appealed to the Court of Appeals, and the court dismissed the appeal on procedural grounds. Now, the owner has made a new application for a permit to construct a new digital billboard on the property. I refuse to issue the new permit. The owner has filed this Item A appeal asserting that I erred in refusing to issue the permit based upon the contention that there is no, and I'm quoting, there's no legal distinction between the digital sign on the appellant's property, which exhibited the hospital wait time at St. Thomas, and a more detailed digital sign, which may include more detailed images, end quote. It is my opinion that there's no legal basis by which a new digital billboard, digital or otherwise, may be constructed on the property. The original billboard was removed sometime before the prior BZA hearing on July 18th of 2013. The current zoning does not allow billboards. More than 30 continuous months has elapsed since the removal of the former billboard. Pursuant to Tennessee Code Annotated Section 137208G, the grandfathering provisions, quote, shall not apply if an industrial, commercial, or other business establishment ceases to operate for a period of 30 continuous months, and the industrial, commercial, or other business use of the property did not conform with the land use classification as denoted in the existing zoning regulations for the zoning district in which it is located. Any time after the 30-month cessation, any use proposed to be established on the site, including any existing or proposed on-site sign, must conform to the provisions of the existing zoning regulations. I'm citing Tennessee Code Annotated Section 13-7-208G. It has been repeatedly recognized by the courts that Tennessee Code Annotated 13-7-208 applies to billboards. In this case, more than 30 continuous months has elapsed since the previous billboard was voluntarily dismantled and removed from the property. The existing zoning regulations do not allow any billboard, digital or otherwise, to be constructed on the property. Pursuant to Tennessee Code Annotated Section 13-7-208G, as well as Metropolitan Code of Laws Section 17.32.150A and 17.32.150G5, it's my opinion that a permit to construct a new billboard should not be issued. Now, I've got aerial photography showing that in 2011, the billboard was there, and in 2013, the billboard was not there.
So prior to our hearing, you said on July 18th?
Correct.
So this case really is about whether the billboard can be reconstructed and this time has lapsed. Is that correct, Mr. Herbert?
I'm sorry.
This case is really about whether the billboard can be reconstructed, and you have given us this letter saying it cannot because of the time period.
That's because more than 30 continuous months has elapsed. It has lost its grandfathering rights, and under the current zoning for the property, billboards are not allowed. Digital or otherwise, billboards are not allowed.
Had they left the billboard up, they could still have it even though the laws have changed, but they didn't, is what you're saying.
That's correct.
Or yeah, at least we'd have a different argument. It's
Right.
sign is a sign.
Okay. Any questions for Mr. Herbert? Okay, Counselor.
The use of the property and the use of the business has continued on, and there hasn't been no change there. It is true that in 2013, I think the billboard at least the face of it, was removed. But we would take issue with the statute on an interpretation of it, because I think the continued use of the business on that property would continue the grandfathering clause application. That having been said, we were denied the permit, and that by Mr. I think his name is Thermopolis, and there was no statement or anything with respect to the interpretation of 137208 or any other basis. The only basis that we were given had to do with the lighting provisions, and the reasoning was that it was static to digital, is what he stated. A difference in the use of the billboard from static to digital, which was, we submit a misapplication or misinterpretation of what the original billboard was and what the proposed billboard is. They're both digital. They move electronically, and even though there's an advance in technology, and if you go down that corridor from Harding to West End down to Broadway, along that entire corridor, there are these type signs.
I think most of those, if not all of them, have been grandfathered in and then apply for changes. Why'd the billboard get taken down?
I think I was recommended by the billboard company as part of the application process was to take it down, then go and get your permit.
The billboard company said that to you?
They did. But I would contend that the case, the clock wasn't really ticking for the 30-month period because we were in the court system still arguing our case, and it, took time to do that.
When did your case end in court? When did it start in court, and when did it end in court?
Well, it started with our first application here, and it ended the last summer.
And the result of the case was?
It affirmed the trial court on procedural grounds.
So I would contend that the 30 months the clock would start then.
That should, even if that application or interpretation of law were correct, during that period of time, Mr. Hurt would be prohibited from doing anything because of the matters before the Chancery Court and then the Court of Appeals. And at that time, we were attempting to the original application was to move the location of the sign, and that was the major contention in our view on that.
But you had every opportunity with that, moving it during that time to put it back where it was. I mean, that was a choice y'all made. Your case was to move the billboard from one spot to another. You say that the sign company said take it down. You took their advice. We said no. Everybody else said no. You still appealed it, and it doesn't seem like there's any evidence that you said, okay, well, we'll just put it back where it was. And so that was your choice. And so it seems like that the clock ticking issue argument kind of went away when you made that choice not to kind of put it back where it was and to stick with your original plan to try to move it to another location.
Well, the problem we would have had is had we prevailed on our appeal in Chancery and we had sought to put it back where it was, then we'd be in a position where we'd have two billboards and there would be a conflict. And we certainly couldn't have two in that instance. So our position was that we need to let that run its course through the court.
But we have photographic evidence that it was completely taken down. I mean, pole isn't even there, right?
No, the pole's not there. The base is what was.
But the base isn't a billboard. The base is a base. The pole and the sign are the billboard. Now, some people would argue the pole isn't even a billboard. It's the sign.
I mean, that's true. I mean, the billboard itself.
So if you would, as Mr. Taylor said, if you would put up another billboard somewhere else, you wouldn't have two billboards. You'd have one. You'd have an old base, and then you'd have a billboard.
Well, had we gone forward and put back that billboard, for instance, and then Chancery Court ruled in our favor, then we'd have this approval, and then we would have the possibility of having two billboards, and we couldn't do that.
Okay. Any questions for the applicant? You'll have time for rebuttal after the opposition. 5 minutes and 25 seconds. So let's hear from the opposition, and you'll be back. Thank you.
Thank you.
Please identify yourself for the record, your address, and why you're in opposition of this case.
Mr. Chairman, Sean Henry with the law firm of Tunentry and White. I represent the Association of Owners of Royal Oaks Towers. On my right is Woods Welburn. He's the president of the Royal Oaks Tower Association. On my left is Christina Fior. She's a secretary of the organization. And we are here in opposition to this appeal case. If I may, I would like to hand out a legal analysis and some photos for your consideration during our testimony.
And please share that with the opposition, the applicant. Has the applicant gotten those?
I don't believe so.
Okay,
If we could
please
have
give
one
them a
for
copy.
the applicant, that'd be great. Thank you. And I must add, I spoke with Council Lady Kathleen Murphy of District 24, represents this area. She's out of town. She asked me to inform you that she too opposes this appeal. The prior decision, as Mr. Herbert has well documented, was more than 4 years ago. And it was the same issue. It was the same parties. It was the same full and fair hearing that occurred back then. Those are factors that lead up to the doctrine of res judicata. I know there's some attorneys on the board, but without getting
Our
too...
non-attorneys weren't fortunate enough to go to law school, tell us what res judicata is.
Yeah, without getting too deep into the weeds on that, res judicata...
Mr. Chairman, could I get a copy of what they filed?
I told them to give you a copy to someone. Okay, thank you.
Mr. Chairman, the doctrine of res judicata is, as our Tennessee Supreme Court has stated, is a rule of rest. The purpose of that is to promote finality in issues in dispute. It's to prevent inconsistent and contradictory decisions. It's to conserve resources, particularly folks like your staff in the Codes Department who advise you on these things. Mr. Herbert obviously has had to now spend more time on this issue. It's to protect the litigants and to protect them from multiple unnecessary lawsuits. Recently, in 2016, there was a case in Marshall County whereby a property owner sought to have the Board of Zoning Appeals declare that his rock quarry was legally non-conforming. And the Board of Zoning Appeals found on 2 occasions that the rock quarry did not qualify as a non-conforming use. That case went up to the Court of Appeals, and the Court of Appeals, in fact, decided that boards like yours, adjudicative boards like yours, quasi-judicial in nature, can rely upon the doctrine of res judicata to dispose of your cases. And in fact, that term should not be entirely foreign to you. Your rules of procedure have a provision regarding res judicata for applications that have been filed and may not come back to you any sooner than 6 months. So without getting into digital versus static, without getting in too far into the facts of what's there and what's not there, the fact that this same issue was presented to you more than 4 years ago justifies you in denying this case on the grounds of res judicata. The second point here, and we've now handed those photos out to you, is the very first photo that we have is a photo I took this morning. And this photograph clearly demonstrates the present condition of the property. And you can see there's a circle in the ground that's filled with concrete. That circle is the border of a metal encasement that once, I surmise, once supported the monopole that supported the billboard sign itself. There's also conduit there that has been filled with concrete. Both of these features are obsolete. I fully expected we might see some method of attachment if they wanted to resume the use of a monopole at this location. There's absolutely no way they can do that. If you flip through some of these other photographs, these are photographs that were obtained from David Klein. He's the custodian of Metro's aerial photography. Each of these photos have a date and pictometry reference in the lower right-hand corner. In the lower left-hand corner, they have dates in which these photos were taken. And consistent with the prior testimony of Mr. Herbert, after February 20, 2011, the billboard containing 2 signs disappeared at some point, so that by February 24 of 2013, the aerial photo that was taken reveals that there's no billboard there any longer. So that means that the billboard's been gone for approximately 60 months, about 5 years, even when they were here before you the previous time. And as already cited, any cessation of use, in this case, the billboard not operating for more than 30 months, has no right under our state statute for nonconforming protection to reestablish itself. Any nonconforming rights that they may have evaporated. They've lost those rights.
Mr. Henry, how do you respond to the other side saying that they were litigating in court and therefore it shouldn't start until after that's done?
Their very testimony says they took the billboard down before the litigation began. Their very testimony says they took the billboard down before they filed for the appeal that was here in 2013. So they acknowledge that the billboard has been gone way before there was any litigation involving it. And so they want to take advantage of the tolling provision, but that was well after they removed the billboard. Once that billboard was removed, that clock began to tick. And I don't think you can toll it years later because you want to take advantage of that statutory protection.
So, what about the argument that the use has not changed on the property itself, the development itself hasn't changed throughout this time, and somehow that pulls the sign along with it?
I disagree with that. Much of the case law looks at billboards as independent uses. Many billboards are owned by billboard companies where they have a ground lease, and what's the use of the ground itself for whether it be residential, commercial, industrial purposes is one thing. But our courts have looked at billboards as business uses all unto themselves. So I disagree with the statement that because they've been using the property consistently for commercial purpose, that use extends to the billboard. The billboard stands independent of any other use on the property. Finally, we're trying to conserve time because there is another speaker who wants to address the board. We don't believe this billboard, even if you find that res judicata does not apply, even if you find that there's a tolling provision and they haven't tripped up on their 30 months of non-continuous use, we simply don't see that the provision they've cited in their appeal qualifies them for a change in use, because we're really not talking about a change in use. The billboard's a billboard. What we're talking about is the method of illumination. They're proposing to change that from static to digital. There's another provision that I'm not going to mention for their benefit under your nonconforming provisions in your zoning code. I think they could have taken advantage of that. They've not selected to do so. They're asking to change a use, and I really don't think that's the proper technical criteria that should be in front of you. Assuming you agreed with that, what they have to demonstrate to you is that a digital billboard is going to be more compatible to surrounding properties and not less. I think they also have to demonstrate to you that it would not increase the degree of nonconformity. So where they had a little box of digital messaging for St. Thomas Hospital, they now want to expand that and cross the entire board. You have to find that is not an increase in nonconformity, and I don't know how you would conclude that. Mr. Welborn can readily speak to the impact that they would expect to have with that billboard, and I think it would be helpful for you to hear from him. Thank you.
Yes, please state your name and address.
I will. My name is Woods Welborn. I'm the current board president of the Homeowners Association of Royal Oaks Towers. We sit on a hill that basically overlooks the entire Belmead Plaza and the location that this sign would occupy. I can tell you that our residents and our owners are deeply concerned with the effect that this would have on our building. It would run 24 hours a day. We would have these LED lights changing potentially every 8 seconds, and shining in a large percentage of our bedrooms, our living rooms. It would really profoundly affect the enjoyment of our units. And I think that subsequent to that, or as a direct consequence of that, it would affect the saleability of the units. It would unquestionably affect the livability of the units, because we would be forced to keep our shades drawn or blinds drawn most of the time in order not to have to look at this bright thing going 24 hours a day. Anyone who thinks you can't see them during the day is dead wrong. You can see them plenty. At night, they would be more than a little offensive. So we're really concerned that anything that would erode the character of the area which we live in and many other people live in, along with having the light commercial and office uses, but there are lots of people who live there, will affect our values.
Okay. Do you have anything else to add for our next speaker?
Just one final correction in my letter to you. There was a typo. The statement should read, consequently, the appeal does not qualify for a change of nonconforming use. Thank you.
Okay.
Where's Royal Oaks Tower on this picture?
I'm
Can we
sorry?
see Royal Oaks Tower on this picture?
It's just behind.
It's just on the other side of this rectangular building at the lower right corner. We actually, you could have taken this aerial just to the right and you would have captured our building.
You see the top of our building right in the lower right-hand corner.
It's probably the
Sorry.
corner, yeah.
You see the
Right
roof.
there.
Yep,
The roof.
Yes, sir, that's
Right
it.
there.
Correct.
Yep, that's where it looks.
Yes.
And I'm sorry.
Sure.
To interject, I'm Christina Fiore. I'd like to also point out that the LED of 14 feet by 48 feet is so enormously big, and it would shine directly into the mirrored windows of the building on the corner, which is Ingram Industries, and that would directly even not only magnify it, but it would reflect immediately back in all of the front units of that building.
Yes.
Okay. So,
Mr. Chairman, one final thing. We just want to entertain for the record, we have 32 letters that have been signed by residents of Royal Oaks Tower. We previously sent those to staff, but I just want to acknowledge for the record that we'll file those here with you today.
okay.
Thank you.
And we have them, I think, too. So thank you. We're going to hear from those also here in opposition. Please come forward.
Chairman Ewing, members of the commission, I'll be very short. Tom White, 315 Dedrick Street. I represent Mr. George Hetzel. He's one of the occupants of the spaces in Royal Oaks. He's on the 8th floor at the corner, probably the most directly affected unit by the issue that we're talking about because of the height, the proximity, and basically the magnitude of his balcony facing this exact area. With respect to the arguments that have already been made, I think the clearest one perhaps is the res judicata. There are lawyers on the board, relatively simple doctrine where it's the same parties, the same issue. I don't think that could be any clearer than this exact case. And my understanding is not only same parties, same issues, same attorney. I mention this to you because we had the issue of res judicata come up before this board on a number of occasions. It came up in the East Ivy case, and there was some discussion there about does it apply in administrative actions. The Finley case that's cited clearly establishes that in administrative quasi-judicial actions such as yours, res judicata applies. The second debate was, well, the East Ivy case was a case that dealt with a conditional use permit. The Finley case is a non-conforming use case. That's exactly what we've got here. It's not only on all fours, it's 4+. It's exactly what we have. The next issue has to do with the cessation of the 30 months. Again, the record can't be any clearer that before this matter came before the board 4+ years ago, there was a cessation of the use. And so, in my opinion, it's a classic example of the plaintiff in this case being an architect of their own agony. They're here because they took the board down. Why did they take it down? I don't know. But it's down to the ground. There's no pole. There's no sign, period. So I'd respectfully ask the board to not allow this request today. Appreciate your courtesies. Thank you very much.
Any questions for Mr. White? Okay, thank you. Anyone else speaking for opposition? Nope. Let's hear from the applicant again. Please come forward. You'll have about 5 minutes, and that's it.
I would point out, Mr. Ewing, that what appears on your diagram to be where they say the sign was is not where it was. It was over towards White Bridge Road on the building.
Oh, you mean this little house thing?
Yes.
Yes, I mean, that's I don't know
If
why.
that's what that
That's just a
denotes.
That's probably the address, the PIN address.
Okay.
We have many.
Okay. Well,
We have many photos, including the Metro photos, that show the before
Where
and
what?
after. And while we're on this subject, I want to ask you about that, Mr. Preston, that the other side submitted a picture that you should have a copy of taken today, and what you called a base has been filled in and just looks like another part of a concrete loading zone. Is that what you call a base still?
no, the original sign had some support for the base, based on what I've been told, on the top of the building.
Yeah, I don't think that's where it was.
I don't think that's the base. The base is on top of the building.
Is there anything related to the sign left anywhere?
There's probably a small stump.
A stump on the
Yeah.
building?
They cut the pole when they removed it.
Did you not see this picture that the opposition gave us taken today of kind of outside Katie's Hallmark? And it looks like a circle that is kind of the width of a pole for a billboard, and it's been filled in?
I do see that, and it was my understanding that the base of it was on the building.
Yeah, you look at the pictures that we provided of the sign,
Okay.
it looks like it's more on the roof.
But basically, I mean, you all took the sign down in 2013, and it's no longer there. And you took it down before the court case, so why should we start the clock later?
Well, for the same reasons we discussed earlier, and that is, we brought this original application during what is referred to as the 30-month period. There was that issue, and it was brought during that period. There was no...
Yeah, but you had taken the sign down before, and then you lost the case here, right?
That's right. And then we appealed, and then once through the Court of Appeals, when we were unsuccessful there, then we, within a year, we've brought this case back. So, but this is different. I want to address the race judicata argument, if you might. Sure. If you'd let me. It's not the same because the issue's different in that this application applies for the sign to be restored, a different type of illumination, but restored in the same place. First application was to move the sign. So it is not the same on all the issues.
Well, now, you can't have your cake and eat it too. I mean, if it's a different issue, then how can the clock still be?
It's the same.
How can
It's
the
the
clock
same.
stop?
It's the same sign. You're allowed to have the one sign on the property. So we asked to move it, got denied, went through the court system, lost. So we're now back to our okay. Well, let's leave it where it was. And
then we were denied simply by the administrator. We were denied on the grounds simply that static to digital. There was nothing said or in this opinion or the order denying it that had anything to do with timing or anything of that nature. It was simply the issue of static to digital, and it was our argument and belief that there's not a good definition in the law or one that's clear that says what's the distinction in the types of digital. I mean, even though that is a simplistic...
But, Mr. Preston, the issue really is you all took down the sign. Mr. White says you all are the architect of your own agony. Had that sign been still up, this is a different case.
you got 30 months after you take it down to make your application to put one back, and we did that.
You took it down in 2013, and then it wasn't...
We were denied by codes and then came before y'all in 2013. You denied us. Then we worked through the court system.
But
now
that
we're
wasn't
back.
putting up an application, or you could have put up a billboard, right? You could have, as it worked its way through the court system. But you've argued that there was like some remnant of this sign, or you didn't want to put up 2 billboards, but there's no billboard here. There's not even a piece of a billboard left.
We couldn't have 2 billboards on the property.
I know, but there's not one billboard on this property now. There's
Well, I
0.
understand, but we had to work through the court system. I mean, had we been granted by the Court of Appeals or Supreme Court or whomever to put up a sign, and we had left that sign there, we would have two.
You wouldn't have two until you put up two.
Well, but I mean, that's the whole point,
Did the zoning examiner?
was to make the move.
Physically go to the site when you made this application, or did you come down here and tell them that you wanted to change a grandfathered billboard from a digital or static to a digital? I mean, did he physically go there and see it?
He took pictures, Mr. Demopoulos did, I think, first.
I can answer that question, actually, Mr. Taylor. We don't allow our zoning examiners out in the field. We handcuff them to the desks and keep them in their office all day long.
Well, that's what I thought. So, I mean, it seems reasonable for someone to be presented. I mean, if I went to the code's office and I said, I have a grandfathered billboard, I want to change its use, and I would say, well, no, you can't change it because you're changing, the use. It seems very reasonable that a zoning examiner would make that point, not knowing fully that there wasn't an existing billboard there. I mean, you pull up.
I think he did look at, if I remember correctly,
It's neither here nor there because, I mean, he's not here to.
on his
defend himself.
computer,
He's saying
I think he looked at Google Maps or whatever.
So continue. Let's talk. You were talking about res judicata.
So it's not identical. I mean, the parties are the same. The issue's not exactly the same. The issue's not exactly the same because the application is different. It's different in that the application is just to put the sign where it's always been, or was until it was removed. The original application, the first application, was to put the sign in a different location. So res judicata wouldn't apply because it's not the exact same issue. So I respectfully submit that that's not an accurate depiction of the factual issue here, which is it's a totally different application, but we were within this time. It was brought originally within the 30 months. And time-wise, I looked at the opinion. We were denied cert by the Supreme Court in April of last year. So, we're within a year of bringing this action. So it's not like there's been a total lapse in what the appellant here has done with respect to seeking to utilize this property the same way it's been utilized the whole time. This property's still the Hertz property. It's still being run and operated, the different businesses there, the way it was, the whole time. Nothing's changed in the ownership, and it's being used the same way commercially. I would like to point out one thing, if I can, that if you look at where the opponents, the opposition, live in comparison to where the billboard is proposed to be, I mean, it's a pretty far distance. They're up on the hill back behind this large building at the bottom of the photograph. They're back behind the hill. And to take the position that the illumination from the sign that would be pointed more towards the east on White Bridge Road there would somehow be in their bedrooms and change their views and somehow obstruct and interfere with their use and enjoyment of their property is, I would say, a pretty good stretch, particularly because of the heights. Number one, the Royal Oaks, and they would tell you, is elevated. It's behind the office building there at 4525 Harding Pike. It's behind it, and it's the highest point. It's the citadel in that area. Across the street, that billboard would be not only not pointing directly to them, wouldn't have the illumination power to interfere with anything, but it's also on a different sight plane. They're above that, so they would have to look out their windows and actually make an effort to even see what the billboard had on it.
Okay. Anything else to add? Questions?
I have a question. In 2013, you applied to put a digital billboard on a different location on the site.
That's right.
Okay. And now in 2017, you applied to put a digital billboard on the same location as where an old billboard was.
That's right.
And it was in both 2013 and both 2017, was it the same digital billboard that you're proposing? The same type of, I guess it's a scrolling? How do you describe your digital billboard in 2013 and 2017?
It's one of the, be a giant reader board, with pictures and scrolling ability. You see them all over the place now.
And it's the same proposal in 2013, the same type of billboard in 2013, and the same in 2017? Okay.
How was the billboard operated before? Was the landowner operating and owning the sign himself, or is the land leased?
The landowner owned it, and it was leased. The rights to the billboard was leased by a billboard company.
Has the lease, have they continued to lease it this whole time?
Well, no, they're not using it right now.
And if I might,
When the last time the billboard company leased it?
I guess in 2013 when we had a billboard. So we're waiting to put another billboard to lease it to another billboard company.
So the reason you don't have a lease is because there's no billboard, right? I don't think
well, that's right. There's no dispute there's no billboard there.
Yeah, we're not going to dispute that.
I would like to provide you with one other thing, and that is this is a Google Maps of that, what I call the Broadway West End Harding Pike corridor, and it shows, and I have one for each of you.
Okay, we'll take it.
And what it shows is the white dots here show where there are these exact type signs that we propose to put back in the original location along this corridor.
But I think the difference is those were old existing billboards that they went through the procedure. They never took them down, and they just, appealed to make those digital.
Well, I don't think that's accurate because, and on the back page, I have the list of where these different billboards were. And, some of these are relatively new businesses, some are not. But you have these type of illuminated digital billboards from Hart's Hardware in Belmead. Then there's a spot where we would have ours, you could see. And then all the way down to almost 2nd Avenue, these are along that entire corridor. And the zoning's different, but the denial that we, from Mr. Thermopoulos, had to do with the lighting, and which is proper for Metro to enforce under the police powers. But if you look at these billboards along that corridor, there is no distinction, or should not be any distinction between a billboard that could be placed off of White Bridge Road here and one at Hart's Hardware. They're all the same along this corridor. All we're asking is that Mr. Hurt be permitted to put that type sign back where
very good.
That was.
Time's up. Any other questions for the applicant? Nope. We're going to close the public hearing. I want to ask our attorney or John Michael kind of the rules of billboards and kind of how you're allowed to, so the question is, if I owned some property along this same corridor that Mr. Preston talked about and there wasn't a billboard there, could I put a billboard up today?
I will defer to John with respect to what the zoning is, but if it's not correctly zoned, then no, you cannot.
There are a lot of places in Nashville that you can't put up a new billboard. Is that correct?
That's correct. There's tons of places you can. It's actually far more that you cannot than you can. As you can see from the slide shown here, that's the MUL, Mixed Use Limited Zoning District. You do not have the right to operate a billboard in that zoning district. That zoning district was put in place after the original billboard had been put there. So as the board has already noted and heard from both the appellants and the opponents, was a legally non-conforming billboard when it still existed and was there. However, under this zoning designation, you don't get a new billboard today.
Okay, thanks. Discussion.
I think it fails on a lot of issues. Almost every one that we've heard. I'm not a lawyer, so the res judicata, you know, the only thing I really know about that is probably from Legally Blind. But I think that was an argument there and wasn't effective, but I think it may be effective here. And but that, because I do think that it's sounding a lot like what I remember hearing in one of the first cases that I heard. I do believe that I was part of that that original case. But I also think the cessation argument that the zoning administrator made is also compelling, because I do think that it was their choice to take it down. I don't think that they had to take it down. I don't think the clock stopped, you know, and and I think they may have gotten bad advice to take it down. But they took it down, and I think that based on the aerial photographs of the existing, when the billboard was there, appear to sync with the opposition's photograph today in terms of where I think the billboard was. And I think there's no longer any evidence that that billboard ever existed. And so I think that I think it's hard to argue that point. I think the zoning administrator is correct there. And while we didn't even get to the argument on the type of lighting, I know there have been court cases from our decisions in the past about whether the types of billboards are the same or not. But I do think that if the argument had gone further than I think Mr. Henry had argued, I would be in agreement there that it's hard to, I'd support his argument that it's hard to argue that going from a 10-minute wait sign to a full-fledged LED is less non-conforming. So I don't see the appellant making a case or kind of winning their argument on all three of those major points. So I tend to support the zoning administrator's decision. Although I will have to ask the technicality, because in the docket it says that they are requesting a change in non-conforming use. The zoning administrator is saying, hey, I think this is an item A. We declined a permit. They're saying we were wrong. So I'm not sure exactly how the motion needs to be made, but my vote would be to support the zoning administrator.
More discussion?
Well, I'm not a lawyer either, so stop me if I sound stupid, but I feel like sort of the running the clock argument and the change of views, I feel like it was a very scattered argument, and I don't feel like it was. I don't feel like there's a good argument there on any of those 3 points that Mr. Taylor mentioned, and I think I agree with the zoning administrator on this case.
Any more discussion, or is there a motion?
I will just step in briefly and say that according to their application, it's an item A appeal, and which is in line with what Mr. Herbert said in his letter. Also, to get one quick point of clarification to your question earlier, Chairman, there is a Court of Appeals case, and you referenced this briefly, that says, and this is just further consideration for you all, that signing and lighting restrictions and regulations are not tantamount to zoning, but rather are reflective of the city's police powers to regulate and provide safety regulations. And so therefore the grandfathering provisions don't kick in. So that's something else for you to consider, is that because this is a sign and lighting regulation, and therefore, according to the Court of Appeals, not tantamount to zoning, it's not a grandfathering issue.
Since this is an
I have a question. I just wanted to ask Mr. Herbert his opinion on the res judicata argument that's been made.
I didn't really look into it, and the reason I didn't is because when I looked and saw that the billboard had been taken down before the application to come to the Board of Zoning Appeals back in 2013, to me, that was the end of the analysis. So I didn't even look at res judicata. I'm certainly aware of it, but I didn't go there because, to me, the bigger picture is the zoning doesn't allow billboards of any type at this location, and since that billboard was taken down before the Board of Zoning Appeals case or even application back in 2013, To me, that starts the clock to tick, the 30 months, and once that ticks off, then there's no ability, the grandfathering is lost, and there's no ability to come back and put another billboard of any kind. Litigation notwithstanding, but only, it might be slightly different had they not taken the billboard down prior to making the application back in 2013 to go to the BZA.
Any other questions, motions, anything?
I make a motion that the zoning administrator did not err and his decision should be upheld.
Motion's been made and properly seconded. Any discussion? Seeing none. All those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. John Michael, we would like a short break.
The BZA will take a short break and reconvene with the next case on the docket, case number 398. One additional case was added after we started our meeting. That's case number 2017-437 from Council District number 17. Yancey Lovelace is the appellant on behalf of LL&E Holdings, LLC. The property at issue is 407 Humphrey Street. The request was for a variance from sidewalk requirements. The appellants have agreed to match the Planning Department's recommendations for that case, and therefore staff recommends the matter be considered for consent agenda today.
Okay, another case moved to the consent agenda. Is there a second?
Second.
Case has been properly moved and seconded. Any discussion? 437 is it? Okay, any other discussion? Seeing none, all those in favor of putting 437 on the consent agenda signify by saying aye. Aye. Opposed? Passes unanimously.
Mr. Chairman, we're also joined at this hour by Councilmember Scott Davis from Council District number 5. Councilman would like to address the board with regard to a case or cases on today's agenda.
Okay, welcome Councilman Davis from District 5. What cases are you in front of us for today? Oh, please, Preston. Yep.
Thank you, Mr. Chair. I believe it's 1431 Lishi Avenue.
What's your opinion on that case?
I am asking for whatever kind of mercy that this great body deems to give it for a couple of reasons. This property is a large property. It's the Joy Mansion. The Joy Flower Company is a part of this property. It's about total 10 acres or more, maybe 25. But on this property where the mansion sits, it's between 3 and 4 acres. It's a very big property. And during the whole council process, we tried to make amendments for Airbnbs that are on large parcels, and sometimes it went well, sometimes it didn't go so well, and this property has been one of the victims of that discussion.
What do you mean victims, Councilman?
Well, because sometimes when you have a larger parcel, you're less likely to disturb people, or less likely to bother people. Out of sight, out of mind at times, and maybe sometimes people say, "Hey, this is a historic mansion, and and we want to have weddings, or we want to Airbnb this, or we want to have all our guests stay here because I live in East Nashville. We have a lot of historic buildings, and this neighbor has repaired this back to its former glory. It was a very expensive endeavor before the Airbnb craze. Now, I will be the first one to say he has not been the perfect owner, but as far as doing stuff in the neighborhood association has sent in 12 letters of support, I believe. He has done neighborhood events. We have our movie night for Highland Heights there because he has the space. And I know ignorance of the law does not excuse anybody, but when you have a large mansion like this, and when you're trying to, work with your neighbor and you're working with your other colleagues in council to, hey, can we get some exemptions, or can we for historic mansions or historic properties like this, can we go into, can they do 11 rooms instead of 7? Can they do 15? Because it's a large property, but it's a very unique property in my neighborhood because most of my neighborhood is in the urban core near downtown. So having 4 acres where just one big house is plopped in the middle is very rare. Just a brief history lesson, the Joy Flower Company and the Joy family, one of the daughters of the Joy family married married somebody related to Andrew Jackson, either Andrew Jackson or their son married. They're one of the first families of Nashville, so they're related to the Jackson family.
Most likely the Donaldsons.
Yes, sir. So
and of course Tom Joy Elementary, same family.
Yes, and also with the neighbor over here with his property. It's a large parcel, and I know there's been some complaints about some parties, but in their defense, they've thrown parties for kids in the neighborhood. We've done our Halloween there for Highland Heights twice. So I'm scared that some of the complaints may have been from the Halloween or from the Christmas party. There was no alcohol at the neighborhood Christmas party for Highland Heights the year that we threw it there. So I'm hopefully that, we've not caused this gentleman any extra pain because Highland Heights would meet in a room in a church, which we're blessed to have, but when we want to do big events and want to raise money for the neighborhood, we do it here at the Joy Mansion. And I want to ask for also leniency because we're looking into this and, because of the repairs and the stuff that the gentleman has to do, I don't want to cause a financial burden, but I'm looking at, doing a historic marker now that we've fully established this is the Joy Flower Company and the Joy Mansion, and doing a historic bed and breakfast, which, with the bed and breakfast, you got to have staff and other obligations. And I know eventually he was working his way into that, but I'm open to, and I know the neighbors are, to rezoning this for him. So any kind of mercy, I feel 8 months to a year suspension, this is all he does. And not excusing or saying that people who work jobs and have Airbnb, they're deserving of mercy too. But this is all he does is this Airbnb work and keeping up the mansion, and and this is his livelihood. So I really don't want to damage it, but I understand that you have to do what you have to do, and whatever decisions you make, I am not going to be angry, or whatnot, but maybe there's some guidance or options just in case, the hammer comes down, can we amend after the historic zoning and bed and breakfasts are approved? Can he come back and say, hey, I'm doing this now, I have this. Can we fix it or not? I'm just asking for you to have some blessings, have some mercy, because there may have been confusion on all ends about the number of people you could have in such a big house, but not, and then the land size. So whatever you want to do,
okay. Thank you, Councilman Davis. Any questions for the councilman? Thank you for being here. John Michael.
Mr. Chairman, case 2017-398 is a case that's been presented to the board previously. Aaron Smith is the appellant and owner of the property, previously represented by his son in this matter. The property in question is located at 2210 Mecca Drive in Council District Number 15. You may remember that I noted Councilman Syracuse is present and wishes to speak at the end of the proceedings on this matter. The request is for a variance from the restrictions on size of an accessory structure in the RS10 zoning district for the construction of an addition to the side of an existing garage. The half-circle driveway shown here is the property in question. The structure behind the obvious house is the large garage as it's present, or somewhat presently situated, based upon the date of this aerial photograph. The site plan submitted shows the approximate area where the construction is proposed. The photographs from my recent site visit to the subject property. The view up and down Mecca Drive. Mr. Chairman, you'll remember that the board deferred this to this later date so that the appellant and his neighbors would have the opportunity to meet, discuss the matter, and see if there was any sort of meeting of the minds. It's my understanding they have in fact had a chance to have such conversations and come back to you now today a little better informed on the intent of the appellant. With that, we'll invite the appellant forward to make his presentation to the board, and after the appellant speaks, we'll hear from the opposition. After any rebuttal testimony, I believe we'll hear from Council Member Jeff Syracuse. Mr. Smith.
Okay, Mr. Smith, please come forward. Is Mr. Smith here? Okay, John Michael.
Mr. Chairman, the board has the opportunity to take action on this case in the absence of the appellant on a very clearly identified hearing date. However, the board also has the opportunity to defer to a later date if they see fit, and we'll defer to the board's better judgment.
There were some people here that were, I think, previously opposed.
Who's here
There are
in
several, Mr.
opposition to this case? Please raise your hand. Okay. Continue.
Well, I don't know if before we decide if we're going to defer or not, if we want to hear from them.
Why does that change your mind?
Well, I mean, they're all here. It seems like the only person not here is the appellant, so
But we can
I
make a
would be
decision-
curious to know if they've met. Or,
But we can make a decision based
Sure.
on, I mean, we respect the people's time, but, you know, we know that they're here, and we could either defer it or just vote it down, whether we hear from them or not. So does anyone have any suggestions?
Well, I tend to say my leaning would be to defer it. I remember this case. I'm a little surprised we don't have the appellant. I would maybe want to just ask the opposition about deferring it 1 or 2 meetings. That's sort of my thought.
Opposition, please come forward.
And Mr. Chairman, I would note with the council member present, there may be some prudence in considering
Actually,
his
yes.
input.
Mr. Syracuse, let's hear from,
councilman.
please come forward too. Well, we're going to hear from, yes, you're here, so have a seat. Please state your name and your address, and what do you think about a deferral?
My name is Elizabeth Sykes. I'm an attorney for Virginia Strong, who is to the right at 2212 Mecca Drive. So her property is adjacent to Mr. Smith's property, and we are not in favor of a deferral. She has contacted me, and I'm representing her, so she's incurring costs by being here today. In addition, we have contacted Jeff Syracuse and expressed our opposition to this, and he indicated that there are many others that have expressed opposition, and it is not correct that the neighbors have been in communication with Mr. Smith. They have been in communication with each other, and they are opposed to it.
So no, Mr. Smith has not talked to anyone that you know of that lives nearby? Please identify yourself, ma'am, and your address.
Not to my knowledge.
What's your name, ma'am?
I'm sorry, Virginia Strong. I live on the right side of them.
Okay, thank you. And what do you have to say?
My name is Russell Hobbs. I'm the president of the Neighborhood Association, and we did have a meeting with our neighbors. And because of the mass amount of garage that he wants to build on top of his garage, it would be a bigger structure than his home.
well,
It is already bigger
okay,
than
one
his
second.
home.
We don't really want to adjudicate the issue. We just really want to know about how you feel about a deferral, and have you met with?
Would you be in favor of deferral?
I would say no.
Okay. Let's hear from Mr. Syracuse. Councilman Syracuse, come forward. You represent this area.
Thank you, folks.
You might have even knocked on doors on this street, I'm sure, to get elected.
Thank you, Mr. Chair. Commissioners, appreciate your service very much. Jeff Syracuse, 15th District. Yeah, I would ask that you not defer. I have the feeling, I did speak to Jeff Smith, the son of the applicant, and my feeling is that he's not here. He's kind of given up on this. He knew it was kind of a long shot, and you know, I appreciate you deferring last time so that the neighbors could meet, which they did. There's been a lot of conversation on their Facebook page, and I believe there is a definitive response from neighbors about what they want or don't want. So I would ask that you not defer. Thank you.
Okay. So let's close the public hearing. Or close whatever that was. So what do we think? Councilman says don't defer. The people, including the lawyer who was duly hired to come here. So.
Is a motion required that
Yes.
we not, okay, I move that.
Well, before you have a motion is not required not to defer, but if we reject this case and turn it down, that requires a motion.
Oh, okay.
So our options are to defer, and that would require a motion, or to just deny the case because the person's not here and they had notice and everything else.
Well, I'll move that we deny the request.
Okay? Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. Case denied. Thank you all for being here.
Mr. Chairman, case number 2017-407 is the next item on our docket. Sterling Abernathy is the appellant and owner of the property located at 915 Oneida Avenue. Forgive the typo that incorrectly marked it as 95 Oneida. It's 915 Oneida. The request is an item A appeal involving the denial of a short-term rental permit. The location shown here on the aerial map. Is there opposition present on case number 407? Any opposition? Seeing none, the appellant will have 5 minutes to make the desired presentation to the board. Please introduce yourselves by name and address.
I'm Sterling Abernathy. I live at 915 Oneida Avenue. Thank you for your time today. I'm here to make an appeal of the zoning administrator's denial of my owner-occupied short-term rental permit. Some background on my circumstances. I'm a touring musician, and I've rented my home out through Airbnb on occasion. Unaware of the laws and my need for a permit, I received a letter from the city postmarked October 27th and stating I was operating outside the permit laws and ordered to cease and desist all Airbnb activity. I was on tour at the time that this letter was sent. Upon returning home and reading the letter, I immediately deactivated my Airbnb account and canceled all guest bookings as stated to do so in the letter. As you are aware, there's a 2-week time period in which the letter recipient is to comply. I did everything the letter instructed me to do. However, I was not able to read the letter until November 14th, as I was on tour October 25th through November 14th. When I visited Codes Department to obtain a permit, I was informed that I had not complied with the 2-week time period and I would not be granted the permit unless I appealed my case before you. And so I'm here today to ask for your grace in this matter. It is my intention to operate in compliance with our city laws, and I ask that you would allow me to receive the owner-occupied short-term rental permit. Thank you very much for your time and consideration.
Okay, so how often are you on the road? What kind of touring do you do?
It's like maybe 2 or 3 weeks every 3 months or so.
Okay. And so, but during this window of time, you were physically not here in Nashville?
No, I was out on the West Coast.
Okay. So who is this?
My father.
Okay.
I'm Steve Abernathy.
What's your address?
1316, I'm sorry, 13031 South, 13031 South 143rd East Avenue, Broken Arrow, Oklahoma.
So why do you, how did you hear about Airbnb and how did all this come about?
Well, I had some friends that were doing it, and when I travel on the road, I stay in Airbnbs often with different bands. And when I was gone, my girlfriend was here to help me, and she said, "Oh yeah, I'll be glad to, manage your place while you're gone if you Airbnb it." So it's not that I do it all the time, just here and there. And that's how I heard about Airbnb, was through friends and internet.
Questions of the applicant? Anything else to add?
No, sir.
Okay, thank you. We're going to close, no one in opposition here? Nope. Going to close the public hearing. Discussion? Oh, wait a minute. Yes, Mr. Osborne, or tell us about this. Is it host? Is it?
Yes, this is one that Host Compliance did identify for us, so we did send a letter about it.
And were there any other complaints besides operating without a permit? And
not that I'm aware of.
And so you sent a letter or stop order to the house when?
It was just a letter, and it was sent on October 27th.
And have there been any evidence of any other postings, rentals, anything?
No, sir.
Okay. Any questions for Mr. Osborne? Thank you. Discussion.
Today. So I think this is a situation where he's, as I understood the evidence, he has complied with the stop work order, and he is here before us today asking for a renewal of the rental permit. So as with many cases we've heard, he falls within our discretionary ability to set a punishment, and I would find that the zoning administrator, well, I would be inclined to allow him to apply, if y'all want to discuss that.
Do you want, is that a motion?
I will make that a motion that the zoning administrator did not err and that he should be eligible to apply for his short-term rental permit.
Okay, motion's been made. Is there a second?
Second.
Motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Passes unanimously. What we've ruled today is you are eligible to apply. That means we do not give out permits, but you can go talk to the codes person, and if you comply with all the laws about short-term rentals, they will give you a permit, not us. So, but you're eligible. And
Thank
do
you.
not rent and do not post until you actually have a permit in hand. Okay?
Yes, sir.
Thank you. John Michael.
Mr. Chairman, the next case is 2017-413. Sharif Tadros, the appellant, and Ambrosia Catering Tennessee Corporation, the owner of the property located at 2211B Gladstone Avenue, shown on the zoning map here, has filed a request for a variance from sidewalk requirements in the IWD zoning district. That's
Case, please come forward.
Industrial Warehouse District, for the construction of a new kitchen for the catering business. This has come to the board as a traditional sidewalk requirement. You already have the planning department's recommendation. You may recall that Mr. Tadros was here with this case at our last BZA meeting. There was more time given to consider the options with his partners on this matter, and thus the board comes back today with an opportunity to take action. The site plan shown here gives a proposed layout from my recent site visit, the face of the property in the lower right-hand corner, the view across the street in the upper left, and the view up and down Gladstone as it currently exists, where you'll note the absence of sidewalks. Mr. Tadros, if you'll introduce yourself by name and address, and then address the board.
Yeah, my name is Sharif Tadros. I'm living the 840 Cranberry Lane, Nonsville, Tennessee 37135. We come a second time we show you all the road around me doesn't have a sidewalk, and we have all the picture with me here. I take it. If you want, I can show you here.
Yes, and I think as we said in the last meeting, we're not debating whether there are no sidewalks or not. There's a sidewalk ordinance that was duly passed by the Metro Council last year, which basically says if you build a new house or do major renovations, that you either A, have to build a sidewalk, B, pay into the sidewalk fund. So what are you asking us for today?
We're asking you can take the decision about the sidewalk.
It's what?
You take the decision about the sidewalk, doesn't come for it today.
That's why we're here. Okay. So why are you asking not to build a sidewalk or pay into the fund?
We don't have anybody beside me to have a sidewalk, because this behind. If you go to the back in my house, you see that all the properties look like the commercial properties, not the house. All around this side, you don't have a sidewalk.
Okay, we understand that. So there's two options under the new sidewalk ordinance. A, either build a sidewalk. B, either pay into the fund and not build a sidewalk. So why can't you do either one of those?
We can take a show. I can build it, that's fine, but we don't see anybody have a sidewalk. That's what I'm coming today for.
Our planning commission has identified this area as an area where light rail will be built hopefully in the future, and that this is a more pedestrian, and their attitude is you have to start somewhere. There might not be any sidewalks around, but if everyone didn't have to build sidewalks, then we never get sidewalks. So we're a city that wants to build a bunch of sidewalks now, and that's why we passed the law unanimously in the Metro Council.
Okay, that's fine. I can build it. It's okay.
Questions? So you're saying you're going to build it?
Yeah, I can build it.
Okay. John Michael.
If the appellant has decided to build the sidewalks, then there is a basis to withdraw the appeal and continue with his permitting process.
Okay. So you're going to withdraw the case and just build the sidewalks?
Okay.
Okay, very good.
Thank you.
John Michael.
The next case on the docket is 2017-424. David Bishop is the appellant and owner of the property located at 1616 Glen Ridge Drive, shown here on the zoning map and in the aerial photo. This is another short-term rental case, an item A appeal based on the denial of the short-term rental permit. Is there anyone here in opposition to case number 424? There is. Mr. Bishop, if you'll come forward, address the board after introducing yourself by name and address. You'll have 10 minutes to make the desired presentation. If you wish to save some amount of time for rebuttal, please do so out of this original 10 minutes, and then we'll hear from the opposition.
Please begin.
Good afternoon. My name is Michael Wren from the law firm Freeman and Fuson, 2126 21st Avenue South. I'm here on behalf of David and Sandy Bishop, who are at 1616 Glen Ridge Drive. This is in regards to a Type 1 short-term rental permit. Mr. and Mrs. Bishop began putting a room in their house up for rent on VRBO and Airbnb in September of 2017. On November 20th of 2017, they received a letter from Codes that they were operating without a permit. The next day, on November 21st, they called and pulled down their listings on Airbnb and VRBO. And to clarify, the Airbnb one was pulled down immediately. Apparently, there were issues with the VRBO one. My client received a call on December 10th about someone interested in renting that property. He was alerted that the VRBO was still up, so he had called VRBO, and that one was taken down for good on December 10th. But he had called on November 21st for both of them to be taken down. Mr. and Mrs. Bishop have lived in the house at 1616 Glen Ridge since 2001. They are not seeking to rent out the entire property. It is a 4-bedroom house. At most, they would rent out 2, but typically I think their intent is to rent out 1 bedroom with them present at all times. They're here today asking that they be allowed to apply for a permit for a Type 1 owner-occupied short-term rental permit.
Were there any rentals after November 20th?
No, there were no rentals after November 20th, 2017.
Were there any rentals ever?
Yes.
Before that.
Okay.
Do they have 2 properties?
Yes, ma'am. One in Kentucky.
Okay, so you don't own 1414 Garland and 1416 Garland?
No.
Okay.
Any questions for the applicant? I'll ask. Oh, you've been doing this for how long have you been doing this, renting out?
Here in Nashville since September. I did it in Kentucky in 2012, but we didn't require a permit up there.
So when did you learn that Nashville had laws that related to this?
Well, I don't. We don't take, we don't have Comcast or AT&T, and we don't
No, I
take.
said laws that you need a permit to rent out.
When I got a letter from Mr. Osborne, I think it was on November 22nd, the Monday or Tuesday before Thanksgiving.
So that was the first that you knew of this law?
Correct.
Even after renting it? How many times did you rent out the Nashville property? Because we have
probably a dozen times.
So these other reviews some of these are Kentucky, I guess,
Correct.
that we have. It's 307, it says. That's a lot.
Yeah,
But Nashville's about 12.
correct.
That's in Kentucky, I think. Is Gartland in Kentucky?
No, it's Dinsmore, not Dinsmore, 124 Division Street is the avenue, or the house resides in Kentucky. It's in Grand Rivers.
Okay.
Nope. We don't own that one.
So what are you asking us to do and why?
Well, I'm asking for forgiveness for not having a permit, not realizing that I needed one, and allowing me to put an application in for one.
Questions for the applicant? 424.
We have erroneous information in this file, obviously, because it talks about Gartland, and he doesn't own Gartland.
What council district are you in?
35.
So that would be in Bellevue?
Yes, ma'am.
Okay, let's look to see if we're on the same page. Because we're looking at something that says Gartland right now.
Yeah, that's not ours.
Yeah, what is your short-term rental address?
1616 Glen Ridge.
Okay, that's what's on the agenda.
Correct. Garland is not ours. I don't know where you got that.
Yeah, 'cause
Are you in Riverside subdivision?
Yes, ma'am.
Okay.
Well, some of the letters of support and opposition mention the correct address, but other stuff doesn't.
Are you in an area that has an HOA?
Yes, sir.
That's correct.
So some of the letters that we have appear to be your case, yes. Maybe it's the reviews that aren't.
And Mr. Chairman, by way of clarification, the packet that you have may include information about a different property, as you noted, one with a Gartland address. However, the appeal was filed for Mr. Bishop's property. He's properly before you today on his case, of course. And you have other information in the file that speaks specifically to the 1616 property that's at issue over in Council District number 35.
Yeah, I believe every single letter we have, bless you, is related to 1616 Glen Ridge.
And that's what I was going to note. For the benefit of the board, for the appellant, and anyone else interested, and there are a number of interested parties in this case, we'd be happy to recompile the file with the up-to-date information if the board wishes. We'll leave that to your discretion, of course.
I think the only thing that was missing from we have all the letters in support and opposition. What else would we be missing in the file outside of pictures?
Information from the codes enforcement staff.
We'll ask Mr. Osborne that. Is there any picture? Show us the pictures of the house again. Or do we? Mr. Osborne, come up here. How'd you hear about this property, and were there any violations besides not having a permit?
That was the complaint, was that they did not have a permit.
Okay.
And looked and found it on VRBO, and the Airbnb listing came down immediately. So,
Was this found by host?
no, it was found by me.
Oh, good old-fashioned work. See, we've got host and we've got Mr. Osborne here, so.
So I did send them a letter and did have some correspondence with Mr. Bishop. It did take a while for the HomeAway or VRBO advertisement to come down, but they didn't operate in the meantime, to my knowledge.
You didn't see any reviews or anything like that during that window?
The last person that stayed there was in October, to my knowledge.
Okay. Questions for Mr. Osborne? Thanks again. Okay, so you've been renting out either one or two rooms and you didn't know. Counselor, help us out here. How did your client not know? We've had rules for a couple of years now. There've been articles in the paper.
Sure.
If Metro Council people who are responsible for this law, they'd be here, they'd be shocked that people still don't know.
I completely understand, especially it's been a hot topic, as you guys are fully aware of, and people in my position as well. In speaking with the bishops, my understanding, they didn't even have a cable or satellite provider until September of last year.
Well, what does that have to do with this?
As far as the news and staying. My understanding is they're quiet people, keep to themselves, a lot of reading. They've lived at that address for 17 years, since 2001. Don't really know their neighbors or other people in that neighborhood. They're pretty quiet and keep to themselves. So while we in our positions find it hard to believe that people aren't aware of these rules and regulations, unfortunately, every time that you guys have a meeting, we see it come up. And I do know that Mr. and Mrs. Bishop, as soon as they found out and received that letter from Metro Codes, took the listings down, had conversations with Mr. Osborne, and have done everything that they can to make sure that they stay in compliance.
Okay. Any questions for them before we hear from the opposition? Anything else to add? You'll have time for rebuttal, but we're going to hear from the opposition.
Sure, just save time for rebuttal.
Okay, thank you.
Thank you.
Opposition, please come forward, state your name and address for the record.
My name is David Warren. I'm representing the Homeowners Association. I live at 505 Glen Lee Court. I'm also a resident of Riverside. Thank you for allowing our input.
So before you get started, just wanted to kind of let you know, you all have rules related to homeowners association. We are not the ones that enforced it. That's between you and your people. We just look at whether someone operated without a permit, so we don't.
But you're going to award, you're going to make a decision whether he can apply for another permit.
Yes, we are. So
Okay.
we want to hear from you about what you think in opposition.
Well, as an HOA, we have an obligation to enforce our covenants, and as a resident, you have an obligation to abide by your covenants. We have a covenant, and our covenants that pertain are our houses are to be exclusively used for private single-family resident purposes and not otherwise. And secondly, that no house or structure shall be used for any business or commercial purpose. And we try to enforce these things fairly. We have had 2 Airbnbs that we've identified and reported. This is that's enough on that. To this appellant, specifically, Mr. Bishop has, according to neighbors, instructed his customers to park in Eads Court, which is the cul-de-sac that you can see about half of. These folks have complained to him. He has told them that they can't complain that the road is a public road. We also have covenants that require residents to park in the driveways or in the garages. We understand that the conflict between a public road and our covenants can create some problems. But as a resident, you make a covenant with the neighborhood that you should do what it says. I haven't pursued those legally.
So why are you in opposition to this?
Because it is against our covenants.
Okay. Yes, but as I said, we don't enforce your covenants. You do.
I know we do. I'm telling you, though, that this permit is against our covenants, and that's why I'm here.
Okay. But what we want to know is, based on this use, how is this disruptive to you and your owners that live out there? Why are you against this?
The owners directly affected are the ones on Eads Court, who, it's a very small cul-de-sac, and when you park in the street, as you can see in the picture, there's not a lot of room to turn around. I don't know who those cars belong to.
Okay.
But they complain. The other one, we created quite a bit of disruption in another cul-de-sac, and the neighbors were vehemently complaining. And because, I don't know how to reconcile the fact that we have covenants, but the covenants are I believe, from a planned unit development, are zoning, and they require the developer to create this set of covenants, and we have since amended it. So I would hope that the zoning commission would support the covenants.
Do you have anything else to add, sir? Do you have? Okay.
No.
Questions for the opposition? Thank you for being here. Let's hear from the applicant again.
Thank you, Mr. Chair. And I'll be brief in response. As you pointed out, the enforcement of any covenants is up to the HOA itself. I do have a copy of the covenants for Riverside HOA, and I just want to bring one section to the board's attention. Section 17 talks about use and occupancy restrictions, and it states for the property may be used for purposes no part of the property may be used for purposes other than housing and the related common purposes for which the property was designed and as allowed by municipal zoning laws. This area is allowed and zoned to be used for type 1 short-term rental permits. So it is being used for the proper purpose if this board does grant my clients the opportunity to apply for a short-term rental permit. The other issue is my client would also like to be allowed to apply for a short-term rental permit because these bylaws and covenants for HOAs can change. You can get enough members to form a quorum and change any of these bylaws. So if it is against the HOA covenants, he would still like the opportunity.
Are those the most recent HOA laws? Okay.
Yes.
Well, Counselor, you know how this works. We now have rules related to that. John Michael, tell us the rules related to applying and what it says about HOAs.
During the application process for a short-term rental permit, applicants are required to give a sworn statement that their application for and potential acquisition of a short-term rental permit does not violate any conditions or terms or covenants of a homeowner's agreement or other similar bodies' agreements. Obviously, if that turns out to be a fraudulent declaration, that's a basis for immediate revocation of the permit or cancellation of the permit. However, sometimes permits are issued without us knowing that there were, in fact, HOAs, and very occasionally without the homeowner even realizing that there are HOA guidelines. Yes, I have an HOA. Yes, there are guidelines, but they really just didn't know that something about it violated the terms of those guidelines. So we encourage concerned neighbors to share with us a full copy of those HOA guidelines. And although we in the Codes Department and every other agency of the Metropolitan Government want no part of refereeing HOA disputes, the reality is, in this unique circumstance, we need to know what the applicable language is with regard to the uses of the subject properties. So from time to time, I do sit down and read HOA agreements and determine whether or not they are a violation and whether or not a permit has to be canceled, revoked, or otherwise handled.
Okay. Any questions for the applicant? Anything else to add? Okay, we're going to close the public hearing. Discussion.
So, the question that we're actually being asked is, like with so many of these, is are they allowed to reapply? And
because they operated without a permit.
Because of whatever the violation was.
That's what's in front of us today.
So, like with many things that come before us, there may be other code issues, and we decide, but that does not trump any other requirements. They still have to follow building codes and everything else. So I just want that.
So if we were to allow them to apply for a permit now or in the future, they still have to comply with all the things that John Michael had to say.
We're not giving anybody, and we're not allowed, or.
And as John Michael also said, we are not here to enforce someone's HOA rules, not this body. So, discussion.
All right, I don't see this case significantly different than the case we handled just a minute ago, and I would find, well, based upon the evidence that we've heard, I would, if agreeable, go ahead and make a motion that the zoning administrator did not err, but the applicant should be allowed to reapply for his permit.
When?
I didn't hear the date of the.
Do we know the date of the?
November 20th, I believe, was the letter.
The letter. Sure.
So yes.
This is on my application.
December.
11th.
And you like to do those 90 days?
At least 2 months.
Okay.
I would say.
I would move that he can reapply in 90 days from December 11th, 2017.
Okay, motion's been made. Is there a second?
Second.
Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. You will be able to apply for a permit 90 days after what, December 11th. and then comply with all the rules. So, thank you. John Michael.
Mr. Chairman, the next case to be presented to the board is 2017-425. Jason Oggs is the appellant and owner of the three parcels located at 2312, 2314, and 2316 Whites Creek Pike. They are the three long, thin parcels shown here on the zoning map, R6 zoning district. The project would involve the construction of three duplexes, or duplexes. The variance request is for a variance from the sidewalk
Will the applicant
requirements.
come forward now?
The aerial map here gives you a sense of the layout of the undeveloped lot along Whites Creek Pike. The site plan, or rather the survey shown here gives you some sense of the easements and other constraints associated with the lot as well. From my recent site visit, the upper left-hand corner shoots down into the interior of the lot from the center parcel, and then the lower right-hand corner shows you the topography at issue with the drop-off from the street down to the main part of the parcel. The view across the street is on the upper left-hand corner, and the views up and down Whites Creek Pike on the lower portion of this slide. Are there people here in opposition to case number 425? There are. Therefore, the appellant will have 10 minutes to make the desired presentation to the board. After that, we'll hear from the opposition, and the appellant would afterwards have the opportunity to make rebuttal comments if you wish. Please introduce yourself by name and address.
My name is Robert Pelosi. I'm a civil engineer with OHM Advisors, 209 10th Avenue South. I'm representing Mr. Oggs and his partner, Mr. Brown. Mr. Oggs was here at the onset of the meeting, but had to step out for another appointment.
Okay, get us started. What are you here for? What are you asking for?
So the applicants are actually proposing to construct single-family homes instead, rather than duplexes as stated in the case. They're looking at 5, maybe 6 single-family homes on the 3 separate parcels. The Whites Creek, this section of Whites Creek Pike is identified in the major, the adopted collector's plan as requiring sidewalk. However, due to the topography of the land, the steep slope, the sidewalks would be extremely challenging to construct. And we've identified about 5 site constraints that impact the ability to construct sidewalks.
This appears to be a very narrow lot. I don't think that paying into the fund would be very pricey. Why can't you just pay into the fund?
Based on the prices that were presented to the owners from Public Works Department, it was going to be about $30,000 in lieu of fee.
Okay.
That would, for such a minor development of 5 or 6 single-family homes, that's a
5
disproportionate.
or 6 single-family homes is a minor development?
On 3 separate parcels?
We have a sidewalk bill. The sidewalk bill says you either build a sidewalk or pay into the fund. Now, you could come to the BZA and argue why you shouldn't, but guess what? Every other developer in town is faced with this ordinance, and they have to either build a sidewalk or pay into the fund. So why should you do neither?
Well, the case for why not to build it, there are numerous factors.
Okay, you talked about that, topography, but why shouldn't you pay in the fund? Everyone else has this option whether to build. They know that these costs could be passed along or not, and that's what our Metro Council passed this law unanimously.
But paying into the fund is something that gets passed on to the homeowner and exacerbates the problem of increasing home prices.
Well, we had many time to debate that when the Metro Council passed a bill, but that's what it is. We're not the legislative body here.
And we have met with the District 2 councilman, Mr. Councilman Hastings, and he was supportive of the variance.
Okay.
I didn't see anything in our file, and I appreciate you saying that.
Yes.
Okay, I just want to get to it.
Maybe we've gotten 2 of them.
the letter of the councilperson really talks about those topography issues that you mentioned, TVA, easements, et cetera. But as the council passed, there's this sidewalk fund. So,
I mean, your council person is in support of the variance, but he's not suggesting that you shouldn't have to pay into the fund. I mean, the variance would, we can allow you to not build the sidewalk and pay in, and I don't see that your council person is saying you shouldn't have to pay.
That, from our meeting that we had with him last week, that was not the understanding we had.
so the letter is dated yesterday, January 31st, 2018, and there's nothing in the letter saying, I don't want them to pay into the fund. And we've had a council person at our last meeting from this area, or representing this area now, basically telling us not to have someone pay in the fund. And this is a very lengthy letter for, usually it's just a paragraph or a few sentences. It's almost 2 pages, but nothing in here about not paying into the fund. So I'll ask again, why aren't you paying into the fund?
Yes, my name is James Brown. I'm co-owner of the properties here. I think our issue here, we had originally we were going to build 16 units here, but because of the topography here, it was going to cause various challenges, and so we were wanting to contribute to the growth in the area. But with this fee here, it is going to make it challenging to even move forward with developing because, as you can see, there's a drainage that runs through the middle there, and it's going to move us down from 6 to possibly 5 homes. So if we do have to pay into the fee, we might not be able to develop it at all.
Well, have you been a developer here in Nashville before? You aware of this law?
Yes.
Okay, so you bought this property being aware of the law?
Yes.
Yeah, I mean, we're not the legislative body. It passed unanimously. And we have a recommendation from planning to basically disapprove this, but because you have the option of paying into the fund. We're going to hear from the opposition, but do you have anything else to add before we hear from the opposition? Okay, let's hear from the opposition. You'll have 8 minutes for 16 seconds for rebuttal. Opposition, please come forward. Please state your name, your address, and why you're in opposition. Bottom button. Yep.
My name's Winnie Forrester. I live at 2611 Shreve Lane. And I have some...
Give that to us. We'll look at it. And as you're probably aware, the reason that they're here today is not because how many houses they're building or single family or duplex. They're here just to get out of paying or building sidewalks. So that's what we want to hear from you, why you're in opposition of them not building a sidewalk or not paying into the fund.
Right. So if you could indulge me just for a minute, I'd like to say a couple of things.
Are they related to the sidewalk or not building a sidewalk?
Well, they're related to as why we're here.
Well, I told you the reason why we're here today. We're here to decide whether he should pay into the fund or not, or have to build a sidewalk or not.
Okay.
And if you're in opposition, we want you to speak on one of those 2 issues.
Okay, I will. So I'm president of the Haynes Heights Neighborhood Association. First of all, we are in opposition to granting any kind of exception to the sidewalk requirements. These properties are located in an urban services district and not in the suburbs. Whites Creek Pike is an arterial boulevard and it's classified as a major collector street. As a reference point, the southern border of Haynes Heights neighborhood is less than 150 feet away from Mr. Ogg's property. And before the land use update that was approved on January 11th, which substantially changed the land use policy in our area, this property was T3 Suburban Neighborhood Evolving, and now it's T4 Urban Mixed-Use Neighborhood, so it's a significant difference. So our understanding was, as he stated, that he intends to build 6 residences on 1.32 acres with the current R6 zoning, and he could build more. So his property is located approximately 500 feet away from the nearest sidewalk. That sidewalk continues south to Trinity Lane. And I gave you guys a Google Maps that shows the layout of the property as on the yellow highlighted lines are the existing sidewalks on Whites Creek Pike. And they continue on to Trinity Lane, which is right there at the corner where Haynes Middle is. So there's significant foot traffic on Whites Creek Pike. And where this particular property is located, pedestrians are forced to walk on the shoulder of the road. And so we feel that any reasonable person would agree that sidewalks are a critical need in this area, and not to mention that our area is going to be in line to be developed significantly. And so properties on either side of his properties are likely going to have sidewalks, and eventually, hopefully sooner than later, we'll actually have a sidewalk on Whites Creek Pike. So importantly, though, we want to see a sidewalk. An alternative for him contributing to the In Lieu Fund is something we would accept, of course, but we would really like to see a sidewalk. So I would like to encourage Mr. Oggs and his partner, Mr. Brown, to work with the community and the planning department to design an alternative sidewalk as the planning department has recommended already. This would go a long ways to promoting goodwill with our community and our newly formed Haynes Trinity Coalition of Neighborhoods and Nonprofits and resident associations. So, we do appreciate him coming to our neighborhood to build. I looked at some of his other homes that he's already built, and they actually look good, at least from pictures. I've not actually seen one. But we want to work with developers, but we want our sidewalks too. And so if he's going to build this and build more in our area, we would love to be able to come to some sort of compromise.
Why are you here, ma'am? And state your name and address.
My name is Joyce George. I live at 711 Work Drive, which is in the Haynes Manor subdivision. I am a member of the Haynes Manor Executive Board, and I'm here on their behalf. I have lived in the area for 50 years. We desperately need sidewalks. Within less than a block from Mr. Oggs' property, there is a convenience store, a church, a school, a strip mall, a bus stop. And people do walk to these various entities and destinations. I am here in opposition to him not either paying into one or the other, paying into the fund or building the sidewalks. Also, I feel that if he does not do one or the other, it is setting a precedent for other developers who will come to our area, which I'm sure will happen in the near future, and they will come to this board and say, you let him get away with it, why can't I do it? So I'm asking you, I'm beseeching you to deny his request. Thank you.
Questions for the opposition? Okay. Anything else to add? Thank you. We're going to hear from the applicant again. Please come forward. Okay, rebuttal.
One thing I'll add is that paying into the fund, my understanding is that does not guarantee that sidewalks will ever be constructed on Whites Creek Pike or even within this council district. But our position and what we would ask this board to consider is, given the separation of understandings between the councilman's opinion on the in lieu of fee, to defer until the next.
Board members, what do you think of this?
I don't wish to defer. I don't think we should defer it.
I don't agree.
Okay.
I agree with Christine.
Doesn't seem like the majority of the board wants to defer, so continue.
So back to paying into the fee, again, does not guarantee sidewalks in the district. And constructing the sidewalks.
It guarantees sidewalks in whatever district that they have the sidewalk fund in. And did you see this map, this Google map that the opposition gave out showing sidewalks nearby? Well, you know your property, right?
Yes.
So right down the road, there's sidewalks on both sides, not very far from your property?
500 feet to the south, I believe, is the sidewalk, and about 0.8 of a mile to the north.
So we get these kind of requests all the time, and somebody shows us a map often, and there's not a sidewalk to be seen anywhere. But although it's, as you said, more than half a mile away, it's down the street.
I have a question, too. Is it likely that the families that move into these homes that are being built will have children that attend Haynes Middle School that's right up the road from there?
It is certainly a possibility.
Then wouldn't that be a case for actually having sidewalks on that property?
If those sidewalks connected to Haynes Middle School, yes.
Okay.
Yes.
So what else do you have to add in rebuttal?
Anything, James?
Okay. Close the public hearing.
So from what I understand, our charges, we can't necessarily make them build a sidewalk because they have the option to pay into the in lieu. That's correct, right?
But if they want to build it, they have to comply with the ordinance, which either says build a sidewalk or pay into the in lieu, or they don't get a permit.
But we can't force them to build a sidewalk.
Well, technically,
The question before the board is, may we please refrain from either building or paying? You get a yes, no on the can I get out of everything. Then if the board, for example, said yes, then they get a pass, don't have to build, don't have to pay. If the board says no, we deny that appeal, they go back and still have the option to pay or construct the sidewalk.
So John Michael, I want you to, since this is not the only sidewalk case today, give us the 30-second version of why this sidewalk bill is here and what does it really mean?
Can I first have a piggyback question? Planning says an alternative sidewalk could be constructed on the site. Can you address whether or not we can allow that without them coming back before us? Can we allow them to work with planning and public works on that?
The last part of that question is the pertinent part, Ms. Karpenick, and that is yes, if the board were to choose to defer the case 1 meeting, 2 meetings, whatever you see fit, thus allowing the appellant to go back and work with the staff at the planning department, they may in fact arrive at an alternative sidewalk design that, number one, the planning department would recommend to this board, and number two, was agreeable for the appellants in this case. That is an option before the board to defer with that specific mindset of allowing them to go back and have that conversation.
Could we deny and then they can work with the planning and come back with a different variance?
If you deny the case, then it's under our board rules, it's a 6-month wait to come back, if they needed to come back to the Board of Zoning Appeals, unless it was a completely different or a substantially different case. Again, using the language from our board rules of procedure.
I also will say I don't think you have to defer in order for them to work with planning. I think if you wanted to grant a variance with the condition that they submit an alternative sidewalk design, you could say, you could grant the variance conditional upon their working with planning commission and coming to an agreement, and then the permit.
And if they don't come up with that, they still have the option of the in lieu fund. So John Michael, tell us how we got here.
One important note at the outset, Mr. Chairman, is the, although implied, not overtly stated reference to the pedestrian benefit zones. It is correct that sidewalk fund dollars don't necessarily go to the project in question. It is also correct that they don't go to the council district in question necessarily. Pedestrian benefit zones have nothing to do with the shape of the council districts, which change with the census every however many years that is. Instead, the pedestrian benefit zones are defined as being in the same area so that a project here on Whites Creek Pike doesn't pay into the sidewalk fund only to see those dollars used for development in the Hickory Hollow area. And similarly, a project in the Hickory Hollow area doesn't contribute to the sidewalk fund only to see those dollars spent for a sidewalk out in Bellevue. The idea is you stay within a reasonable proximity to the project in question, predefined borders that are codified and followed closely by both the planning department under their sidewalk priority index and major and collector street plan, as well as our public works department, who of course inspects the construction of the sidewalks once they are in fact constructed. So to Mr. Chairman, to your question about the sidewalk ordinance, as you know, the current version from Bill 2016-493 took effect on July the 1st. You have seen now over 100 sidewalk variance cases that have come to you since the implementation of that law. You're getting good at it. The idea is to create a certain literal ground level basis for improving transit in Metro Nashville. All studies indicate that an improved sidewalk network is a part of improving the overall transit experience in any municipality, certainly one in the size of Nashville. That's why the council, as you noted, Mr. Chairman, put that law in effect with a unanimous vote back in the spring, and why our staff has continued to try to apply it as consistently and accurately as possible since the July 1 effective date.
Discussion.
Well, I feel we should deny the request and give them the opportunity to work with planning and public works on the alternative sidewalk design, or they can choose to pay into the in lieu fund.
Okay. Motion has been made. Is there a second?
Second.
Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Passes unanimously.
Mr. Chairman, the next case is 2017-426. This is an item A appeal involving a short-term rental permit denial. The appellant is Christy Weiser, both the appellant and owner of the property at 2235 Stratford Avenue, shown here on the zoning map and here on the aerial photograph. Is there any opposition to case number 426? Is there an appellant for case number 426? Seeing none, Mr. Chairman.
Okay, here we go again. Board, do we want to defer a meeting or just reject it? Short-term rental. Knowing that...
And I'll double check, Mr. Chairman, is Christine Weiser in the audience? Please come forward. We are about to deny your case. Please introduce yourself by name and address. Make the desired presentation to the board.
My name is Christy Weiser.
Please press the button on the bottom. Very good.
My name is Christy Weiser. I live at 2235 Stratford Avenue.
And why are you here, and what are you asking for?
I'm here to get an appeal on getting a short-term type 1 permit.
It stays on, so you don't have to touch it.
Oh, sorry.
And how long have you been renting your house for short-term uses?
For about 2.5 years.
And so when did you did not know that we had laws related to short-term rental?
Yes and no. At first, it was an awareness, and then I started the process of getting a permit. I ran into a couple of dead ends with various aspects of it. Did get a little bit discouraged, tried to figure out if I wanted to continue to rent out my house. Also, probably just let life get the best of me and drug my feet on it. So,
why were you discouraged, and why didn't you complete this application process? You said you started it.
I did.
When did you start it?
I started it, I guess, right around the time that it came into place.
And so why didn't it get completed and finished and duly turned into codes?
I was confused by some of the requirements. I didn't completely understand various aspects of with the smoke detectors, if they had to be hardwired, if they could be battery operated. With the insurance aspect, I actually did go to my agent and tried to get my policy increased because he is a longtime family friend. He was very discouraging because he doesn't like the concept of Airbnb. So I even...
But doesn't he sell insurance?
Yeah, he does, but...
Okay, so how are you in front of us today? I imagine you got a letter from Mr. Osborne.
I did get that letter. I was also out of town, I'm guessing, when it came into my mailbox. So whenever I did get back into town and checked my mail, opened it, instantly went into my Airbnb account and closed it, discontinued it. So there were no upcoming renters, didn't have to cancel with anyone. It hasn't been live since. I've also gone to codes and tried to work with them. I've gone to collections, gave them a very large check for some taxes that I did not pay. And then I also emailed my council person, Anthony Davis, to let him know that I was filing this appeal.
Okay. Questions of the applicant? Is there opposition for this? No. Oh, is there? No. Okay. So you knew that there were laws, and then you just, as you said, couldn't figure it out, was confused. You know, the authors of this legislation wrote laws so people would either not rent or get a permit. And even if you knew there were laws and you decided to rent anyway without a permit, did you think that this would just happen indefinitely?
People make mistakes, obviously, we all know that. I definitely had all intentions of getting a permit. It's not an easy process. If you work a 9-to-5 like I do, it's kind of hard to take off work and also get into the actual codes office. There's various reasons why I did drag my feet. I apologize for that. I know that that was wrong. I've done many things to try to make it right.
Okay. Questions for the applicant? Anything else to add?
No, just thank you for your time.
Okay, thank you. We're going to close the public hearing. Discussion.
Mr. Chairman, I believe this is one of Mr. Osborne's cases.
Mr. Osborne, how did I forget that? Come forward. Tell us how you found out about this. Any other non-permitted violations?
Host Compliance notified us about this one, so we sent out a letter on October 27th. Sometime between November 13th and the 17th, it was taken offline. And to my knowledge, there hasn't been any more rentals since then.
Okay. Any questions for Mr. Osborne? Thank you. Discussion.
Well, this is a case where the owner knew about the permit requirements and failed to get the permit, and only got the permit when prompted to get the permit. So to me, that's more like a 6 to 8 month penalty.
I think it was 1 year myself.
How about 8 months? 9 months?
Okay, 9 months.
Okay, then I will move that the zoning administrator didn't err and the applicant be able to apply for the permit 9 months from December 11th, 2017. I don't know what 9 months is. I'm sure John
Okay.
can figure it out.
Okay, that's the motion. It's been properly seconded. Any discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Passes, 4-1. 5-1. Passes 5-1. John Michael.
Mr. Chairman, the next case is 2017-428. And the appellant is Benita Dudley Scott Parker, the appellant and owner of the property at 1611 Baptist World Center Drive, shown here on the zoning map. This is another item A appeal involving the denial of a short-term rental permit. Ms. Parker, if you'll come forward at this time, please. Is there anyone here in opposition to case number 428? Seeing no one, the appellants will have 5 minutes to make the desired presentation to the board. Please introduce yourselves by name and address.
I'm Benita Dudley Scott Parker. I live at 1611 Baptist World Center Drive. Nashville, Tennessee, 37207. I'm here to apply, to appeal the denial of application for a permit to operate a Type 1 STRP.
So you were operating without a permit,
Yes, sir.
and why? Why didn't you have a permit, and why were you?
I didn't know. My brother has Airbnb in Alabama, and he encouraged me to do this, and I just did it. And when I started hearing stuff on TV about it, my understanding was the permits were for the non-owner occupied places. I didn't understand it.
So
But
when you
as soon as I got the
so
letter,
you got a letter.
I
when?
shut it down.
What about the future bookings? Did you cancel
I
any?
canceled all my bookings.
How many did you cancel?
Oh my goodness, I already had some that were into October of this year. I canceled all of them, including the one that was supposed to start the next day.
Oh, you did? Interesting. Okay. And how easy was that to do?
I contacted Airbnb, and they canceled them for me, and then I let each person know before I actually shut down my site. I let the people that were already booked know that I had been shut down, and that was the reason that Airbnb canceled them.
Okay. Do you have anything to add, sir?
My name is Fred Parker. I'm her husband. I live at 1611 Baptist World Center Drive, and I'm here to support her because we're in this together.
Okay. Questions of the applicant? Mr. Osborne, I want to hear from you. Tell us about how you heard about this, any other non-permit violations.
This one was brought to our attention by Host Compliance. They sent a letter on October 27th. They did actually come in and see me about a week or two later and discuss the violation with me, and then from there they removed their advertisement, and now we're here today.
And we have a note that we passed around. Someone wrote it here today that had to leave, that was in opposition to this case. Board members?
Has everyone seen it?
Yes. So do you have anything else to add?
Me?
Yes.
No, I am prepared to pay all of my taxes, back taxes.
How much in back taxes do you owe?
Well, going by the calculations that you all have on your little application.
Yeah,
thing.
roughly. It doesn't have to be to the penny.
Oh, it's 900 and something.
Okay. Any other questions for the applicant? Thank you. We're going to close the public hearing. Discussion.
I think this falls into a less egregious category. We have a homeowner who has been immediately canceled her rentals upon notification. She has taken the proper steps that she needs to take. Based on her testimony, if y'all want me to make a motion, I would make a motion that the zoning administrator did not err, and she should be allowed to apply for a permit 90 days from December 12th, 2017.
Okay, motion has been made. Is there a second? Second. Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. You'll be eligible in 3 months. We need
Quick break.
Okay. And John Michael, break time.
Board will take a short break and reconvene with case number 2017-429. With us, and will be working as program manager with my team, with the zoning administrator, Bill Herbert. We're delighted to have her and wanted to make sure you got a chance to say hello to her today before we take up the next case.
And thank you for being here. I know it's going to be a busy year for you as everything is just busy in Nashville. So we appreciate you being here. Thank you.
And in order to welcome her gently, we've come up with a nice short BZA docket today. Moving on to case 429, Mr. Chairman, Jacob Hurt is the appellant and owner of the property located at 729 Douglas Avenue. This is an item A appeal involving a short-term rental permit denial. The property shown here in the aerial photo and here from the ground photo is the one at issue. Mr. Hurt's present. Is there opposition present for case number 429? Seeing none in the audience, Mr. Hurt will have 5 minutes to make the desired presentation. You'll hear from staff and then have the opportunity to deliberate. Mr. Hurt, please introduce yourself by name and address.
Good afternoon. My name is Jacob Hurt. I live at 729 Douglas Avenue.
Why are we here? So you rented this out without a permit, and why didn't you know, and how'd you find out?
So I purchased this house sight unseen from Portland, Oregon in, I think it was June 2015. And I originally, when we looked at the property, knew that we wanted to rent out a room. We live here full time, but I knew I wanted to rent out a room. And this happens to have a duplicate master suite on the first floor. So that was the perfect setup for an owner occupied. And when we looked at the laws in June 2015, we didn't see any Airbnb owner-occupied rules. So when we moved into the house in December, we started renting in 2016, I think it was February. We didn't see any of the law change. We saw the laws changing, but we were confused because every time we saw the law change, it would say non-owner occupied law rules are now changed, and then it would say non-owner occupied laws remain unchanged. And so we were confused by that context. We received the letter, I think it was in October of 2017. And we did a cease and desist. We canceled all of our reservations, and then I went into the codes department to get a permit, and that's when I discovered that it was a year waiting list.
So you said it was in October
of 2017.
We have a review on here from November 2017.
Yes. So the issue that I ran into is because I did this for so long, my company has started giving my coworkers the opportunity to request my Airbnb because the hotels in Nashville are either too full or too expensive.
So that's not canceling everything.
I canceled everything except for my coworkers. That's 8. That was 8 between October and January.
Okay, but that counts, right?
Well, I didn't actively advertise. I didn't willfully advertise it. That's the other issue.
But you didn't pull the listing down, obviously.
I did.
So how did that get in
They
there?
were pre-booked a couple months in advance.
Oh, so you didn't cancel them?
I'm sorry. I canceled all.
Everybody but the coworkers.
Correct. And I did pull it down. However, we've been having issues with Airbnb reposting it, and we've had to cancel multiple requests since then. So whenever he pulls up the report, it's going to show.
I've never heard that Airbnb just reposts something that someone has taken down.
It's according to Airbnb customer service, it's because we've had previous guests that have stayed with us get in contact wanting to stay with us again.
So why didn't you want to follow the laws that related to your coworkers?
Because according to the paper, it said actively posted.
But rented too. You're renting them. You get a stop work order or stop renting order, right?
Right.
And what does that mean?
You're correct. I should have canceled my coworkers. I just didn't.
Because?
I didn't want to make a big scene, and one of the dates I knew was full, and I didn't know where they're going to stay otherwise.
Which date was that? The eclipse?
No, it was New Year's Eve or day.
Okay.
So,
Mr. Osborne, please come forward. Tell us how you found out about this. Is there any non-permitted violations or complaints?
Not to my knowledge. We received this from Post Compliance, and looking back over the past few months, it looks like it's went up online at least again in November, December, and January, with more and more reviews showing up each time.
Have
So-
you ever heard of Airbnb reposting without someone's permission?
No, occasionally I'll hear about like, oh, I forgot to put it back on snooze. But
not that something is totally down and then Airbnb themselves wants it to be put up and without the person having anything to do with it, Airbnb reposts.
yeah, but
So-
due to the continued operation on this one, we are going to
So
take this one
repeat
to
again how many times it showed up after your letter, Mr. Osborne?
At least twice, once in December and once in January, and then it was online at least early November as well.
That it's not online now?
Not presently.
Okay.
I would've
Questions for
assumed-
Mr.
I would've
Osborne?
assumed it's like 5 or 6 times.
Questions for Mr. Osborne? Nope. Okay. Anything else to add?
No, just I'm sorry. I should have canceled my coworkers. I don't know why Airbnb reposted it. I did take it down every time.
Okay. Do we have? Oh,
I'm sorry, I just
yeah,
had
go
a
ahead.
question for you.
Yes, go ahead.
I'm a little, I want to ask about the coworker thing. Is this a company that you work for, or are you the company?
Oh, it's a company I work for.
And you have a situation with them for out-of-town coworkers, but you get paid? The company pays you, or the company allows you to, tell me about that.
The company requires a receipt for, in order to reimburse the person that's coming out of town. And so in order for them,
Well, but I'm not talking about them.
Do you
You're
make
making
money?
Yes.
You're making
Just
money.
like a private person would have
Right.
rented it?
Correct.
Okay. Do we have any opposition that wants to speak? Okay, yes. So you'll have rebuttal time, so come back after the opposition. Opposition, please come forward and go back into the audience. Yeah, I don't know if he wants to come. This is the time for the opposition, so anyone in opposition, this is the time you come speak. Okay.
Hey, good evening. This should just take
Please state your name and address and why you're opposed.
Matthew Bond, 3519 Gulf Street, 37216. What I just heard is that Mr. Hurt cares more about making a scene or being nice to his coworker than he does about the laws and ordinances of Metro. And I don't think that that is showing a good respect for his neighborhood, which isn't that far from mine. I live on Gulf Street in Englewood, and he's in District 7, and he's in District 5. And that he saw several times that there were laws relating to Type 1s, and yet he never pursued it. He kept seeing laws change about Type 2s, but the Type 1 laws weren't changing, but he never pursued to see what they were. And I don't think that kind of lassitude should be encouraged. Thank you.
Question for the opposition? Any other people who want to speak in opposition? Please come forward.
Thank you, Mr. Chairman. John Summers, 5000 Wyoming Avenue. I had a question. This is an SP, it says, in terms of the zoning. It's my understanding that STRs are not allowed in SP zoning?
That's inaccurate. SP zoning districts are reviewed by the planning department to determine whether or not they are in fact eligible for STRP usage.
And what's the basis of that?
It's reviewed by the planning department, not the codes department.
But what's the basis for
The reason I answered it that way is because I don't know. The planning department does, and that's why we turn it over to them to review. They are the unique holders of the province over specific plan zoning districts.
Well, I'm under the impression that under the current ordinance, SP is not in that ordinance, and we shouldn't be allowing any permits in as
So
SP zoning.
as you know, Mr. Summers, as a former council person, we're the board that gets to kind of rule on this, and then the best that we can do is tell someone that they're eligible, and so then that's somebody else that gets to decide.
I understand, Mr. Chairman. Thank you. But I just wanted to raise that issue because having somewhat of a familiarity, we just went through that debate on these last two ordinances, and SP language was not in either of the current ordinances. So
Okay.
I'll be talking to the Plan Commission next. Thank you.
Thank you. Okay. Applicant, back forward. Rebuttal. So you heard both of those people, but mainly the first person related to your case. So how do you respond?
My apologies. It's poor judgment on my part. I shouldn't have held my not wanting to make a scene at work over the laws of the land or laws of Metro. As for the SP, I was told in the planning department when I was trying to get the permit that owner-occupied type 1s were allowed in my area as an SP, but I don't really know the laws with the planning department.
Any other questions for the applicant? Okay. Nope. Thanks. We're going to close the public hearing. Discussion. So we have a case here where host compliance has found yet another person operating without a permit. And Mr. Osborne said that this showed up a couple times after his letter. And of course, the applicant said that he canceled everything but his colleagues and people from his company. So here we go.
I think the Planning Commission, Metro Council done a terrific job trying to get all this stuff worked out. Been a lot of confusion about it. And I'm going to start supporting the one-year rule.
Okay. Other discussion?
I think to me, it's more like a 6 to 8 months. Because, yeah, it's just, okay. I will move that the zoning administrator did not err and that we assess a 6-month penalty from the date of the application, which was December 13th, 2017.
Okay, motion's been made. Is there a second?
I second.
Motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor signify by saying aye. Opposed? Another motion.
Let me try to amend that motion. Can I amend that motion?
Just a new motion. That one died.
Okay, I'll have to try again. Okay, so I'll move that the zoning administrator did not err and we assess an 8-month penalty from December 13th, 2017.
Okay, motion's been made. Is there a second? Okay, motion's been made and properly seconded. Any discussion? Seeing none, all those in favor signify by saying aye.
Aye.
Opposed? Next motion.
You make a motion.
I'll move that the zoning administrator did not err and the applicant should be eligible within 10 months of applying, of the date of the letter. That's my motion. Is there a second? Okay, no second. Is there a second? Nope.
I'll second.
Okay. All those in favor signify by saying aye. Aye. Opposed? Passes unanimously. Next case.
Thank you.
The next case is 2017-431. This, too, is a short-term rental case, item A appeal, brought by Capricia Hudson, the appellant and owner of the property located at 1020 10th Avenue North, shown here on the aerial map. It's challenge to the denial of the short-term rental permit. Is there anyone here in opposition to case number 431? Seeing none, the appellant will have 5 minutes to make the desired presentation to the board. Ms. Hudson, please introduce yourself by name and address.
Hi, good afternoon. My name is Capricia Hudson, and I live at 1020 10th Avenue North. I'm here to appeal the denial of the short-term permit application. A little bit, I started running my property after speaking with some of my neighbors about doing the short-term rental. I will admit that I was a bit ignorant in regards to the laws and procedures. I thought it was more so kind of like Lyft or Uber. You know, you kind of go like their guidelines, and once they approve you, then you're okay. So once I submitted everything to Airbnb and, you know, they told me that I can go live, then I went live and did so. It's, you know, I didn't know the laws. It's not that I tried to defraud anyone. I want to be in compliance, you know, with the laws. And so when I got the letter, immediately I stopped my Airbnb listing. I canceled all my reservations that I had, although it was really hard because this is kind of like my way of living. And, but I didn't want to do anything, you know, that would put me in jeopardy of having the time to be extended any longer. So I'm here today to ask that my appeal be, for the short-term application, be approved.
Okay, any questions for the applicant? Okay, anything else to add? Is there anyone here in opposition? Nope, okay. Let's close well, let me ask you this,
Sure.
actually. How come you didn't know?
Like I said, I thought it was more so like, you know, I don't drive Uber or Lyft. However, I did, you know, apply for Lyft. And like with them, I had to like go by their guidelines and their approval. And so I thought, since it's like another like app type situation, that, you know, once I got everything squared away with them, that I was okay.
So how long have you been doing this?
For probably about a year and a half.
And how many times do you think you've rented it?
Probably maybe 250 times.
250 times? That's a lot.
Yeah.
Mr. Osborne, come
And,
up
and
here.
I will say that even with the neighbors, I have several neighbors that do it, but I really didn't talk with them. I only spoke with one that I kind of held high. I valued his opinion and things that he has to say. I thought
And
he
he
was
didn't
pretty
tell
smart.
you, gee, you know, you need a permit.
But he didn't have a permit.
Oh, he didn't have a permit either.
He didn't have a permit either. So it's kind of like the blind leading the blind.
So he'll be here probably pretty soon too, because
Probably
this guy is
probably
all
so.
over it. Mr. Osborne, how'd you find out about this and what you do once you did, and any not having a permit violations or complaints?
No other complaints to my knowledge. I did find out about this one, and we sent out a letter on December 1st through Host Compliance.
Okay.
Her ad came down shortly thereafter.
Is that, okay. Anything else to add? Nope. Close public hearing. Discussion
I see we do have one letter of support on this one.
by a neighbor.
Yes.
No, it wasn't that neighbor. Actually, the neighbor that sent the letter, I don't know them. They put one in my mailbox as well. So
They saw the red sign?
yes, no, they saw the right sign, and then
Oh, they
also
got the letter, not the
Yes.
red sign, letter. Yep, okay. Oh, discussion.
Well, I think this is a similar case where we have, upon notice, she canceled her listings. She has now attempted to put herself in compliance. There is a letter of support in the file, so I'm happy to make a motion. I would make a motion that the zoning administrator did not err, and that she should be allowed to apply for a permit on March 13th, 2018.
Okay, motion's been made. Is there a second?
Second.
Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor signify by saying aye.
Aye.
Opposed? Okay, it is 5-1. Passes. You will be eligible when?
March 13th.
March 13th. You still do not have a permit.
I understand.
Do not advertise.
I
Do not
understand.
rent. And come down here, and on March 13th, you will be able to attempt to get a permit. Okay? Thanks. John Michael.
Mr. Chairman, the next case, 2017-432, is Hunter Moore is the appellant and owner of the property at 708 Glenview Drive, shown here on the zoning map. It's an item A appeal of a short-term rental permit case. I believe this was actually a cancellation after issuance on his case. Mr. Moore is present, and we'll have the opportunity to address the board. Is there anyone here in opposition to case number 432? There are opponents. Therefore, Mr. Moore will have 10 minutes to make the desired presentation. Mr. Moore, if you wish to save some of that time back for rebuttal responses after the opponents speak, please do so out of this originally allocated 10 minutes. Then we'll hear from the opponents, which of course have 10 minutes to share among themselves and divvy up as best they see fit. Board members, you have the case file in front of you in its entirety. Mr. Moore, please introduce yourself by name and address the board.
Hi, my name is Hunter Moore. I live at, I'm the owner and liver occupier of 708 Glenview. I'll keep this brief. I know you guys have been through a lot of these, but I would like to give a quick backstory about the house. So my brothers and my father started a development company to build this house, We bought the lot in 2015. After 2 years of the most unlucky construction project I can possibly begin to describe, the house was delivered to us 16 months behind schedule and $130,000 over budget. And absolutely bankrupted our family company, and we all had to go separate ways. After 6 months being on the market with not one offer, going through 3 different realtors, the construction loan payments starting to kind of cripple us. I tried to rent it out. I couldn't find a renter to occupy the house in that area for the amount of money that we need to obviously sustain it. So as soon as I found out about the STR permit, I finally saw a way to kind of financially help my family. I'm the only family member who doesn't already own a residence, so I volunteered to move into the house, pay as much of the mortgage as I possibly can, and because I travel for work, when I'm not there, try to rent it out and try to recoup some of our losses. I asked a former work colleague who was here, but she's had an emergency and had to leave, to manage it for us. She does rentals in the Nashville area and somebody that I trust. I wanted somebody to look over the property that would be vetting our guests. We've spent obviously a lot of money there, understanding who's there for my neighbors and the area, making sure we have good substantial people who are vetted before they obviously are in the house. In September, going through the permitting process, moving into the new house, moving into a new office, starting a job, and I was about to leave the country for a month. So in the midst of filing meeting codes, I believe I misunderstood the fire marshal once she gave me the "you're clear," and I think I instructed Janelle, who's the property manager, to go ahead and put it up online. We were active online for 17 days before I had my hard copy of a permit. In those 17 days, we had one person stay there. In that 17 period, we were not trying to act illegally or unlawfully. We paid property taxes on it, thinking that we were legal. As soon as I was back in the country, I didn't get the letter till later because I was in South America for over a month. Once I got back and got the letter, we immediately took down our listing, called several people at Metro, went down to codes, and have been trying to undo this ever since. I would just simply ask that this was human error, miscommunication between myself and my property manager. I was traveling a fair amount. I've probably spent 3 weeks in Nashville, in the United States, in the last 3 months, and it's just been kind of a balance of some new things going on. I would like to ask the council to please grant me the opportunity to reinstate. We have paid everything, and we've done everything to comply. If you could have an opportunity to reapply, that would be fantastic. Thank you very much.
It appears that you hosted more guests than you're allowed. There's one review in here. There were 13 people in the house?
Correct. So in the beginning, there's a fourth floor or a third floor where there is it was an office or a bonus room. I didn't really give a full description of the property to the property manager. Because it had a window and it has a closet, she assumed that it was another bedroom. We have since had a property assessor from Metro give us the sign off on that room, and we have had it corrected as soon as we got a notification that we were listing too many rooms than were on the original fire marshal plan. We had it changed and corrected thus far.
Any other questions before we hear for the opposition? Okay. Oh, go ahead.
Our file from your council person and several other letters in opposition. Have you seen those?
No, ma'am.
I don't know. Is he getting a copy or is he listening? Okay. We can hear from the opposition and give him an opportunity to look at.
We're going to hear from the opposition, and then we'll show you the letters of opposition. Opposition, please come forward. Collectively, you will have 10 minutes to, Thanks, Jim.
Do you want to look at these?
I guess 5.
Mr. Moore, do you want to look at these letters?
John Michael, what's the
No,
new
10,
rule?
10 for opposition.
For
5,
opposition?
no opposition.
Oh, 10, okay. Gotcha. Sorry.
Okay. Collectively, you'll have 10 minutes, so use your time wisely. If the first person speaks for 9 minutes, everybody else just gets 1 combined, so divide it up. Please identify yourself for the record by name and address, and please get started. Who's going to start us out?
I will start. My name is William Worrell. I own a house and I live at the property at 1000 Glenview Drive, which is immediately adjacent to 708. I'm a civil engineer and a regulator for the Army Corps of Engineers here in Nashville. Over the past several months, I've collected evidence of multiple violations at 708 Glenview related to the short-term rental ordinance. These were passed out to all of you as exhibits. In addition to this, Metro Nashville has sent official notices of noncompliance to the owner Moore Development Group on 5 separate occasions from what I can see. We have one notice of violation letter that was sent in October. We had 2 letters in regards to a revocation of the permit. We had an environmental court summons, and it shows that an email notification was sent. These were sent to the Moore Development Group out of Arrington, Tennessee. Some of the letters were sent to Hunter Moore at 708 Glenview Drive. So this was sent to multiple addresses that they should have received these. Also, the owner Moore Development Group has hired a property manager to rent the short-term rental. The property manager stated that she manages multiple other properties, so should therefore be aware of the code that exists in Nashville. So despite all of this, the owner has continued to operate the STRP in violation of multiple sections of code. So I'm going to go quickly through the different slides, the evidence that I did provide to the board. The first violation that existed that I documented is that the property operated prior to obtaining the required permits. In September, 708 began operating as an STRP. Multiple guests stayed. So there's a couple slides on that. In November, the permit was revoked. If you'll see here, there's a letter sent from Metro Nashville in October, a notice of correction letter sent to the Moore Development Group in Arrington, Tennessee, telling them of multiple code violations. That was sent in October. We have documentation here of the people who stayed at the property. There are 3 different reviews of people who stayed at the property in October and November. So the notice of permit revocations went out in November. Those were sent to Mr. Hunter Moore. Here's a screenshot of the Airbnb advertisement that was still active on December 9th, 2017. If you look at the calendar, it has dates blocked out for the New Year's holiday, in which we documented over 10 people at the property with out-of-state license plates. The next slide, we have pictures of guests arriving at the property on January 15th. We're not sure, the Airbnb advertisement was down at this time, but we're not sure who these people were, but they arrived via a chauffeur vehicle, and they did not have a personal vehicle with them at the time. If you go to the next slide, you'll see the property manager's advertisement website where she has advertised the short-term rental property. If you'll see, this website is still active to date. On the next slide, we have that we believe that illegal drug operations were being conducted at the property on November 19th. We documented over 10 vehicles that came and go throughout the day and night. Here's some pictures. That was very disruptive to our neighborhood. Next slide, we have where we chose not to call the police because we wanted to be a good neighbor to the Moore Development Group. We sent a personal email to the owner telling them of these, what we have appeared to be drug-related activities. The property owner did not respond. The property manager instead responded to our email. Next slide is that the property knowingly advertised and hosted higher occupancy than permitted. You'll see evidence here from the property assessor website that it's a 3-bedroom house and there's 3 sleeping rooms on their permit. On the next slide, we have a review from an individual who said they had 13 people in the house. We have December advertisement on Airbnb with 12 different guests being allowed. In addition to these violations, the Moore Development Group did not appropriately post their public hearing sign. This was posted in early January. You'll see photos here throughout January in which the sign was laying on the grounds. Okay. And finally, the property is owned by a business, a group partnership, Moore Development Group. An ordinance has been passed recently that prohibits a business from having a short-term rental property owner-occupied. Finally, we have evidence that the property is not owner-occupied. I've never viewed Mr. Hunter Moore staying at the property. We have a advertisement that is currently that was posted in December and is still valid on Zillow, showing this property for long-term rents for $3,600 per month for the entire house, long-term rent. So that's all that I have. I appreciate you listening to my testimony.
Okay, who's next? Or that's a lot. Questions about that and thorough documentation. Okay, next. And notice that you have 3 minutes and 15 seconds cumulatively. When we ask you questions, that doesn't count against your time, but when you all talk, it does. So go ahead.
Yes, sir. I'll be real quick. My name's Jim Gregory. I also live at 1000 Glenview with my husband, Will Worrell. I just want to state real quickly that this yellow folder is all of the hundreds of hours and thousands of dollars that we have spent defending our property from Moore Development Group. They have failed to survey their property when they first started building it, and they were going to build a house on our property line. We had to show them that where our property line was. They failed to place the house in the correct with the correct setback. We had filed a zoning appeal with you all, and when we got on the docket, they took us seriously and they pushed the house back to the setback. We had a boundary tree. They said that they were never going to cut it down. They sent a crew the next week after they said they were never going to cut down, and thank goodness I worked from home and caught it, and otherwise we wouldn't have our boundary tree that we love so much. The worst thing they did is they didn't tell a contractor with a bobcat to where the property line was, and they graded 18 inches onto our property, compromising a 100-year-old wall that is supporting our building's foundation, our house's foundation, which is 5 feet away. We had to go through a lengthy process, but them on notice, their insurance company on notice, had them build a sub-retaining wall to support the damage they did to our property. This is ongoing, and now they're running a short-term rental property which had drugs. They were smoking pot in the backyard the weekend before Thanksgiving, and several other beer pong, several other things. You all have the letters. It takes a lot for us to be up here. We don't want to be up here, but they would be up here too if they would experience the stuff that they put us through. Thank you.
My name is Michael Basham. Shall I go ahead? My name is Michael Basham. I live at 1107 Ozark Street, runs behind Glenview. I'm neighbors for these gentlemen and for the subject property. I am an attorney, and I am not here representing them because I've looked over what they had to say, the ordinance and the materials they were bringing you, and decided they didn't need my help. I've helped them in other situations, but I'm here to add my voice to theirs, as are several of our neighbors.
My name is Emily Pierce, and I live at 1002 Glenview Drive. It is the White House, 2 doors down from the property in question. And I ask that you uphold the zoning administrator's action to revoke the short-term rental permit at 708 Glenview Drive. Over the past several months, I have personally witnessed this home operate as a short-term rental property despite having its permit revoked. Furthermore, I feel strongly that the behavior of the owner, or rather the business entity of Moore Development Group that owns the property,
and the property manager have knowingly and purposefully operated in violation of the rules set in place by Metro. The brazen behavior of Moore Development Group, as well as the property manager, is not only offensive to me as a resident and property owner on Glenview Drive, but also as a supporter of those in my neighborhood who operate their owner and non-owner occupied STRPs lawfully and within permit specifications. To this date, I have never met Hunter. This is the first time I've ever laid eyeballs on him, and you would think if I lived 2 doors down and work from home, that I would regularly see the same vehicle parked there, especially when someone leaves the country. He does not live there. I think that that is a lie. And it seems crystal clear to me that the parties associated with the ownership and management of 708 Glenview do not respect or plan to follow the laws set in place for residentially zoned STRPs. And I encourage you to please uphold the revoked permit and additionally invoke the 1-year waiting period to apply for a permit again.
Okay, time's expired. I know that, is there anybody that could quickly speak? We've heard that said something different that wants to than
Chairman,
what we've heard.
If you want to add a minute, and we could add it to the.
Yeah, we'll add a minute to both sides. So just quickly, if anyone has something burning that they hadn't heard, come forward. Come forward.
Got to come forward.
Or it didn't happen. We're out of time, so.
We got a minute.
I represent 4 of these properties that are in the picture here, and I can just say that, we're all completely for what they've said. And also, I walk my dog probably twice a day by this house. I've never seen the same car there. I've never seen him before. So, I mean, you're hearing more of the same, but like.
Very good. Mr. Summers, name for the record, please.
Thank you.
Your name for the record?
John Summers, 5,000.
No,
sorry. Sir, you got to give him your name.
What's his?
Sorry, Brian Letcher.
Okay. John.
John Summers, 5,000 Wyoming Avenue.
Quickly.
I'd like to submit to you, if I could, copies of the pending ordinance 937, which is before the Metro Council. This is one that was deferred, but there was, I think, unanimous agreement in the council that the council is going to ask for longer penalties for these. In fact, there's a minimum 1-year violation that's set in this ordinance. So I hope in considering this that you would set at least a minimum of 1 year. In fact, you have discretion up to 3 years. I hope you would consider, because of the grievous nature of this, that you would look at the maximum penalty, because today you have given all penalties less than 12 months. So,
Mr. Summers, I think environmental court has 3 years. We only have 1.
No, I think they're giving you discretion to set it at 1.
I mean, we can't go over 1. Environmental court gives you up 3.
Right, but, I think this sets a minimum for y'all. I thought y'all had 1 to 3 still.
Nope.
For BZA, it's up to 1 year. For environmental court, it's a mandatory 3 years.
Thank you.
Okay. Thank you for this. Quickly.
Hi, I'm Jason Garrett, 1508 Severe Court. I'm the president of the neighborhood association where this is. And just to give a context of the area, we're very close to downtown. And also with the pending legislation from 608 before, is that this has pushed a lot of people to try to use fake credentials or fake means to actually say that they live there, to have the ability to run the short-term rental. So we've seen this on numbers and dozens of occasions in the neighborhood. And this is very consistent with that behavior. And I don't think that equity, and I feel very much for Mr. Moore in this case, but I can't see that can be a factor. Otherwise, everybody's going to overbuild and use other more lucrative means to try to subsidize their some poor situations.
Okay, that's it. Time. We're going to add 2 minutes to the other side. The applicant, please come forward. Everybody else, go back to audience. And rebuttal time.
Well, I don't have much to argue with right here. Obviously, they're very upset about things that have gone down in the construction process, but so are we.
We're not talking about the construction.
I know. I'm not
we're
trying
talking
to get
about
in there.
short-term rentals.
Well, just tell me what you'd like to answer. Obviously, I've been in and out of the country and been trying to do this via a property manager. I did want to have somebody on there doing her best, but clearly she didn't do good enough and I didn't do good enough, so I have nothing more.
Okay.
I'm
Any
sorry for
questions?
everything that has happened on the
Any
property.
questions for the applicant? Nope. We're going to, Mr. Osborne, how'd you hear about this? And what other non-permit violations did you notice or investigate?
We did receive a complaint about this one back in October. Sent an abate notice on October 17th of 2017 for advertising over occupancy, over bedrooms, and not having their permit displayed. Also did notice that they were just issued their permit that day and already had a review. Took that down to zoning to have the permit revoked for the excess occupancy and the operating without a permit prior to having one.
And did you investigate any of these slides that we got? Have you seen these before?
I'm not aware. I know we received some complaints, but we haven't been able to follow up on them that may have had some of that information.
Questions for Mr. Osborne? Okay, thank you. We're going to close the public hearing. Discussion.
I want to know if it's relevant that this company, and I guess I want to ask our legal counsel, is the new law effective now? The 608 that passed is effective now. Is it true that a company cannot own an owner-occupied STRP?
I believe that is correct. The definition says that yes, the definition says that a company or an LLP, corporation, et cetera, cannot.
That's what I thought I had read.
And, Mr. Chairman, if I may, to supplement what council just stated, it's referred to as the Natural Persons Amendment that was put in by council. So it includes family trusts, which we often see, also not allowable for ownership of a Type 1 permit, at least as far as new applications.
But once again, that would come up if someone goes down and to the office, and that's the name it's under. So we're here to decide about this. So, other discussion? Well, large number of people here and documentation that kind of I've never seen before, the detail and the pictures and dates and everything. And obviously staying 4 hours to say all this too. I think this is one of the more egregious ones that we've seen, and kind of an absentee person who, according to the testimony, wasn't around. And then even the person they entrusted, even according to his testimony, did not do a good job managing it and complying with the law. And a lot of letters of opposition.
So,
including the council person.
I'll make a motion. I move that we find zoning administrator did not err in his.
Mr. Harper, I'm sorry to interrupt you. I just want to clarify one point. This is not the typical item A appeal for denial of a permit. This was a permit that was revoked. So the answer is yes or no. Was the permit properly revoked? If so, it stays revoked for, according to the law, a year. If it was improperly revoked, then it would be immediately reinstated.
Thank you. It's a muscle memory there. I move that we find that the revocation was proper and should remain.
Okay, motion's been made. Is there a second?
Second.
Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor signify by saying aye. Aye, opposed, passes unanimously. It stays revoked for a year.
Mr. Chairman, the next case is 2017-435. Randall Roberts is the appellant, and Ira Shivitz, the owner of the property at 3706 Estes Road in Council District Number 25. The request is for a variance from the sidewalk requirements in the R20 zoning district for the construction of a single-family residence. We did receive a late email from the district council member from Council District Number 25, Russ Pulley, as I'm showing the aerial photograph of the subject property, the site plan of the proposed addition, and the photographs from my recent visit to the property. I'll pull up that email and read it into the record at least. From 12:39 p.m. today, Councilman writes, Bill and John, sorry for the late email. I wanted to email the BZA to let them know that I support the Planning Department's recommendation that the applicant, Ira Shivitz, be allowed to pay into the in lieu fund rather than build a portion of sidewalk on Estes. Thank you for your consideration, Russ Pulley. That will be entered into the hard file, but we want to let into the record as well today. We are joined by both the appellants and we are joined by both the appellants and opponents in part to this case. Both parties will have 10 minutes to make the desired presentations. You have the Planning Department's recommendation in your case file, as well as letters that were submitted in support and in opposition. The appellants will come forward and introduce themselves by name and address.
My name's Randy Roberts. I work with Old Hillsboro Building Company, and I'm here for for the property at 3706 Estes Road.
Okay. So
Go ahead, I'm sorry.
you're asking to be let out of building a sidewalk. Why?
No, well, we're asking if we can go ahead and just pay the variance.
Pay into the fund? In the
Yes,
fund.
yeah.
Okay.
Yeah, we have no problem with the sidewalk and the whole issue. It's just, it's been, I was told, if I understood that right, that I needed to come here before you guys and then get approval to pay it instead of build it.
That's just. Anything else to add? Okay, is there opposition here? No? Okay. Question for the applicant? Okay, thank you. Close the public hearing. So he wants to pay into the in lieu fund. Discussion.
There are a lot of letters in opposition, but they're generally opposed to the sidewalk variances.
Right, but we have a late letter from the council person saying that he's supportive of him paying in the in lieu fund.
And staff is supportive of that as well. I mean,
Right.
planning.
Any motions? What?
I move that we grant the variance and allow the applicant to pay in the in lieu fund.
Okay, motion's been made. Is there a second?
I would,
Oh, no, well,
go right away.
that's up to you all.
I'll second.
Okay, motion's been made and properly seconded. Any discussion? Seeing none, all those in favor signify by saying aye. Aye, opposed, passes. Pay into the in lieu fund and
What is my next step after this? Where do I
talk
go?
to code.
Go to the Codes Department on Monday.
Excellent.
Okay, thank you. John Michael.
Thank you.
The next case is 2017-436. Conrad Norris is the appellant and owner of the property located at 409A McIver Street in Council District Number 16. The request is an item A appeal involving the denial of a short-term rental permit. Is there anyone here in opposition to case number 436? Seeing none, the Norrises will have 5 minutes to make the desired presentation to the board. Please just introduce yourself by name and address.
My name is Conrad Norris, and I live at 409A McIver Street, Nashville, Tennessee, 37211. And this is my wife. This is my wife, Alyssa.
When did we start renting without a permit, and how'd you find out about our great laws?
Do you mind if I read a statement I prepared?
Sure, go ahead.
Thank you very much. Good afternoon, everyone. My name is Conrad Norris, and I'm with my wife, Alyssa. We're very grateful to be with you today to share our story. We bought a house in the end of September, and we now live close to family and just walking distance from our church. We're very blessed to call it home. We were planning to rent out a room to make extra money to help pay for our mortgage in this expensive housing market. We're entrepreneurs, and we're working hard to grow our small businesses to support our family. Initially, when we started renting out a room in our home, we didn't think we needed a short-term rental permit because our home was owner-occupied. In December, when I learned from a friend that he had obtained a permit for his owner-occupied short-term rental, I investigated and confirmed that we did need a permit, so I quickly began the process to acquire one. When I went in to apply for the permit, I was relieved to finally meet with a Metro employee to get the permit. We brought proof that we had taken all the required steps to be eligible for a permit. At the end of the process, the employee I was meeting with asked if we had a short-term rental listing. I told him that we did. Then he asked if we had been renting it out, and I told him we had been. I also shared that we had paid all of our occupancy taxes. He pulled up the short-term rental website, and I directed him to the listing. He suddenly said that we had been renting out our home illegally and that we had 3 options. We could shut it down and wait a year, rent it out long-term for a year, or appeal to the board. We were devastated. Because we were counting on rental income from the room to help pay for our living expenses, we didn't know if we'd be able to keep our home. We chose to appeal to the board, which is why we're here today. I realized too late that we shouldn't have rented out our home without a permit. I'm embarrassed to admit that I trusted informal and inaccurate information from people I knew in the short-term rental community without actually verifying that information for myself. That was a careless and costly mistake, especially since we were relying on the income. I should have done research before we rented out our home to determine whether or not we needed a permit. When I went into the codes building in an attempt to acquire a permit, I was trying to make things right and abide by the law. The appeal process has been long, expensive, stressful, and humiliating. We've had to send out letters to all of our new neighbors and post a large red sign that says we operated illegally in front of our yard for nearly a month. That said, we understand that these are all consequences for our actions. We're here with the hope that you'll have mercy on us, knowing that we were in the wrong. We're asking for your permission to continue the legal process to obtain a permit for our home. This would allow us to support our family, grow our small businesses, and welcome visitors to Nashville. Thank you so much for your time and consideration.
Okay. Any questions of the applicant? So, why didn't you know?
Honestly, I haven't seen anything about it except for when I started looking into it. And we have another rental property. It's type 2 where we don't live in it. Even through that application.
You have a permit for that?
Yes, we do. And even through that application process, we had no idea for type 1.
But you went online and looked because you didn't know anything about a type 2 permit, and right there on the same website, it talks about.
It was unclear to me at the time.
Okay, Mr. Osborne, come up here. How'd you hear about this? Any non-permit complaints? And
we didn't receive a complaint about this one, so they came in on their own.
oh, that's right, the old self-incrimination in front of the code
yeah.
staff with your application in hand. Did you
Right.
rent before? Yes. Denied.
I did get an email from Mr. Norris about December 15th asking about his renewal application for his other property, in which I directed him to zoning.
Okay.
But other than that, we didn't know about this one.
Any questions of the applicant?
Did I understand you to say you don't have any current, you're not currently listed?
That's correct.
And you've not rented?
We took it
since you
down.
noticed?
We took it down that very day when I was in the office. I actually unlisted it.
Okay. Any other questions? Okay, we're going to close the public hearing. Discussion.
I know that one of the letters that's marked oppose is actually supporting when you read the letter. It's from Colton Kidwell.
It says strongly support in the
Right,
first
all-
sentence, so
all
yeah,
are in
I'm not
support.
sure why that got
I don't
marked.
see any opposition. All the letters are in support.
I think there's one letter opposed, actually, right behind that letter. Oh, that says support too. You're right, okay. Mislabeled, so 3 letters of support. 4, okay. Discussion, motions.
I'll make a motion. I think I move we find that the zoning administrator did not err and that the applicant should be able to apply 90 days from the date of their application for appeal.
Okay, motion's been made. Is there a second? Motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor signify by saying aye. Aye, opposed? 5-0. Passes. You will be eligible in 90 days of the late date of the letter.
I believe it was December 15th. Well, we didn't actually receive a letter, but when I was in
That's
there.
right, when you came down here.
The
Yep.
motion was the motion was the date of the application.
Yep. Okay, very good. Good luck.
Thank you very much.
Mr. Chairman, the next case is 2017-438, another short-term rental permit item A case challenging the denial of the permit application. Vanessa Brown is the appellant and owner of the property at 2900 Highland Drive, shown here in the aerial. Is there anyone here in opposition to case number 438? Seeing none, Ms. Brown will have 5 minutes to make the desired appeal to the board. Please introduce yourself by name and address.
My name is Vanessa Brown. I live at 2900 Highland Drive. I'll make my presentation very brief as well. It's very similar to a gentleman we heard a couple hours ago who also was unaware of the permitting process and received a letter in the mail. I received your letter. It was dated October 27th. I didn't receive it until a few days later than that. But within the hour of receiving that, I had taken my listing down from Airbnb. I spoke to Airbnb, and they work with me and the tenants, and we canceled every reservation.
How many were that?
Probably 3 or 4, because I had it booked out for a good while.
Okay.
But they're good in the sense that they will call the person on your behalf and, help them rebook. After that, I got all the documentation that I needed to. I upped my insurance on my property, gathered all the documentation that I needed to, went to apply for a permit and was told that I was not eligible to. And so here I'm to appeal for you today. You just consider my ignorance and accept my apology and consider that.
How'd you figure out that this was, that you needed a permit? How'd you figure out?
The letter that you sent.
Okay, speaking of the letter, Mr. Osborne, how'd you find out about this and any non-permitted complaints?
I don't believe we have any other complaints on this one. We found out about this through host compliance.
Okay.
So we sent a notice on October 27th, and then shortly thereafter, it was removed from Airbnb.
Yep, okay. Questions of the applicant? Okay. Anything else to add?
No, I would just ask that you consider that the property has been shut down for about 2-3 months presently, and if you would take that time in consideration.
Okay, we will.
Thank you.
Thank you. Closed public hearing discussion. Mr. Harper.
So I was unclear on that last part. Was she saying that?
She has not been operating, I think, since October, and to take that into consideration.
Oh, okay. Well, then I move that we find the zoning administrator did not err and that the applicant is able to apply immediately.
Okay, motion's been made. Is there a second?
I second.
Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? 4-1. Passes.
And, I'd just like to opine for a second. It seems like somebody would start a Facebook group or something. I mean, we are expending an incredible amount of resources doing this twice a month, and I know the staff. I mean, we have 8 inches of thick of documents for these cases, and we're hearing, I mean, they're all the same case, it's all the same problem.
So we need a hashtag. Go get your permit.
Get your permit.
Okay, so you are eligible
It's gonna
to
catch fire.
apply for a permit immediately. Do not advertise, do not rent until you do.
Yes, sir.
Thank you. John Michael.
Case 2017-439 involves a property located at 4601 Billingsgate Road out in Council District Number 28. Steve Sanders is the appellant, and Golden Took LLC, the owner of the property. The request is for a variance from sidewalk requirements on the corner lot shown here on the aerial map in the RS15, or rather the R15 zoning district. The site plan submitted gives some sense of the topography associated as the property curves down toward Franklin Limestone Road. From our recent site visit, the construction well underway in the bottom right-hand corner, the view across the street on the upper left-hand corner, the view exiting back down toward Franklin Limestone Road in the lower right-hand corner, and uphill going into the Billingsgate Drive in the upper left. Is there anyone here in opposition to case number 439? Seeing none, the appellant will have 5 minutes to make the desired presentation to the board. Please introduce yourself by name and address.
Yes, my name is Steve Sanders, 217 Wheeler Avenue, Nashville, Tennessee, 37211. I am a registered land surveyor, and I'm representing the owner, Golden Touch. I've been surveying in Nashville, Davidson County, and surrounding counties for 45 years, and this is the first time I've been before the Board of Zoning Appeals. And I wouldn't be here today if I didn't believe it was for a just cause. I am familiar with the sidewalk ordinance, the conditions, standards to be granted a variance according to the zoning department are the physical characteristics of the property. The topography of this property is a very steep slope. In order to install the sidewalk as public work requires, it would require a 4 to 5 foot retaining wall around the perimeter of the front of the property because the slope is so steep.
Okay, we do understand your topography issues, and as a surveyor, we really take that into consideration. But why doesn't your client want to pay into the sidewalk fund?
Well, the uniqueness of the property, some of the unique characteristics. There is an open ditch that runs along parallel with Franklin Limestone Road.
The sidewalk fund doesn't have anything to do with the topography. It's like if you don't build the sidewalk, you could pay into the fund not to build the sidewalk.
Well, it was my understanding that the owner would be responsible for that piping and the curb and gutter.
No.
That's
It's
what.
an either or. You could build a sidewalk, or you could pay into the fund. So if you pay into the fund,
Yes,
you
sir, I
don't have to
understand
build a
what you're
sidewalk.
saying, but it was when I asked the Public Works, if that pay sidewalk fund included the curb and gutter and that piping, my response I got was no, that did not include that.
And Mr. Chairman, to be clear, Public Works has their own guidelines with regard to the setup of the ditch lines that are being described. Mr. Sanders is right
So
about
you're
that.
saying
This is just a sidewalk fund question. It's all that's in front of the board, the
Right.
sidewalk part.
The ditch is somebody else's determination, but you could either build a sidewalk or you could pay into the fund. So was your client willing to pay into the fund?
He would rather not, Your Honor. I mean, I don't think he would be willing. I would have to ask him, to be honest with you. I can't give you that 100% answer
But
legitimately.
you sat through 4 hours of this. You've seen other sidewalk cases.
Yes, sir, I agree.
We have a
but I think
law. We need sidewalks.
I think this is a unique case because as I read the conditions for getting a variance granted, I think this case agrees with every one of those conditions. And that is a variance to.
But our laws anticipated that and said if you have these difficult sidewalks to build, you don't have to build it. You could pay into the fund.
Right, but it's my understanding that is a variance for both of those items, not to build the sidewalk or to pay into the fund.
But lately, since we passed the sidewalk bill, we've been making people pay into the fund except under the most extreme circumstances.
Yes, sir, and that's what I was trying to explain. That ditch, there is a area drain at the intersection in the pavement that drains into that ditch. That's the whole drainage coming from the subdivision. I think it's an undue hardship upon the owner to have to pay to have a pipe laid in that ditch when that's catching the drainage from the whole subdivision, not just his lot. I think it's an undue hardship that it's not self-imposed. None of this is self-imposed. There is not, financial gain is not the only basis. There is no injury to neighboring property. On the other hand, there could be injury to the neighbors if you have a 4 or 5 foot retaining wall there and a kid falls off of it. And the sidewalk is just going to lead down to the creek. And then it's going to dead end. And it's in a 100-year flood zone.
Yep. Okay.
And if we're not allowed to build in a 100-year flood zone, why should Metro be allowed to build in a 100-year flood zone? And it could just be a burden on Metro because if we get a flood, it's going to wash that sidewalk out, and then it's going to be Metro's responsibility to see whether they want to replace it or not. I
Questions?
just feel like this is a unique situation. And yes, sir, I agree. I've sit here and listened to the previous cases, and I see you all's point of view on the general concept of the sidewalk plan, and I don't dispute it. I agree with it. But I think this is a unique circumstances where you're not just going to have to build a sidewalk, you're going to have to build a retaining wall, you're going to have to install a storm sewer, and you're going to have to relocate the sanitary sewer because there's a manhole at the edge of pavement on Franklin Limestone Road. Either it's going to have to be relocated or it's going to be right in the middle of the curb and gutter.
Okay, questions of the applicant? Anything else to add? We're going to close the public hearing. Discussion.
I don't think we see anything that gives us the ability to go against planning's recommendation. And they're recommending that he pay in lieu on Billingsgate, not on the limestone portion of the property. It sounds like you're getting a pass on that, but they are asking that you contribute on the frontage of the property.
Okay, I wasn't aware of the Planning Commission's findings. I was informed by Public Works that they agreed with us. Now, don't know what the Planning Commission, I haven't heard from the Planning Commission.
Well, yes, sir. What we've got, it just says that you should, their recommendation is that you contribute to the in lieu of construction for the property's frontage along Billingsgate Road. And I'm saying to my colleagues, I would support planning's recommendation.
Is that a motion?
Yes.
Okay, motion's been made to.
And I second.
Okay, and the motion's been seconded. Any discussion? This is to pay into the in lieu fund.
Only on Billingsgate.
On Billingsgate, okay. Any more discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Passes unanimously. You could pay into the fund.
For the portion on Billingsgate,
Yep,
correct?
by Billingsgate. Yep. John Michael.
Thank you, board members.
Yep.
Mr. Chairman, the next case is 2017-441. Devin McPherson, the appellant, and Holtcamp Property Holdings, LP, the owner of the property located at 1431 Lishy Avenue, shown here on the zoning map. This is an item A appeal challenging the revocation of a short-term rental permit at the subject location. You heard from Councilmember Scott Davis about this matter earlier today, much earlier today. Mr. McPherson is represented by counsel, Mr. Jonathan Farmer. Are there opponents to case number 441 in the audience? There are. As a result, the appellants will have 10 minutes to make the desired presentation. Counsel, I'd encourage you to save any portion of that time you want for rebuttal out of this original 10. Then we'll hear from the opponents and then hear the rebuttal.
And I have a binder.
Okay, get us started.
Thank you. I'm Jonathan Farmer. My address is 150 4th Avenue North. This gentleman to my right is Devin McPherson. Devin, will you tell them your address, please?
1431 Lishy Avenue.
Okay. We're here on a property at 1431 Lishy Avenue, also known as the Joy Mansion. Scott Davis spoke about this earlier today. A little bit about the property. It's a 6,500 square foot mansion that's 3 stories and sits on 4.5 acres. The 1431 Lishy location has had a short-term rental permit since 2014. We are here because of a proposed revocation based on 3 alleged violations within the 1-year period. So this is not, I think, what you typically see where there's the operating without the permit. The law says if you find that there in fact have been 3 violations in the 1-year period, then the permit may, and I will stress the word may, be revoked. The law does not go through an analysis or an evaluation as to what you should consider, but I think that's, I don't want to say common sense, but something akin to common sense. I think the nature of the violations would be relevant. I think the nature of the property usage would be relevant. And I think the actions of the property owner will be relevant. So I'm going to go through those in kind of reverse order. Mr. McPherson moved into the Joy Mansion in 2011 as a renter. He had roommates, and the house was in great disrepair, and he spent a lot of money getting that house up to speed where he could rent out rooms to his friends and cover the rent. Put frankly, he fell in love with the house. In 2014, Airbnb came along. Mr. McPherson, through the owner of the property, got the permit, formed an LLC to run it, and since then it's been his livelihood. He has 3 employees that he's hired through his LLC. They do housekeeping, they do groundskeeping work, they do maintenance work. And to call this an Airbnb house, I think would be a gross misstatement, frankly. It's true that the Joy Mansion does have Airbnb listing and does regularly host Airbnb guests, but they do so much more. They provide community meals for the neighborhood. He has a community garden that he allows people to come and assist with. It's practice space for local musicians. It's an art gallery for local artists. He donates money to the neighborhood associations, money that he raises from this use of this facility. He has movie nights for kids, and he has fundraising events. And as you listen, I think it's important to separate his personal use of this property versus the Airbnb use of the property, because they're not always the same. The property use is a Type 2 permit. It is rented to people coming to visiting Nashville. Mr. McPherson does not live there. He does have a room there, but it's not his permanent address. He pays his taxes. He has the support of his councilman. He has the support of his neighbors, at least several of his neighbors, and you can see that in the binder that I've passed up. There are, I believe, some 10-plus letters in there from neighbors, neighborhood association leaders, and the like. The complaints, the violations are not noise-based. They're not trash-based. The police don't show up out there and harass Mr. McPherson vis-a-vis his Airbnb properties. So I'd like to talk about the violations themselves and just kind of go through them. The first violation was January of 2017, so more than a year ago at this point. The allegation was for advertising more than 4 bedrooms. This is true. Mr. McPherson was advertising more than 4 bedrooms. The house, frankly, had more than 4 bedrooms. What I think is important as to this point is that when the notice came out, it didn't come to Mr. McPherson. He didn't know that the notice came out. It came to the property owner, who at that point didn't share it with Mr. McPherson. The property sold or transferred in April of that year, and then in June, there was another notice of allegation, and it's the same one. Look, you're still advertising too many bedrooms, 1, and 2, you're not displaying your permit on the Airbnb website. This is the first time Mr. McPherson has learned about the 4-bedroom problem, so he fixes it. Solves that problem. The permit was posted in the window. He solved that problem by putting it on the Airbnb site as he was required. We go to November 13 when the next allegation comes about, and it's you don't have a picture of your permit on Airbnb. So it sounds like the same thing, right? Well, what had happened is Mr. McPherson had downloaded several more photos onto the site. Unbeknownst to him, Airbnb only lets you put 99 photos. Okay, he had about 110 or 100 and some odd, and the permit was number 102. Okay, but he fixes that. And then lastly, we have a December 11th, 2017 allegation, and this is no permit and an advertising problem again, too many. This is a VBRO, or maybe VRBO, I get my acronyms mixed up. This is a VBRO advertisement. Mr. McPherson never rented the house through VBRO. It was always through Airbnb. He had the ad up since 2014 or 2015, but it was just simply never rented. And frankly, he just wasn't aware that it was out there. And I say wasn't aware. He had overlooked or forgotten about it. It just simply wasn't on his radar. Never booked it, never did business. I'm gonna stop at this point because I think, why don't you wait and go in rebuttal? If I could save my 4 minutes in rebuttal.
Okay, please introduce yourself with your name and address.
This gentleman here.
Yep.
Devin McPherson,
Address?
1431 Lichy Avenue.
Okay, we'll see you soon. Opposition, please come forward. You will have 10 minutes collectively, so divide your time up wisely. Please state your name, your address for the record, and why you're in opposition. And
My
any
name
other
is
people in
Cynthia
opposition,
Teague.
please come forward.
My name is Cynthia Teague. I live at 2172 Branch Oak Trail here in Nashville. I've been researching the Airbnb industry for about 3 years now. And this particular case is quite representative of what you're going to have before you in the near future. This is particularly egregious because this individual has been not only violating the over-occupancy, but he's actually putting public safety at risk. I've got pages and pages of documentation that show that he had 112 people there. He had 200 people, 223 people, 125 people. This just goes on and on. Not only that, this morning I also discovered that he is listing another property without a permit. At least it is on the site. I've turned it in through Host. We'll let him figure out how to resolve that issue. The bottom line is that many of these parties have been drug and alcohol related or alcohol related. Skip the drugs. The Joy Mansion has lived up to its name. And I think it's time that we send a clear message to the STR community that it's not going to be business as usual in Nashville. Thank you.
Hi, my name is Omid Yamini. I live at, oh, do you have a question? My fault.
You had some very specific allegations about numbers of people. Are you saying that people are staying there, or are you just saying he's having parties?
This is documentation that I pulled off of his Facebook pages where he's bragging about the number of people that were at his parties. That was up as of a few minutes ago. I made copies of it in case he decided to try and remove
Yeah,
this
can we see
listing.
that?
See that?
Any other questions? Okay, next.
Hi, my name is Omid Yamini. I live at 1204 North 2nd Street, Nashville, Tennessee, 37207. I actually live in the neighborhood next to this location. And, you know, again, I've emailed you my thoughts on this case. I think hopefully the codes administrators are going to also present information, so I'll keep my part very short. The things that they spoke on as far as his actions and were saying that they were unaware of, do you have a copy of his SGR permit in the file? Because I believe that it states bedroom limits, it states, you know, that the permit must be displayed. All of these things, I believe, are spelled out on the permit that must be signed. And if not, you know, I know from firsthand experience going down to codes and doing some research that they do give out the rules when you have to sign up for a permit. So I find it a little difficult to believe that this was not known. But I'm going to turn it over to other people in opposition. I'm asking that you deny this because your code staff has found plenty of evidence that shows that he has been in multiple violations. Thank you.
And next, please state your name and address for the record.
Hello, Matthew Bond, 3519 Gulf Street, 37216. And what else to say about this? The amount of prevarication that you're hearing is really getting ugly. Mr. McPherson, for example, does not live at 1431 Lishy Avenue. He lives at 1800 Porter Road, where he has an owner-occupied permit, where he's permitted to have 4 bedrooms, but instead he has 7. So this kind of violation on top of violation, this kind of incorrigibility needs to be nipped in the bud or stopped at this point. I just want to point out again that having a short-term rental is a permit, just like driving a car, just like having a driver's license. And if he had had these kinds of violations while he was driving, he would have lost his license. Thanks.
Mr. Summers.
Thank you, Mr. Chairman. John Summers, 5000 Wyoming. Can I ask the staff as to what the base zoning is on this property?
John Michael, what's base? Oh, he's not there. We'll ask when he comes back.
Well, this case reminds me, for those of you that have been around as long as I have, of the Timothy DeMumbrian case that Sonny West spent a great deal of time dealing with in this board did. Because what you have here is really, and I think even from the testimony of the legal counsel, Mr. Farmer, who I have great respect for, is that what's been happening here is beyond short-term rental. There have been business activities being operated here that really aren't allowed under an STR permit. And so we're basically having home-based businesses run here with clientele coming in, advertisement. There's alcohol being served as evidence on the Facebook page, and I have a copy that was also given to me by Ms. Teague, to where they're hiring bartenders for events at this party. This is way out beyond what a short-term rental is, and I would hope that you would uphold the zoning administrator's decision that there are 3 violations here. I think the council's going to be looking at this case real clearly, and Mr. Harper, the reason y'all are having so many of these cases is because people have learned in the public that y'all have the tendency, in their opinion and many people's opinion, of being too lenient, and that's why I gave you the ordinance that the council is proposing, because if y'all are...
All due respect, I really don't want to be lectured on how we enforce our code implied or code given.
Well, Mr. Harper, I have a First Amendment right to my opinion.
Sure you do. And we have been entrusted, and most of the cases we're hearing are not this type of case. This is a type 2. This is by far rare. I think the last time we checked, we were 90% were owner-occupied cases, and we get a little tired. I won't speak for everyone. I get a little tired of hearing councilmen bash us. We're not doing what we're supposed to do. It's your ordinance. You fix it.
And I think that's what's going to happen, Mr. Harper. I just was expressing my opinion, the opinion I've heard from many council
don't
members.
call me out
and you're
directly,
certainly entitled to ignore it at whatever value you want to put on.
Let's ask
But clearly, you've got a type 2 permit here. You've got a zoning that doesn't allow a lot of the activities that's having here. And I would urge you, your staff does a lot of hard work. I would hope that you would abide by the findings of your staff.
Okay.
Thank you,
Thank
Mr.
you.
Chairman.
Mr. Osborne, please come forward and While we're here, John Michael, what is the base zoning of this property? And
RS5.
Okay. Okay, Mr. Osborne, how'd you hear about this? Do you have any not having a permit violations and any other information that you have that is relevant, any complaints or anything like that?
I couldn't find any other complaints about this one in my emails. These complaints started back, it looks like in January of last year, with Sandy Custody, who was doing this at that time, sending them a letter for excess occupancy.
So that was one.
That was one, and they were advertising for 7 bedrooms and 16 people on Airbnb.
When was that?
January 27th.
Of this January?
January 27th of 2017.
A year ago. Okay.
And she marked it complied on February 13th of 2017.
Okay. Any questions for Mr. Osborne? Okay, we're going to have the applicant come back and we'll hear. This is rebuttal time, so.
Mr. McPherson wants to take the final 4 minutes.
I just get 4 minutes?
Yep.
That was a lot. Okay. We all know the historical significance of the house, built by General William White, Tom Joy Elementary. After their business fell into disrepair 60 years ago, the house fell into disrepair. I moved into it in 2011 in horrible condition. The before and after photos in front of you dictate the improvements that I made on my own dime. The reason that this house has a Type 2 permit is because I don't own it, and the owner currently does not live there, so it's the only permit that I could get. I do, however, have a third-floor apartment, and unbeknownst to the opposition behind me, I actually stay in the house during almost all of my bookings. The parties that they mentioned were from 2011 through 2013. We were indeed shut down for throwing parties in 2013. Ariana Evans' letter of testimony details that in depth at how years ago I was a huge nuisance to the neighborhood, but was arrested, made amends, and became a good member of the community. Tom Joy used his good fortune to build up others around him. Living here gives me a sense of great pride and a fiduciary duty to give back to the community that has helped me thrive. If you flip to the last 2 pages, if you flip to section 2, you will see letters from neighbors and community members. The opposition behind me does not live in Highland Heights. Not a single one of them lives in Highland Heights who have any information detailing the workings of my business. However, the letters that I have submitted to you do, from our steering committee, from every single next door neighbor, and the people in my community who we make a difference for. My staff is hardest hit by this revocation. Courtney is my head housekeeper, a single mother with a 9-year-old boy. She has worked for me for 3 years and is without a doubt the best in Nashville. She never complains, shows up early, stays late, and focuses on the intangibles. Matt and Angie are a husband and wife team. With my business on hiatus, they have been unable to pay for their apartment and are sleeping in their car. They stayed at the house last week while they figure out their situation. This brings us to section 2. Since I'm brief on time, I will go through it following the 12th letter, section 3 of the binder. There are numbered pictures in numerical order. Number 1, we have used the house to host music videos, community meals, and movie nights, and most recently as a free practice space for local musicians. However, none of these are the parties that the people behind me are speaking of. Those were years ago, and were long ago shut down. Number 2, we do put on shows where local band performs and all the neighbors come out. We replace all the usual art with local artists, sculptures of driftwood and paintings temporarily along the walls. We allow these paintings to be purchased by guests, even in the Airbnb, with artists keeping 100% of the profit. Number 3, as a member of the Highland Heights Neighborhood Games team in 2017, we competed against 22 other neighborhoods. As captain of the team, we won $500 for Highland Heights. Number 4, the same soil that Tom Joy tilled 150 years ago makes a community garden that we are aggressively expanding. Number 5, although not pictured, I donated $500 from the profits of my business directly to the Highland Heights Neighborhood Association to help with aid and repairs for the community. Number 6, when Hurricane Irma hit, I organized a Facebook page to put up refugees. We put up hundreds of evacuees in town under a dry roof, and Channel 2 ran a story on us. Number 7, although we require guests to properly resort recycling and trash, I spent an evening resorting after checkout because we do our part to keep green. Number 8, we deck our house out for the holidays with homemade gravestones I made when I was a child with my dad, and hundreds of feet of Christmas lights that stay on until spring. You can drive by tonight. They come on at 5 o'clock. Number 9, this is Susan Joy. She is 83,
Susan is direct descendant of Tom Joy. She lived in the house until 1959, her wedding day. She is a friend and has helped answer many mysteries of the house. The irises that you see pictured on the property were donated by her, a wonderful connection to the gardener of the past. I don't believe that the allegations that have been levied against me by the people behind me have any knowings of the workings of our business or the work that we do with the community. However, the letters in front of you very detailed and very eloquently state our impact on our neighbors and our community and what's important to us. I reiterate again that the parties that we threw were pre-2013, and we have had no illegal activity whatsoever since that time. Thank you.
Any questions for the applicant?
How long have you had the permit? It was 14, since 2014?
We started Airbnb in 2014. The permits became a thing in 2015. We immediately got one. The house was sold in 2016 to Mr. Reinhold Holdkamp. Ned Horton owned the property before. Mr. Horton had a permit, then Mr. Holdkamp got me a permit. Again, the reason why it's not a type 1 is because I don't own the house. I tried to buy the house in 2016, but unfortunately I was outbid by Mr. Holdkamp. On the same day that I submitted my offer, Mr. Holdkamp submitted a cash offer to Mr. Horton, and the house was sold, and Mr. Horton profited off 75 grand of my hard work that I put into the house. Instead of kicking me out, Mr. Holdkamp and I became friends, and we've worked very hard together to continue restoring the property.
So, go ahead. Go ahead.
John Michael, this is a 3 strikes case. Kind of explain to the board about what we're really...
3 violations in 1 year equals a revocation.
Okay.
It's been consistent in application. We've not seen as many of those cases, but obviously that's an appealable action to the board, and the board can determine whether or not those were in fact valid grounds for revocation under the law. I would note, Mr. Chairman, I think we may have gotten cut off during one of the back and forths before Mr. Osborne had completed presenting some of the evidence to you. May be appropriate to hear from him again since he was accidentally cut off.
Sorry, Mr. Osborne. We always want to hear from you, and of course, you're off the clock. You can spend as much time as you want.
All right, so like I said, this started back in January under Sandy. That also came back into violation sometime around June, in which we sent another abate notice on June 30th, and with a follow-up date of July 21st. Again, for not showing the permit number, the advertising too many bedrooms and too many people, had to take them to court to get this action remedied.
Is that still pending?
They were fined $50 in court costs at that time.
And the court didn't take any other action?
Not at that time.
Okay. Any questions for Mr. Osborne?
There's also another case that came up in November. So
a court case?
Not another court case, another abate notice went out.
Okay. And what was that based on?
This was the one that I believe they referred to as posting too many pictures, so the permit number was bumped out.
So this was the second or third strike?
Well, technically it's the third one, but there's still another one to come. Also, we noticed that there were numerous listings for separate rooms on that as well.
What do you mean by that?
So they're advertising the King Suite and the Nashville room, the London room, the Paris room, the India room.
So explain to everyone why you can't do that.
Can't do that because you can't have simultaneous rentals at your property.
So you could have one Airbnb party or short-term rental person at a time, not like, okay, someone from Texas, someone from Kentucky, someone in Florida, all at the same time. The same group. The same group renting it under a common rental.
And I believe that was, they may have been left over from the Eclipse.
Okay.
And then again, on December 8th, received another complaint that they're hosting large groups. And this is regarding their HomeAway advertisement, which was advertising for 4 bedrooms and 16 people.
Yep. Okay. Questions for Mr. Osborne? Thank you again.
So, I don't know if we...
We're still, you questions for him?
Oh, no. Oh, I'm sorry.
We're still public.
Oh,
okay. Yeah, I mean...
May I speak?
Well, you have no time, Mr. Farmer.
There's so much more to add.
There's so much. Let me ask
Just in response to John Michael's comment about the law, I don't want to re-argue what's been said. if I can. If I can't,
I will give you 30 seconds quickly.
Thank you. And I think the law is that after 3 strikes, the permit may be revoked. So there's no mandatory revocation. And what I believe this board is called to do is look at the things I've outlined, the nature of the revocations, the nature of the property, how Mr. McPherson has handled himself, what he has done. We haven't heard about noise complaints, police, is all that. The complaints we've heard, the proof is those were pre-2013.
Got it. 30 seconds.
Thank you.
So
I do have a quick question, and maybe this was covered. There's been a lot of information covered. When does the current permit expire?
May.
Okay.
The current permit is revoked and does not exist.
I'm
Theoretically, if it still
Were
existed.
it not for this,
I'm sure that's the right
it
answer.
would be May. Okay.
The issue is that if you do not vote to immediately reinstate our permit, we will never be able to rent the house out again, and all the work we do for the community will go away with the passage of 608 last week.
it can't become a bed and breakfast?
Unfortunately, with the state of the house that it is in now, it still needs at least another 50 to 60 grand worth of work. And we've been doing the work with the profits of the short-term rental business.
But it can become a bed and breakfast if you pay for it.
It's not, again, I don't own the property.
Okay.
I wish I owned the property. I tried to own the property. We have cease and desisted all operations. I've refunded thousands of dollars in bookings.
Okay, so one of these strikes seems a little bit of a technicality about, let's assume you posted all these pictures there. How come you didn't figure out the one that you needed to by law?
It turns out that it was an error in the Airbnb system, and I brought documentation showing that they themselves weren't aware of this. We had 102 pictures on the
How's
listing.
an error in their system if they say you have 100 pictures and you should be able to find one of those 100 to comply with our laws?
May I respond?
Yes.
The platform allows you to upload as many photos as you want as a host. I had 102 photos. When I look on my platform as an editor, I see all 102 photos. However, to a potential guest, or in this case, a codes officer, they only see the first 99. They do not see photo 100. My permit, which we had just been cited for over the summer, and I was very diligent to make sure that we were following the rules, was picture number 102. I had no notion whatsoever that this wasn't being shown. I contacted codes. I sat in John Michael's office. I explained this to him, and it fell on deaf ears.
Well, I mean, it's not his decision to kind of make.
I understand.
Questions for the applicant?
How many bedrooms are you supposed to advertise?
4.
And are you doing that
Sorry.
properly?
Yes.
How many times does Metro have to tell you that to learn it?
We were cited once that we received in June.
And you've corrected that?
Yes.
Your opposition seemed to say otherwise.
The opposition mentioned parties predating 2013 with hundreds of people off of a Facebook page that is apparently still public when we used to use the house as an event space. As I said before, the letter from Ariana Evans.
The parties aren't on a strike, so that's just a...
I understand.
You know, we're not going to talk about
And I think to clarify, he got the notice in June. That there was the December notice on the, I thought it was VBRO, maybe it was Home Away, but on the site that he didn't use. So I don't want you to think there's equivocation.
Mr. Counselor, 3 strikes here. Why shouldn't there be 3 strikes? Codes did their job.
Well, because I don't think it's just but for. I think what this board does then is evaluate, so what do we do, even if there is 3 strikes?
Actually, I think it's 4.
In excess of.
In excess of 3.
Oh, I see. I understand.
So, you know, there's a reason for 3 strikes. So what's the argument here?
The argument is that the strikes are, using my term, ticky-tacky, and the reason that you guys have discretion is so you can take technical strikes, to borrow your honor's term, and weigh them appropriately. That what he has done with this property and with this house is frankly extraordinary. And if you can look through the binders, you can see that. He is a good Airbnb host. He is a good community member. To revoke this man's permit when you have the discretion to not do that in the face of, again, ticky-tacky strikes, I think is not...
Were any of the strikes not ticky-tacky?
I'm sorry?
Were any of the strikes legitimate? What about the 16 people? That's a legitimate strike, isn't it?
Well, legitimate, but... I mean, they're all against some sort of a code, certainly. But I think what the...
No.
And I would just say, as sitting up here trying to listen to the rebuttal, there's a lot of movement from people that spoke in opposition. It's distracting, and I find it very inappropriate.
Mr. Chair, we were held.
No, I'm sorry.
No,
The applicant has not been.
you're not at the table. The public hearing is closed. It's completely inappropriate.
Okay. Okay, counsel.
I guess what I'm trying to do is distinguish between a speeding ticket and a DUI.
Okay.
That's the distinction I'm making. Are they both technically against the criminal code? They are. They are. But clearly, one is more serious than the other, and these violations are more along the lines of a speeding ticket.
Okay.
So,
We're going to close the public hearing.
okay.
Discussion.
Given that there's been a lot of information thrown out today, I just want to make a couple of clarifications to make sure that the board is on the same page before you have your discussion. There was one question about the environmental court case and what happened at that point. The $50 fine was, the law says that the 3-year injunction in court applies if it's for operating, if they're found guilty of operating without a permit. My understanding is that the warrant was issued for advertising without the picture. That by law only mandates the $50 fine. So that's why that was a $50
So
fine.
not to interrupt, but that is counting as one of the strikes.
I believe so, yes. I believe there were 4 strikes, and that's one of them. And that was my second point, was that just because y'all have not had many of these revocations, I just wanted to get with crystal clarity what the law with respect to revocations are. It says if the zoning administrator determines based on reasonably reliable information that 3 violations of this section or other code sections referenced in this section have occurred within a 12-month period, the permit to operate an STRP may be revoked. So it is correct that the revocation is not mandatory according to the law. However, my understanding is that codes routinely applies a revocation for 3 strikes in an effort to be consistent and apply the law evenly across the board. This is an item A appeal of that revocation. So your task.
Why doesn't it say must, Counselor?
They're giving the zoning administrator the discretion, I believe. So I believe that's why, if it said must, then the zoning administrator would have to. It says
But
maybe.
it doesn't. That's what they said.
Correct, it says may, so it's discretionary. However, as a policy and practice, I believe across the board, they apply this. If there are 3 strikes, they exercise that discretion and exercise that authority that they're given to revoke the permit. You're tasked with an item A appeal for a revocation. You were tasked with determining whether the zoning administrator acted in error or arbitrarily in exercising that authority to revoke the permit. If you determine that he did, then the permit would be reinstated immediately, or the revocation would go away. If you determine that he did not, then the revocation stands for a year.
Okay, I'd like to hear from Mr. Osborne
I'm
again.
sorry, can I ask, before we get to Mr. Osborne, so are we tasked with deciding on each of the strikes if they're appropriate or not, and then that informing our decision, or are we to just decide, well, there's 3 strikes, should it be revoked or not? Do we consider each individual strike?
I think, the item A appeal standard is that if you determine that the zoning administrator acted in error or arbitrarily. So I think if you determine that one of the strikes was arbitrary or was an error, then I think that you need to state with specificity how it was an error or how it was arbitrary.
I didn't want to get too far in the weeds, but we are at 4 strikes?
That is my
Officially?
understanding, yes, and Mr. Michael can speak to that, but yes, there are
before we start
4 strikes.
deliberating,
Thank you,
we're going,
Thank you,
okay.
Mr.
Mr. Osborne.
So I believe the reason that it wasn't submitted at 3 is because there was Mac and me both working on these cases throughout the year, in addition to Sandy. So I believe that may have been overlooked whenever.
So was it 3 or 4?
It's 4. It is
But
4.
did they get notice of 4 or notice of 3?
Yes, they got notice of 4. They were sent the abate notice for every one of them.
Okay.
Also, I would like to add that one of the most recent advertisements from March was advertising for a bartender to have a party there at Joy Mansion, which was brought to my attention by various people in opposition, and I did provide packets of that to all of you.
Is that a violation of our short-term rental law?
Having 40 people at the site, definitely. You cannot have more than 12.
But even if it was a party, not like staying overnight, that's what I'm saying.
That's not how the ordinance is written.
Okay. John Michael.
Was that tied, I looked at that, but I only looked at it quickly. Was it tied to a short-term rental?
Or is it just a separate event? Because if someone has a short-term rental, and one night they have a short-term rental, and then another night they just have a party,
The
John
ordinance-
Michael, you could do that, right?
The ordinance doesn't say that you can have 50 people there when you're not running a short-term rental. It just says you can't do it. So that's how I interpret it.
I'm sorry, I just
You-
couldn't hear you.
The short-term rental ordinance says you can't have more than the maximum number of rooms times 2 plus 4 at that property. So it doesn't say if you're not using it as a short-term rental, you can have 100. So that's how I apply it.
Interesting question for our
John Michael,
council,
so
and
if
our council.
someone has a short-term rental, one night they rent it out legally, short-term rental, but then the next night they have a party for 100 people, totally unrelated to renting short-term, can they do that?
Can they?
Yeah.
Sure.
Is that a
Is it legal to do so?
But is that
Fair
a
question.
violation of the short-term ordinance?
The regulations associated with the short-term rental permit and STR usage are unique to that usage. So I don't know that the ordinance necessarily excludes the ability to have a great big old 100-person rave the night after you've completed your short-term rental operation. It's worthy of note that service of either food or drink in conjunction with short-term rental use is specifically explicitly not allowed under the ordinance.
Okay, so.
And I will elaborate. I agree with Mr. Michael. To the extent there are any violations of the code, at the party, I think that is something that can be considered by the zoning
strike on-
administrator when
okay.
determining strikes.
Please go through the 4 strikes again, so as we get ready to deliberate, so we know what has been charged.
What each one is. There are 4 specifically identified in the revocation
And the
notice and
date,
revocation
please, too.
letter. I don't have the dates in front of me.
Oh, okay, well, just the strikes are fine. Strikes are fine.
The strikes are all from 2017. They are case number 17-1151966, item 17-1160601, item 17-1170888, and the most recent one, 17-1172214. Of note, the 17 at the beginning of those numbers indicates that they all happened in the year 2017.
Okay, so tell
obviously
us
within
what they
12
are
months.
again, as opposed to the numbers.
So-
Mr. Osborne.
The one in January is for excess occupancy. The one
How many?
advertising, how many?
Yes. Is that the 16 one?
I believe so.
Okay. In January last year, what's the next one?
Yep, they're advertising for 7 bedrooms and 16 people in January.
Okay, next.
And at the end of June, they're advertising for 7 bedrooms and 16 people.
Okay.
Was that the one where that notice went to the property owner?
Yes, all notices go to the property owner.
Okay, what next?
On 11/13, that was a notice for the permit information not being displayed.
Okay, the famous 101st photo. Okay,
And then again in December was for advertising for 7 and 16, or 4 and 16.
4 and 16. Averaging for 4 bedrooms and 16 people.
Yes, sir.
And that's it. Okay, thank you. I'm going to close the public hearing. Discussion. So this is a strike case. So as Mr. Michael said, we have to look into whether these were done correctly or arbitrary, and if they are, do we uphold the zoning administrator or overturn the strikes? And thus, if they have 3 strikes, they lose their permit.
Okay, so I've got one more clarification. There is no permit at the moment. I get that. Were it still in effect or applicable, it would go through May. So when you get the 3 strikes and when your permit is revoked, at what point, without appeals or anything, would they be allowed to reapply?
The ordinance reads, once a short-term rental permit has been revoked, no new permit shall be issued to the applicant for the same property for a period of 1 year. I read that to say, once it's revoked, they can't apply for a year, so I believe that's from the revocation.
And John Michael, obviously the Metro Council kind of weighed in recently. How does this case affect that?
608 does not allow the issuance of Type 2 permits in R and RS zoning districts. This is an RS zoning district. This is a Type 2 permit. So a new application today, a month from now, a year from now, absent any other change in law, would be rejected because it does not meet the requirements of the
new law,
Council Bill 608, as amended and filed and as is effective law today.
Yep. Okay.
And I believe that's what Councilman Davis hours ago was referring to, possibly rezoning.
Right. Of course.
Thank you.
Discussion.
I mean, we're not talking about 3 strikes and maybe one is ticky-tacky. I mean, there's extra. We can give them one, and they're still at the point where they're going to lose it. So,
It depends on if you. What do you think of the strikes?
What do you think? I haven't seen anything that seems arbitrary or capricious in the application of these strikes.
Well, I think we've only had maybe one other case that dealt with 3 strikes that I remember. We're dealing with the Type 2 permit, which are unpopular to say the least. It seemed like it took an inordinate amount of time and resources to get compliance on some of these things, even though I would generally agree that they are not of the sort of complaints that are upsetting otherwise. At the same time, we had a councilman who came in here and spoke quite eloquently about his opinion about the positive nature of the contribution of this business to the neighborhood. And without question, based on what we've seen, it's had a renovation both outside and inside. So I've got to think about that. I'm curious what other people think.
Well, I would think that the only way to maintain a permit is for us to find 2 of the strikes were in error. I think, legitimately, I think that's, if that's the direction that we decided to go. And I hear what you're saying, and I agree to, I agree to a point, but I think finding 2 of these that justifiably we could say.
Well, what's the, Counselor, what's the standard here? It's either upheld or it's.
Yes, because it's an item A appeal of the revocation, you either determine that the revocation was properly issued, in which case it stands, or you determine that the revocation was issued in error or arbitrarily, in which case it would not stand, and he would still have the permit.
In error or arbitrarily, or it stands.
I mean, I'll entertain.
So as you know, most of the offensive kind of complaints that we get are noise or operating without a permit. They had a permit. They just advertised for 16 people 3 times and then didn't figure out how to put their permit on the visible 99 pictures that go online.
And that is not out of line with the other types of errors that people have come in with. We used to get a lot of they were being penalized for advertising, and the only reason they were advertising was because they had to bring up their page to show them that they had the insurance, and then they didn't know they had to turn it back off. So that, that's a possibility.
And then one of the strikes, they said it went to the wrong person or went to the property owner, not them.
I sort of would also to contribute to people's consideration. I personally do not find the printing the license online to be, I think that was a legitimately explained issue. So I'm really not concerned about that. I also think, based on what our council has told us, the way the zoning administrator enforces this is he is not looking at the underlying rationale. He's looking at the number of strikes. And so it's before us, not because that's just what their policy is, and I appreciate that. But we've also not gotten a recommendation from him, which he often will do if he has a strong opinion one way or the other.
I would just like to make,
Mac,
I would just like to make one clarification. The notifications of violation are always sent to the owner
property owner.
unless the contact is listed. Mr. Holcamp is listed as the owner and also as the contact. We have no other alternative as to where we may send it. So all of these notifications of violation have been sent to the owner.
Absolutely. I'm about saying that I'm not suggesting that anything was done
Wrong.
in that regard. It's certainly on this applicant and his lack of communication, not
Yes.
you at all.
Thank you, Mac.
What do you think, Ms. Hampton?
I keep, excuse me, I keep thinking about Councilman Davis's plea and the letters that we have. And
From the neighborhood.
Right, from the neighborhood, very, very supportive. And no one has said, traffic has been a problem. It's just not, there are no complaints from the neighborhood.
So who has a motion?
Okay, here's what, take it how you want to, but here is my general thinking. I'm not a huge fan of the type 2 permits myself. However, I think if you look at how we handle the other violations that come before us, for these types of violations, on a revocation, we would not put the person in a situation not to be able to have their permit again. And I think these are the types of violations that we would allow a type 1 owner to at least have an opportunity to reapply. This person would not have the opportunity to reapply if we uphold the zoning administrator. And because of that distinction, I am going to make a motion that the zoning administrator acted arbitrarily and that the revocation did not properly occur.
Okay. Motion's been made. Motion's been made. Is there a second?
I'll second.
Okay. Motion's been made and properly seconded. Discussion. Seeing none. All those in favor of the motion signify by saying aye. Aye. Opposed? Abstentions? Is that a no, Mr. King?
No.
Okay. Is that a yes?
I'll say yes.
Passes 5-0. John Michael.
Mr. Chairman, the next case to be presented to the board is case 2017-443. Jeff Seal is the appellant and owner of the property located at 925 Archer Street. The request is for a variance from the sidewalk requirements in the R6 zoning district. The property you see here highlighted on the zoning map is just sort of at the end of two separate sort of cul-de-sacs, one a turnabout, one a cul-de-sac, here just south of downtown. The aerial map shows the undeveloped lot. The site plan submitted demonstrates the proposed layout of the construction at this location on Archer Street. And from my recent site visit, you see to the interior of the property from the street in the lower right-hand corner and the view directly across the street in the upper left. The views back into the cul-de-sac and down Archer, demonstrating the absence of any current sidewalk at this location. Are there opponents to case number 443 in the audience? Seeing none, the appellant will have 5 minutes to make the desired presentation to the board. Please introduce yourself by name and address.
Jeff Seal, 925 Archer Street.
John Michael, can we clear the gallery?
There's a button there you need to push.
Yep, let's
There
get
you go.
going. Okay, go.
Okay, Jeff Seal, 925 Archer Street. I got an email that I sent to Colby Sledge, my council person. I'll just read that, kind of summarizes everything. It just says, Colby, I filed a notice of appeal hearing for my property at 925 Archer Street. I'm building a single-family house for myself here and plan on moving in when it is complete. The appeal is on Thursday, February 1st. The appeal is for the sidewalk requirement. My lot is very unique and is in between two cul-de-sacs. See attached site site plan. I sent them the site plan that y'all have. I have met with Bill Herbert and Hal Balthrop about the issue. Bill's suggestion was I file for an appeal and contact you to let you know I was doing so. The ordinance requires I pay $178 a foot for frontage or build the sidewalks myself. Because of the funny shape of the lot being situated on two cul-de-sacs, I have 250 feet of frontage, which comes out to $44,500. Due to the topography, it will be very hard to install the sidewalks on the south side of Archer Street. The front yards are very steep, and it would require a substantial retaining wall to be built. I don't want to get out of anything and want to pay my fair share, but the $44,500 seems a little excessive, especially since I own the property prior to the sidewalk ordinance. The rest of the lots on my side of Archer are 70 feet wide or less. I was hoping through this appeal I could get the frontage reduced to 70 feet and pay $12,460 versus $44,500.
And Councilman Sledge's response was?
He says, thanks for the email. I drove by your property and looked at the maps today. I think your compromise proposal is a good one, and hopefully the BZA will be willing to compromise as well.
Okay, we have an email from Councilman Sledge saying the odd frontage of this property calls for a compromise. I believe the applicant is promising something like 70 feet worth of payment in the lieu fund. I trust the board will find an adequate compromise. So, there you go. Anything else to add? Okay. Any questions? Closing the public hearing. Discussion.
This is unique. I have never
All these
seen
sides of a cul-de-sac. So 70 feet, reasonable, Mr. Architect? Okay. Motion, someone.
I make a motion that we grant the requested variance and approve planning's recommendations.
Okay. Motion. Planning's about 70. Is it 70 feet? Okay. In lieu fund. Is there motion's been made? Is there a second? Motion's been made and properly seconded. Any discussion? Seeing none. All those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. Good luck. John Michael.
The next case to be presented to the board is 2017-445. The appellant is an entity called TransCanada. The owner of the property is Columbia Gulf Transmission, LLC. The property in question is described as 992 Barnes Road. There's a large parcel along Barnes Road in southeast Davidson County. The request is for a variance from the sidewalk requirements in the AR2A zoning district. The aerial here shows the undeveloped lot along Barnes Road that sits between Nolensville Road out to the far west and a portion of Old Hickory Boulevard to the east that shoots off of the main Old Hickory Boulevard, 231, more to the north. The site plan submitted gives a proposed layout of the construction that will take place for the compressor station. You'll notice the relative proximity to Barnes Road in this. I think other documents either have been or are being submitted with regard to the landscape plan also associated with this project. From my recent site visit, although I did not walk the entire 2,350 feet of frontage that are at issue with this request, they give you an idea of the undeveloped nature of the property with the picture in the lower right-hand corner, and then the views up and down Barnes Road as they currently stand in this slide. The appellants are represented and will have the opportunity to make the desired presentation to the board. Is there still opposition present in the crowd for 445? There is. So both sides will have 10 minutes to make the desired presentations. For the appellants, feel free to save whatever portion of this time for your rebuttal. For the opponents, do make sure to divvy up the time as you see fit with the 10 minutes allotted to you. And we'll distribute any other documents that are needed. Gentlemen, please introduce yourself by name and address.
Well, good evening. My name is Alex Stroman. I'm a Government Relations and Community Affairs Manager for TransCanada, which is parent company of Columbia Gulf Transmission at 992 Barnes Road. I'm joined today by our project manager, Jared Ciarella, and Brian Stauffer of Stahl Schaefer Engineering. We appreciate the opportunity to speak briefly with you about our request for a variance from sidewalk requirements in the AR2A district. Additionally, we have read the Planning Commission's recommendation that is before you today, and we are in full agreement that a fee in lieu is the most appropriate solution for this site. The physical characteristics of this property create a peculiar and exceptional hardship for installing sidewalks. There is no shoulder along Barnes Road in this location, and directly adjacent to the travelway along much of the property frontage is a small swell next to a steep wooded bank. The installations of sidewalks in this location would require significant excavating and grading, which will be detrimental and difficult to construct. Since our initial conceptual drawings for this site, we've taken great care to reduce the impact of this development on nearby residential zones, including significant foliage screening to create a visual, noise, and lighting buffer for nearby residences. An important aspect of this plan has been keeping the existing mature foliage located on the property. The physical characteristics of the property frontage area as we found them, and we have not planned for their removal. To the contrary, we have worked with residents and homeowners association leaders in the communities across Barnes Road who have requested that this site be as richly screened by both existing foliage and planned additional landscaping as possible to help eliminate visibility of the project. The proposed landscaping plan, which omits sidewalks, was designed specifically to the benefit of neighboring landowners. Not only would installation of sidewalks remove existing mature foliage on this bank, it would limit our ability to install additional natural buffers, in direct contradiction to the request of neighbors. There are currently no sidewalks on Barnes Road, and if built, these would only be along our property line, essentially a sidewalk to nowhere on a very small portion of our property. As I stated at the outset, we believe that a fee in lieu is the most practical solution for the community. Paying into the fund would hopefully benefit the homeowners in this area, and we hope that usable sidewalks would be built in suitable locations while also maintaining the requested foliage barriers in the site plan. We are more than happy to make this contribution, which would be considerable. We've already been issued permits by the Federal Energy Regulatory Commission and air permits from the Metro Department of Public Health. We plan to move forward with construction once we satisfy all the expectations of Metro on this facility that's preempted by federal law. We come before you asking for a variance on the sidewalk requirements, not for the benefit of our company, but for the benefit of those surrounding our property. My company and our employees take very seriously our mission to safely, responsibly, and reliably transport energy used by millions in North America each day. We also take seriously our charge to be a good neighbor in Cane Ridge and the greater Nashville communities, as we have been for 60 years. In fact, it is in that spirit that we come before you today seeking this variance. We know that it's your job to take full consideration of our variance request and the recommendation from the Planning Commission, and we would not ask for or expect anything less. We hope that when considering our variance, you will arrive at the same conclusions we have. The hardships are not self-imposed. It would not create an inconvenience or harm to neighboring property. It would not compromise the design integrity or functional operation of facilities within the PUD, and financial gain is not a contributing basis. Thank you for your time and consideration today, and Mr. Chairman, I request to reserve the balance of my time.
Okay, so the other people will speak during rebuttal. Please introduce yourself.
My name is Jared Cirella, property
Address.
project manager, 992 Barnes Road, Antioch.
Brian Stauffer, Stahl Schaefer Engineering. I'm heavily involved in the permitting
Address.
coordination with Metro. What's
Address.
301 Science Park, State College, Pennsylvania.
Okay, you'll have 6 minutes and 27 seconds left for rebuttal. We're going to hear from the opposition.
Thank you.
We have 10 minutes cumulatively, so pick your people and let's get going. Whoever wants to speak in opposition, please come forward now. Please identify yourself for the record with your address.
And thanks for sticking around. It's been a long day.
Oh, thank you, guys. And we do want to take a moment to say thank you to Councilman Fabian Bedney for speaking earlier.
And we have a letter from him too, as well.
Excellent, thank you. Well, I'll start. My name is Heather Hickson. I reside at Stanford Village. My address is 701 Kelsey Court, Cane Ridge, Tennessee, 37013. I do have many others that will give you their names and addresses when they speak. I am here representing Keep Southeast Nashville Healthy. I have a letter I'd like to read to you. I am president of that organization. This is regarding case number 2017-445. Keep Southeast Nashville Healthy, a community group dedicated to keeping our environment, living areas, and property investments healthy, are here today to ask that you do not allow a variance to be issued to TransCanada in regards to the sidewalk on 992 Barnes Road. We feel that having a sidewalk in this highly populated area is imperative for the continued growth of Southeast Nashville and for the safety of its residents. We feel that TransCanada shall face no financial harm by building this sidewalk and helping build our city for the future. The very essence of the sidewalk law is to have detailed and underscored the importance of safe pedestrian facilities and their connection to improved transit systems and growth in identified centers. Barnes Road is a major thoroughfare in the Southeast Nashville area with connections to the Mill Creek Greenway. The subdivision Stanford Village, directly across the street from the property in question, has extensive sidewalks throughout, including to its entrance on Barnes Road and onto Barnes Road itself. This subdivision directly connects to the Mill Creek Greenway. As you know, the bill explicitly states that in lieu contribution fees are not an option if there is a sidewalk adjacent to or on the same block of the property in question, which there is. In this specific case, the answer is very clear: the sidewalk should be built. We feel that it is imperative that our local residents can safely exercise and travel between subdivisions and the Greenway. Therefore, TransCanada should not be granted a variance to pay into the sidewalk fund, which may not directly help the citizens of Southeast Nashville. Thank you so much for your time.
Who's next? State your name and address.
Hi, I'm Brant Miller, and thank you. I'm Brant Miller, and I live at 13566 Old Hickory Boulevard in Cane Ridge, and I'm the volunteer chair of the Friends of Mill Creek Greenway, which she just mentioned. And as a chair, I represent the many users of the nearby Greenway, which is right there. It's about a 2-mile trail that ends at Old Hickory Boulevard, just several hundred feet down from Barnes Road, where this property is going to be. And we feel that as users of the Greenway and people in the neighborhood, it would be very important to have a way to get down Barnes Road from some of these areas, to walk to Old Hickory, where it's a short distance to connect to the Greenway. And there's a new extension, a 2-mile extension going to Orchard Bend that will be completed by next year, and it's going to be a large area. So a lot of people will be using that, and including people from these neighborhoods. So we feel that sidewalks are essential to get started in this area and to help the residents to have a safe way to get to the Greenway. And we do not feel it is a hardship for the Columbia Pipeline to build this, and so we hope that you will refuse that variance. Thank you.
Okay, next, name and address.
Hello, my name is Sue Goodman, 3833 Grant Ridge. I live in Hidden Creek, just at the bottom of Barnes Road there, just below your photograph. We too feel that this sidewalk is really necessary because as they have so eloquently stated, there is a white line and a ditch and a hill. And there is no easy way to get up and down Barnes Road. This area is going to connect up to the new soccer field that the mayor is building for us. Just at the bottom of the hill, little ways over, there's going to be the connection for the Mill Creek, and that's going to run directly to those soccer fields. So if the compression station is the quiet, invisible, wonderful neighbor that they purport to be, these rural areas are going to become homes. And those homes are going to have kids, and those kids, are going to have moms and dads, and they're all going to want to be able to go down to the parks and go to the Mill Creek and come to our movie nights and to join in the activities of the area. And you cannot walk or bike along Barnes Road in any way, shape, or form at this time. It's dangerous. As far as them cutting down mature things, where there is the ditch and then the hillside, that hillside is a natural buffer. Further on down, where there is the white line, the ditch, and a field, there isn't much vegetation there anyway, and there would be a whole large area for them to add vegetation or a wall for soundproofing or whatever else they would need near that construction area. Thank you.
Okay, quickly, who's next?
Yep. My name is Jim Tokarski, Tokarski, 360 Upper Mill Drive, Cane Ridge, 37013. Briefly, I've been to, when this whole project started, we took a trip down to Hartsville, Tennessee, and saw a gas compression station, existing one. And this is quite a fortress. I mean, this is a big deal for our neighborhood. And Columbia Gulf is spending hundreds of millions of dollars to build this thing. And now they're saying they can't afford a sidewalk because it's extra construction or something. Our main focus is the safety, so the people can walk to the Greenway, walk to the new soccer field that's under construction. Considering the total budget they must have for this job, the hundreds of millions of dollars, we don't think, a decent set of sidewalks in that area is an undue hardship. Thank you.
Next.
My name is Chris Strong, and I live at 6323 Pettus Road, Cane Ridge, Tennessee 37013. I think that picture is a little misleading. That is the site where they're going to build. That's the acreage that they have purchased. However, if you look at our whole community in South Nashville, there are no less than 5,000 homes currently either planned or under construction right around here within a 2-mile radius. So we need these sidewalks because all of those are going to have sidewalks. And if we don't have a sidewalk fronting this property, there is no way that people up Barnes Road or on Old Hickory will be able to get, as the other people have stated, get to all of our parks and to our schools. We want walkability. We're getting this huge liability. The least we can get is some benefit from it. So please deny the variance.
Okay.
Thank you.
Next.
My name is Gwen Orr. I live in Stanford Village. We really do need the sidewalks. We have large communities out there. We have hundreds of children out there. My feeling is also maybe a little different. For what it's doing to our neighborhood and the impact that it's going to have, my personal feeling is the least they could do would be to put in the sidewalks for us, because it's going to hurt our property values and everything else. Our neighboring neighborhoods, that's basically what I wanted to say. We really need the sidewalks, and it's the least they could do.
Okay, thank you. Any questions for the opposition? Any other people to speak out in opposition? Okay, very good. We're going to hear from the applicants again. You'll have your rebuttal time.
Ready for me to start now?
Okay, so you heard everyone. This is your chance to respond.
Yes, sir. Well, just simply, today, again, we're asking for a variance from constructing impractical sidewalks on our property lines along Barnes Road. There are no sidewalks within our blocks. They're many blocks away. We're not anti-sidewalk. We think sidewalks are good things. That's why we've requested and support the Planning Commission's recommendation to pay into a fund for sidewalks in appropriate areas of the neighborhood. But
So
this is not
a
an
big piece of
appropriate
property.
site.
So how many feet would you be?
So it's approximately 2,350 feet.
Okay, and how much does that come to?
A little over $400,000.
Into the sidewalk fund?
Yes, correct.
And you're saying you pay that instead of building the sidewalk?
Yes.
You're willing to do it?
Yes, absolutely.
Which I think would be the largest amount ever put into the sidewalk funds. Okay, any questions? No questions? Okay.
I guess I have one, and that is, why could you not also build the sidewalk and also have the plantings there as well, or add to the plantings?
So I'll speak to that.
I don't see that as mutually exclusive. Explain to me why that would be mutually exclusive.
It's not mutually exclusive. However, it would cut into the existing mature growth that's there, and our planned landscaping plan falls behind that existing mature landscaping. And we had not planned on removing any of that existing landscaping, and that sidewalk would cut into that. So it would not be mutually exclusive. However, it would impact it.
Any other questions? Okay, we're going to close the public hearing. Discussion. So we've had lots of sidewalk cases and people saying don't want to pay into the fund, too expensive, and this is over 2,000 feet, and so, as you heard, over $400,000 into the sidewalk fund. So, discussion.
I am impressed that we have, it looks like 10 people or more
From the neighborhood.
who have sat here for 5.5 hours.
I know.
So they feel very, very strongly about this. I don't live in this immediate area of Southeast Nashville. I'm a little bit east of there, but I know the area well. And as we've said earlier today and many other times, we need to start somewhere. There may not be a sidewalk on Barnes Road. This may be the first, but it should be the first. This company can obviously afford to pay for this sidewalk if they can pay $400,000 into a fund. And I would be against allowing the variance.
Okay, more discussion?
Well, again, I think we try to give deference to our planning department, who is recommending, although it was not optional for them to pay to the in lieu, planning is recommending that. And my thought is that I would defer to that recommendation. But like Ms. Sanford, everybody that's been here all day has seen government in action. We've had a lot of really active community people, and I respect that. I also think to me, I think the other side of Barnes Road may be the ultimate better place for a sidewalk. And so that, I don't think if I make a motion that's granted, I don't think it forecloses the idea of having sidewalks in the neighborhood. I think it just may not be at this particular time. I'm happy to make a motion.
Do you drive on Barnes Road? I'm interested.
This is what I see.
Oh, well, I'm there often, and I feel like this would be the side it should be on. I would, in fact, like to make a motion if y'all are ready for it.
Sure, yep.
I apologize, I have it. I already knew that we denied the variance, that we required the company to build a sidewalk, and that prior to issuing a building permit, that the planning department's requirement is met, that they also dedicate right-of-way along the property for future roadway widening.
Okay, motion's been made. Is there a second? Okay, motion's been made and seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye.
Aye.
Opposed? Next motion. Motion fails. Next motion.
Well, with respect to my colleagues, I would make a motion that we grant the planning recommendation to allow payment into the in lieu fund. I would also require dedication of the right-of-way to this utility.
Okay. Motion's been made. Is there a second? Okay, motion's been made and properly seconded. Any discussion? All those in favor of the motion signify by saying aye. Aye. Opposed? Okay. John Michael.
In the absence of 4 affirmative votes on the case will stay on our agenda until our next board meeting, which is set for February the 15th. It'll be taken up near the top of that meeting. Board members who are not present for today's hearing will have the opportunity to review both the case file and the video of this hearing and then participate in the vote that will take place on February 15th.
Okay.
Thank you.
Next case.
Mr. Chairman, the next case to be presented to the board is case number, if we could ask everyone to clear the room, please, since we're still having a board meeting. If we could politely ask everyone to step outside for their conversations as we're still having the BZA meeting. The next case is 2017-446. Anis Nif, the appellant and owner of the property located at 1211 Calvin Avenue, is requesting an item A appeal on a short-term rental denial. Property shown here is the one at issue, and here's the aerial for the neighborhood. Is there anyone here in opposition to case number 446? Seeing no one indicating their opposition to that case, the appellant will have 5 minutes to make the desired presentation. Please introduce yourself by name and address.
Good evening. My name is Anis Mnif. I am the resident and the owner of the property on 1211 Calvin Avenue, Nashville, Tennessee, and that's District 6.
Why are you here? You operated without a permit? So how did that happen?
First of all, I'm here to appeal on the decision for denying my request for a short-term permit. I first would like to apologize for doing that. I operated without a permit without knowing that was a permit needed.
Why didn't you know? We passed a law a couple years ago. It's been all over the news, newspapers.
My only knowledge, I thought at the end of the year I should pay taxes like a regular permit or a regular rental, and that was the assumption I was operating under. But as soon as I knew that was a permit needed, I met with Metro.
How did you find it? First of all, why didn't you know that there was a permit needed?
Like many other people here today, I was not aware of it. Maybe it was spoken about it on the news, but I don't.
How did you hear about Airbnb or short-term rental to begin with?
I used it when I traveled across the country.
And so when you found out, how did you find out you needed a permit? Did you get a letter from
received the
Mr.
letter.
Osborne?
Yes, and the same week I received the letter, I immediately took action. I visited Metro and I took the ad off the website.
Did you cancel any future
I
permits?
canceled.
How many?
I canceled actually two. One I denied it. The other one I had it for Christmas, and I canceled it for a week.
Did you cancel all of them, or did you
Yes,
let
I
somebody?
canceled everything.
Okay.
And even contacted the Airbnb, and I reached out to the guests as well, and I spoke with them, and I explained the reason that I didn't have a permit. I needed a permit. I was not aware of that.
Okay.
I even spoke with my neighbors, and I explained to them the situation. I got letter from them that they are okay with that. I emailed my council member several times.
And has your council member taken a stance on this?
This is what happened. I emailed him several times using my personal email, and I didn't hear back from him. Then when I used my work email, which is a state email, he replied to me yesterday saying he does not oppose my appeal.
But did he say he supported it?
No, he did not. He said he's neutral. He didn't have enough time to meet with me, and he will not be able to attend today. He wished he knew about it ahead of time so he had the opportunity to meet.
Any questions for the applicant? Is there any opposition? Okay. Mr. Osborne, tell us about this. How'd you hear about it? What violations have you found unrelated to not having a permit, and any other information we'd need to know?
This is another one that was brought to our attention by Host Compliance. Sent a letter on December 1st. To my knowledge, they've stopped operating, listings down.
So no other future bookings or anything like that?
Not that I'm aware of.
Okay. Anything else to add?
No, again, I'm aware that I broke the law. Ignorance of not following the law, it's my mistake, and I take responsibility for it. And moving forward, I will make sure everything is in order. Actually, I got all the documents ready. I met with my neighbors. I got all the requirements for legal permit. I have those already on file.
Okay. Members, how many times have you, we have 12 reviews. How many times did you rent it out?
I rented it 9 times. Maybe that's on my travel site as a guest, not as a host. I started operating late August, the 3rd week of August, and then the last rental was in...
You say you stopped renting in the 3rd week of August?
No, I started the 3rd week of August.
You started, okay. So when did you stop?
I stopped as soon as I received the letter.
When was that?
December 2nd or 3rd, and that I had reservation that I canceled.
And we have 1 letter of opposition in the file, too. So, anything else to add?
No. Thank you.
Any other questions? Okay, we're going to close the public hearing. Discussion. Well, end of the day here. Oh, I don't think Mr. Osborne, were there any other complaints related to this?
Not that I'm aware of.
Okay.
May I add something?
Yes.
I didn't know that I can bring letters of support from my neighbors, but all my adjacent neighbors and like the 5 neighbors next to my house, I already talked to them, and they are supporting that. I even, for those letters, that they are okay with me operating with a short-term rental.
Okay.
I had signed documents, and I already sent them certified mail.
Okay, thank you. We're going to close the public hearing. Motion. Any takers over there? Ms. Sanford?
I'll make a motion. I move we find that the zoning administrator did not err and that the appellant be eligible to apply for permit February 15th.
That's how many months from the letter?
Sorry, did I do the math right?
2 weeks from when was the letter?
When was the letter?
12/19 is when he applied.
12/19?
Letter was December 1st, and the BZA appeal was filed on December 19th.
I'm sorry, let's say February 19th.
March.
Would be 90 days, yeah, March. Sorry.
March.
Sorry.
Okay.
I'll second your motion.
Okay. Motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Passes. Eligible on March 19th to apply.
Mr. Chairman, the next case is 2017-448. Mike and Catherine Strickland are the appellants and owners of the property located at 2314 Spring Branch Drive. This, too, is a short-term rental permit case. This, however, is a revocation case based upon the Codes Department's revocation in a letter dated December 15, 2017. The appellants are represented by counsel. Is there anyone here in opposition to case number 448? There are. As a result, the appellants will have 10 minutes to make the desired presentation to the board. Then we'll hear from the opponents. And, of course, the appellants will have the opportunity to bring back rebuttal testimony if they save some of that time. Please introduce yourselves by name and address and take it up with the board.
Thank you, and I appreciate you all being so patient today. I know it's been a long day. My name is Grover Collins. With Collins Legal, we're at 414 Union Street, downtown, the Bank of America building, Suite 1110. I represent Mike and Kathy Strickland, who are to my right. They are the residents of 2314 Spring Branch Drive in Madison, Tennessee, 37115. In February of this year, the Stricklands applied to have their short-term rental permit issued to them. It was issued to them on March 7th of 2017. Thereafter, on March 30th of 2017, they were issued a notice of correction of a violation. They misappropriated how many bedrooms or how many people they should have had in the residence. That was my first interaction with the Stricklands, wherein we worked with codes to have that remedied and have that situation fixed. Upon them having gotten in compliance and their permit being satisfied, they continued to operate and then had their property manager take over and rent the property and list the property for them as going through this process. In July of last year, July 27th, they received a notice to correct a violation. The Stricklands had just purchased an RV for themselves. They had inadvertently parked it out front of their house. Unbeknownst to them, it is a violation to have an RV in front of a short-term rental permit. They got a notice of that correction, and they subsequently built a fence around the RV so as not to obstruct. We worked with Robert to make sure that this was in compliance, and they quickly did so. On November 29th, they were issued another notice of violation. This violation was because their property manager had put their listing, what they have in this property, it's unique. They have where they live, and then they have a dadu that they live in. So what they'll do on this permit is they will stay where they live, and when people are rented in the homes, they will go to the dadu, and that's where they'll stay. What they did and what constituted the violation in the eyes of codes was they put both listings up. So they would put one for the dadu and one for the listing. It was never their intention for them to actually rent both properties at the same time. In fact, whenever they had a listing for one, they would take down the listing for the other. The problem with that is they were relying on the property manager to manage the listings and manage how those listings would be presented. They were unaware that the property manager was putting the two separate listings. They put their faith in the property manager, obviously inadvertently and in violation, and they received the letter and the notice of revocation from Mr. Michael on the 30th. After reviewing the letter and speaking with my clients, they immediately took down all listings. They immediately refunded all the money that they had collected in coming for new reservations that were coming, including several families that they said during the holiday season they had to turn away, and they refunded their money, and the New Year's holidays. They have not operated since. They have not done anything since. They have done everything they possibly can to stay in compliance. They wish to stay in compliance. This is what they're due for their retirement without Miss Strickland when she travels for work, but otherwise this is their plan going forward. Unlike many of the people before you, they have done everything they could do to stay in compliance. They relied on a manager. He misinformed them about how to go forward and how the listings would be placed on Airbnb. But for him, we would not be in front of you today, and we would not have these 3 strikes. However, I would submit to you that the RV, I believe, would again be one of these minor violations that they remedied as soon as they got a notice to correct. Now, it was a notice to correct the violation, and they did so as soon as they could. And as soon as these permits were revoked on the 15th, again, I'd like to reiterate, they did everything they could to take down those reservations that they had and refund every single dollar of those reservations that they had at that time.
How many
Reserve
were
all
there?
remaining time.
How many did they take down? And
There was 16.
please
16.
identify yourself for the record. and address.
Kathy Strickland, 2314 Spring Branch Drive,
Okay, and
How many did you take down?
16.
his name,
Want you to-
your name and address.
Mike Strickland, 2314 Spring Branch Drive.
Forgive me if I missed something. I got 2 of the strikes, the RV and then the split ads, or for lack of a better term.
So the first one was separate. The first violation that they got in March of 2017 was because they put too many guests. They have
Okay, all right.
They have a huge amount of bedrooms in this property. Of course, it only allows for 4. I think they had listed it for 14 people in excess of the 12, so they adjusted it down to the 12, and then that was the first violation.
How many times did the property actually rent? Has it rented at all?
You mean in 2017?
Yes.
I have that number. Probably 8,
All right.
but before the, 3rd strike.
Yes, I understand.
Yeah.
You have several letters from neighbors in opposition, and so I wondered if you'd received, have you seen those, Mr. Collins?
I haven't, and I had requested those in a public records request and did not receive those, so I'm kind of surprised that, and having not received them, I would ask that they not be a part of this hearing.
Well, we receive them. So they are part of the hearing. I will say in my general review of the letters, they are more against short-term rentals as a whole than specific complaints about renters that you've had in your property. But if you want to look at those.
They're in the back.
Thank you.
And there's also a letter of support.
So as far as the remedies go on the RV, everybody at Codes is happy, as far as you know, with the remedy for the RV?
I can't speak for Mr. Osborne, but I've gone over several times to make sure everything is done. The picture that we've submitted, I believe, was in black and white, but I have a photo, if I could. It's a more clear photo of, they constructed a fence that would encompass the entire RV.
I guess the gist of the question more broadly was, to your knowledge, you have come into compliance on all
Absolutely.
3 of these.
Absolutely.
And
And Mr. Harper, just to put that to bed, yes, for whatever reason, the visibility of the RV is what is contemplated under the ordinance. It's not visible, so Codes Department in their Property Standards Division determined that brought that matter into compliance.
And when we bought the RV, we didn't know this. Of course, our property manager knew that, but he didn't tell us that that would be in violation of it. But we had it parked in our driveway. So it wasn't out front of the house, just in our driveway. So when we found out about this, we had to hire somebody to put it on the other side of the house, from one side to the other, and then we built a humongous fence.
Who was the property manager?
Greg Gardner, and he's taken responsibility.
What does that mean? He's not in front of us today.
I understand. He's written a letter saying what he did.
Okay.
I believe I can have it in my file, but if I can reserve any time for any.
Going to hear from the opposition. Please come forward, identify yourself by name and address, and why you're in opposition. You will have 10 minutes collectively.
Hi, I'm Stacy Farrell. I live at 217 Northside Drive. My backyard abuts Mr. Strickland. Oh, yes.
Where are you in the picture?
Okay. From that picture, you see the slanted, what would be west end of the property. My backyard joins his. You can't see the house because my backyard is.
Okay. But you adjoin the property.
I join the property.
Okay.
My concern is not with short-term rentals or Airbnb or anything like that, but the sheer scale of what's going on here in our neighborhood. The property assessor in Davidson County lists this property as 4,700 square feet, 6 bedrooms. Just by looking at the pictures on short-term rental sites that he's posted, there's seating for 47 people in the incredibly large backyard area. There's an indoor pool, an outdoor pool, a mini golf area. At what point is it a hotel? I appreciate the fact that the property is beautiful, but I just have serious doubts that this is going to end up being used in the spirit of short-term rental guidelines. Not necessarily questioning anyone's motive, but with a property of this scale, clearly can accommodate a whole lot more than 12 people and designed for large and expansive outdoor events. I'm very concerned. Thank you.
Question for the applicant? I mean, the opposition. Nope, okay. Let's hear from Mr. Summers. Please state your name, your
John
address.
Summers, 5000 Wyoming Avenue.
Okay.
I have a question for the staff. What's the zoning on this property?
Okay, well, just speak about the opposition.
Well, I mean, my understanding, detached accessory dwelling units, for you to have, if this is a type 1 permit, you have to live in the primary residence, was my understanding in terms of how the ordinance is operating. That's certainly the intent of the council. And so, you know, the description they've given that they rent out the big house and they go live in the, you know, you can't do that, I don't think, under a type 1.
Okay, thank you.
That's my question. And depending on the zoning, they may not be able legally to have a dadu under the zoning.
Okay.
Thank you.
Let's hear from the applicant again, unless there's anyone in opposition.
For what it's worth, Mr. Chairman, RS 40 is the zoning.
RS 40, okay, there you go. This is rebuttal time. You get to respond to the opposition.
May I ask a question?
Sure.
At the risk of sounding really dumb, what is a dadu?
That's the detached, they're detached building.
Thank you.
And if I may, Mr. Chairman, on that, I think there's an important distinction here. There's the DADU by acronym is, as Mr. Collins noted, the detached accessory dwelling unit, the concept of a converted garage into a small apartment above kind of concept. And that's been popularized in Davidson County in the past 10 years as a means of helping people get a little more density, utilize property that they have, and not have to tear down and build more things back necessarily. It is differentiated from what we more commonly refer to as a mother-in-law suite, which under the Metro Zoning Code actually is required to be connected to the primary residence on a property like this. It's worthy of note that a DADU and a mother-in-law suite are carefully differentiated under the zoning code, although the phrases have been used somewhat interchangeably in some of the documents and some of the permits that are in play with this particular case. There was a residential rehab permit pulled, I think in 2016 for this property to finish out the mother-in-law suite. And then there have been other permits pulled with regard to the accessory structure on other dates as well. So I know I've kind of over-answered it, but those were questions that were bound to come up.
Mr. Chair, so the question is that...
No, we're not here to talk about that. We're not here to talk about that today. Not in front of us. Go ahead.
So just in rebuttal, the only thing I've submitted is the letter from the property manager who was taking, that was an email that was given to my office. I've given that print off to you. Mr. Garner did take responsibility for that. Quite frankly, I asked him not to be here today because he was rather fired up about regulations and that kind of thing. So the Stricklands and some have done everything they can to try to be in compliance. They've tried to follow the law. They try to do everything they're supposed to. This is how they're making their living and their requirements. Their retirement. I would humbly ask this BZA to reinstate this permit. I believe at anything arbitrary for the RV, if you know there's a violation or a notice of violation, then you can go ahead and remedy it. It kind of is contrary, and this is something I've thought about as we've gone through these things, is when you receive a notice of a corrective action, it almost seems as though, okay, you have an opportunity to correct this. This is a violation, but we're going to give you notice so that you may correct it. So it's kind of unclear in the notice itself as to whether we're saying this is a violation, therefore now this is a strike. And it's not told to the person that this is something that's going to strike against you, this is something that's going to strike against you. You have no knowledge as to whether a tally is being kept or anything like that. All you know is, hey, I've got to correct something, now I'm going to correct it. I don't think it's adequate notice in the form of a violation, and this is what's going down in your record, and for that reasons, I believe it's arbitrary, especially when they take every step they can to immediately remedy that situation.
Yeah, I'd like to address my neighbor who I haven't met yet. We took a foreclosed $175,000 house and built it up to a appraised value of $525. We had to go into, we're probably a couple of $100,000 in debt right now. I'm a retired disabled youth minister, so he is correct in saying that we have lots of seating space. Well, that was my model. I'm trying to do everything I can to get people to come and stay there. So have I gone way beyond what everybody else has? Absolutely. Intentionally, I did that. So I've got seating area all over our 2 acres. I have campfire places where you can have that sort of stuff. I have a children's area. I have a putting green. I have an outdoor pool. I have patios all over the place, hammocks, swings. Not that we're going to have 48 people that come over there and stay, but if you want to go do something else, if I can appeal to whoever, children or youth or women or adults, whatever, I've tried to do that to get more business at mine because we are in Madison, not downtown Nashville. So not only do we have to try to go above and beyond to have a beautiful house, but beautiful activities for them to come and do. So we have arcade games in the house because that's what I know. So we've tried to do everything we can to get people to come to Madison to stay at our house as opposed to staying downtown. So we don't have noise complaints that I'm aware of. We stay at the property. If we ever had noise complaints, I would want my neighbors to call me because I'm going to either go talk to them or call the police. We don't want to break the law. We're not going to have people that break the law in our neighborhood. We plan on living there till we move on to heaven. So that's what we are about. And this is my income for our family because I can't go back to work.
Questions of the applicant? Okay. Anything else? We're going to close the public hearing. Discussion. Oh, Mr. Osborne, could we forget? The end of the road. How'd you hear about this? What violations were there that weren't related to not having a permit, and any other material that we need to know about?
Okay, so I received a complaint about this one back in May about them advertising for 28 people, and they're also advertising for 6 bedrooms at the time. Sent them a notice. Mr. Strickland called me, came into compliance. The next month, we got a complaint, or that we had to visit the site because there were some issues with some of the other permits they're pulling to rehab the house. At that time, I talked to Mr. Strickland, told him the RV was in violation and he'd have to do something about that. and I worked with him to give him more time for an extension so he could build the fence. And then again in November, received another complaint that the RV was back and they were advertising 2 different units, which they were advertising 2 different units, and I talked to Mr. Strickland about that and told him that that was fine as long as they weren't rented out at the same time. However, some of the language in the advertisement couldn't be there because it specifically stated, and I quote, "Can accommodate larger groups, please message, call, or email us." And I told him that couldn't be there because that's kind of advertising over the
So
occupancy.
how many strikes is that?
That is 3.
Okay.
So,
Well, I don't determine those, but after I get to 3 valid complaints, I submit it to zoning, and zoning takes it from there.
that's what I was going to ask about the strike. So as far as the RV goes, the first time you sort of verbally said, hey, you can't do that?
I did tell him, and then it took me a couple weeks to send the abate notice, but I did send the abate notice so that it was on our file.
Okay. So each strike gets an abate notice. Is that correct?
Each violation gets an abate notice, yes.
Okay, and then it's up to someone above you to decide if that's a strike or not?
Correct.
Okay.
And Mr. Harper, just to make that even easier, the zoning staff, namely the zoning administrator and myself, when we see that there has been a notice of violation issued by the property standards, that's a strike. We don't just do it on a complaint that has come in from the public, although certain complaints, if they come direct to us, can rise to that level. That's not an automatic thing by any means. When the property standards folks, however, inspect and determine that there has been a violation of the zoning code in this regard, that's what we treat as a violation, and which was the case here.
It's not 3 complaints, it's violations have been found. Okay.
Okay, discussion.
This is a revocation.
Yes, this is a revocation, 3 strikes kind of case, like the earlier one.
What do you think, Mr. Ewing?
I'm not as comfortable with the RV part.
You mean, is it being a strike or not?
As it being a strike, particularly since it wasn't on the street. And to me, our code is supposed to get people to do the right thing. And obviously they need to know it's wrong, but the listing of 24 people, yes, I mean, that's obviously not allowed, but it seems like they had 2 for the RV, or at least maybe the 3rd strike was the RV and something else.
What do you think about the fact they had a property manager?
I mean, we've heard a couple cases today that they hired a professional property manager. I guess 2 others that obviously weren't so professional in the knowledge of our short-term rental rules and following the law. I'm not sure, taking responsibility is being here at the meeting, though. It's easy for someone to say, I made a mistake, and then they're not here, and
He's not
let
losing his
somebody
permit.
else, I'm not sure that's taking responsibility.
I agree, although we do have something in writing from the property manager. But I agree with you. I mean, I think he should have been here. I do think I have concerns about, if I were a neighbor, I would also be concerned about what is going to happen. When I hear you talk about wanting to entice people to Madison, I understand that. At the same time, that could have an effect. This is a large piece of property, but that could have an effect on your neighbor's enjoyment, and I can imagine that they would have some reticence about just that sort of being a park-like setting in the neighborhood. The hearing's closed. I'm just kind of, for my colleagues, I want to state what my concerns are, and the fact that we're here, we don't, if we determine that the revocation was improper, then, this property is right back in business. They've not, but for the time that they canceled, although they did cancel 16 listings at the holidays and refunded that money.
So I hate to even ask this question, but if we find that the zoning administrator erred and we don't specify, on which strike he erred, let's say, how does the strike count go from there? Do they just now have 2 undefined strikes, or do all 3 strikes get erased?
You need to specify, because if it's a matter of you're determining that one of the individual violations was invalid and should not have counted in this.
So we'd be leaving 2 strikes on the record. So
Right, it's a 12-month window that's in play.
So where I was going with that question, fellow board members, was that, if, just so we're not being tricked or lulled into forgiving something that maybe is a perpetual problem that we're not seeing all the evidence of. So if it rears its head again, there's not a lot of wiggle room. They pretty much have to behave until the end of that 12-month period. So, I think I'm in the camp where I'm kind of willing to see the RV as not really worthy of a strike. But I'm willing to leave the other 2 on the record, given that analysis that we just talked about, which I think is somewhere between saying you don't get your permit and do whatever you want. So I think that it's reasonable to leave 2 strikes on there, but let them have their permit back, especially given the current legislation.
Okay, motions.
So my motion would be that the board finds that the zoning administrator erred in determining in revocation of the permit, specifically that the strike for the RV was an error.
Okay, motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. John Michael, are we done yet?
Mr. Chairman, that concludes our meeting. We'll reconvene on February the 15th.
Can we go ahead and just do the February 15th docket now?
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.